introductions. We are currently being live streamed. So again, good morning, everyone. This is the Joint Standing Committee on the Judiciary. This morning, our work will focus exclusively on the main commission on indigent legal services. We will receive a presentation of the annual report followed by committee discussion. And that will take up all of our work this morning. And then we'll resume at 1 o'clock for some additional work. But let's start now with committee member introductions. And I'm just gonna go around my screen and call on people. Representative Thorne, you can be first, please.
Good morning. Thank you, Madam Chair. Good morning from Carmel, where it is currently 11 degrees after a low of -20, according to the weather forecast. My name is Jim Thorne. I represent District 103, which includes the towns of Carmel, Herman, and a portion of Etna up in Penobscot County.
Representative Reckitt.
Good morning. I'm down here in the land of the heat wave. It's freezing, which is a plus today. Anyway, my name is Lois Reckitt, and I live near the temperature moderating ocean in South Portland. Thank you.
Representative Sheehan.
Good morning, Madam Chair, and welcome everyone. My name is Erin Sheehan, and I represent Biddeford's House District 12.
Representative Babbage.
Yes, good morning. -2 here. Woke up without a thermostat, been scrambling for a couple hours, but I am here. Chris Babbage, District 8, that's most of Kennebunk. Good morning.
Representative Poirier.
Thank you, Madam Chair, and good morning, everyone. I am Jennifer Poirier. I represent House District 107, which is all of Skowhegan and part of Madison.
Representative Newell.
Thank you, Madam Chair. Good morning, everyone. I am Rena Newell, tribal representative for the Passamaquoddy tribe, and weather forecast update. Our temperature is now at 0. We are warming up down here in the Down East.
That's great news. Senator Keim.
Good morning, everyone. My name is Lisa Keim, and I represent Northern Oxford County and 2 communities in Androscoggin, and I think we hit 20 below last night.
Ooh. Representative Evangelos.
Morning, everybody. Thank you, Madam Chair. Jeffrey Evangelos, House District 91, and I reside in Friendship.
Representative Moriarty.
Good morning to all. I'm Steve Moriarty from District 45, which is Cumberland and part of Gray.
And Co-Chair Harnett.
Good morning, Madam Chair, colleagues, and anyone joining us from the public. My name is Tom Harnett. I represent House District 83, which is the town of Farmingdale and the city of Gardner. And I just want to alert those watching and committee members, I'll be jumping in and out today due to obligations in other committees on other bills, but I will be here as much as possible. Thank you.
Thank you. And I'm Ann Carney. I'm the Senate co-chair of the committee, and I'll be running this morning's session on the Indigent Legal Services Commission. I represent Senate District 29, which includes South Portland, Cape Elizabeth, and a little bit of Scarborough. And happy to be here this morning. We'll be assisted by our OPLA analyst, Peggy Reinsch, and also our Judiciary Committee clerk, Susan Panett. And with that, I think we will dive into this morning's work. And so I'm going to bring over to the panel the executive director of the commission, and that is Justin Andrus. Takes people a moment to join us, so he will be here shortly. Welcome, Executive Director Andrus. For purposes of presenting the report, I thought we would have you present the report, but is there anyone else from the commission who you would like to bring onto the panel while you present the report?
I believe Chair Tardy had intended to be present. I don't have the ability to see the list in this format, so it might make sense to bring him forward as well.
Okay, he's traveling our direction.
Okay. While we wait for him, I would just say I injured my back, so if you see me twitch or stand up or sit down, I hope you'll have patience with me. I'm not grimacing at anything in the conversation.
We're sorry to hear that. And I did want to let public members of the public who are watching know that there are some other representatives and board members or commission members, excuse me, who are available and may join us later in the presentation. And with that, I'll turn the virtual floor over to you, Justin Andrus. You can go ahead whenever you're ready.
Good morning. Thank you all for the opportunity to speak with you today. You have, I hope, received the written documents that we submitted in addition to having this opportunity. As I was getting ready for this morning, I was thinking back over the last year, and it was 1 year ago tomorrow that I first appeared before you. Excuse me, we began the process of trying to bring MCILS forward into good function and excellence. And we've made really remarkable progress in that regard. You've heard from me a number of times in the past about the work we did using the Sixth Amendment Center report and the OPEGA report as lodestars for the sort of oversight and operational issues that had been identified, and then using those as jumping off places to further identify ways to get better. And we've largely, yeah. I
am so sorry to interrupt you, but I did want to give Chair Tardy a moment to introduce himself now that he's appeared on our panel. And again, apologize for the interruption, but you can continue in just a moment.
Sure.
Well, thank you, Madam Chair, Senator Carney, Representative Harnett, distinguished committee members. I am Josh Tardy. I'm the chair of the commission. We're pleased to be here today to present the annual report. And as the director was telling you, it was about a year ago that he came on board in interim status. He assumed the role of full-time executive director or permanent executive director, if you will, this past summer. I'm thankful for his commitment to our mission, for his leadership. And I would just like to say thank you to this committee for your continued making indigent legal representation a priority. And we really appreciate the support and your constant attention. And I won't, I'll be here throughout Justin's presentation and be happy to answer any questions. Thank you.
Thank you. And you may proceed, Justin.
Thank you. Essentially, I think the easiest way to express where we've come this year is that we've been very successful in bringing MCILS as far forward into compliance with reasonable expectations on it, both from the legislature and from Sixth Amendment Center and OPEGA in particular. We have stemmed the departure of attorneys, in part because of the increase in rate, which they all appreciate. We have improved our ability to ensure that only qualified counsel are being approved for assignments. I say that way because sometimes the court assigns somebody who we have to ask be replaced. Very, very rarely now. Couple of times. It's unlike at the beginning where we were unable to demonstrate that. The addition of the 4 attorney staff members have allowed us to increase our training opportunities, to provide better training, to provide guidance to attorneys in the form of email communications about issues and how to address them. And again, how to ensure that we are serving our clients through qualified counsel. The addition of the audit staff has allowed us to radically improve our review of the voucher process. And as I put forth in some of the written materials previously, we have developed a formalized audit structure that I anticipate will be live in March, including true empirical-based audit sampling practices that should bring sort of scientific validity to that side of the process. We have been unable to hire the paralegals that the legislature authorized for us. We've advertised the position twice. We didn't get the candidates we needed the first time. We didn't get any candidates the second time. We will continue to try to do that, but we are having difficulty there. And so that hasn't yet really hampered us because the 4 people who've come on are doing the roles effectively, but it's not quite as efficient as it could be, and it doesn't quite give the headroom that they should have to be doing development work. But as set forth in the written materials, I think we've done a remarkable job of addressing the oversight issues, ensuring that financial guidance and expectations have been communicated to council, ensuring the council are abiding by that guidance, and assuring that we're providing counsel who are qualified. And we are successfully staffing all of our cases. So I'd be happy to go into any detail about any of that, but I've reported it to you in the past and again in writing, and I don't want to just prattle. Going forward, we're sort of at a crossroads where we're able to operate within the instructions we've received from the legislature through its decisions in staffing us and funding us. And we are going to be able to operate within the budget we have been allocated at the level that we're currently staffed to do, which is excellent. What we're unable to do yet is move forward in the direction of a public defense system that really meets the strictures of the Sixth Amendment. And for those who are involved in the child protective system or in the mental health system or in other parts of our program, when I talk about the Sixth Amendment, from my perspective, the sort of same diligence and same responsibility and same process that should be afforded to criminal defendants under the Sixth Amendment applies in those civil cases. So please understand that to be inclusive. So from this point, I've written out some of the things that we need, but we need to find ways to bring parity to the defense system, parity with the prosecution system, again, including the child protective system. And really, that's a resourcing issue. The MCILS initiatives that were produced in the fall of 2020 that we've discussed at length last year, they remain the asks of the commission. We still need the opportunity to have a public defender office. We still need the opportunity to have employed defenders, both locally situated and this was not in the original ask, but as it has evolved over the year, it's become clear to me, I need the ability to dispatch employed attorneys to places where there are not enough attorneys to serve clients adequately. And that varies from time to time, which means that perhaps it's not yet time for brick and mortar public defender offices in all of the counties, but that from time to time, I need to send people different places. For example, when I last ran the report, there were no attorneys in Washington County, local to Washington County, accepting Washington County cases. There were attorneys in other counties willing to go to Washington County, but I was communicating with the court there earlier this week. They have 0 attorneys qualified and willing to do lawyer of the day, for example. We solved that problem in the short term, I believe, but that is what is informing my ask that the concept of public defense by employed attorneys include sort of a flying squad concept. I think that provides efficiency and flexibility. In addition to that, we have a serious recruiting problem. And I produced a memorandum for the commission earlier in the month, and I know that my commission packets get sent to you all. So I, again, don't want to simply read reports to you, but it was troubling from a recruitment and replenishment perspective. Showed that the average age of the attorneys serving in our program was 52. And 52 is not old, but 52 is beyond the midpoint of a reasonable sort of legal career. There were 4 counties where the average age was 60 or older. And we're starting to see the real threat that in the foreseeable future, we're not going to be able to replenish the stock of attorneys willing to serve at a rate that is going to allow us to continue to serve clients. Again, staffing all of our cases now, but it is taking work And it wouldn't take very much disruption for that to become a problem. It's a crisis of tomorrow. I don't want to overstate that it's a crisis of today, but it's one that we need to begin to solve from an anticipatory perspective. I have a survey out to council, and in one of my recent memoranda, I laid out some of the information that I had received back from them and was looking at what's really involved in reaching parity for council with the state and some of the obstacles. And it was distressing. A lot of council not able to support health insurance, many council not able to support staff. Those with health insurance, I should say, tended to have very high deductible policies. So that's not good for council. It's also not good for clients because it leads to the specter that an attorney who is under the weather or otherwise injured may be practicing on a day when that attorney ought not be practicing and ought to go and get well and come back and be able to practice most fully. I experienced that when I was in practice during a period where health insurance for me meant very high deductibles, and I had an injury that made me not fully on my game. I eventually dealt with that, of course, but that's a serious problem, and it isn't just an attorney lifestyle problem. It's a client problem if an attorney is making decisions that are problematic. So at this point, what MCILS is asking is to continue the dialogue that we started last year. We hope we've shown a willingness to step up the game, to provide the oversight, to hold the attorneys to account, to support the attorneys in their goodness. And I think we have done that. But from here to achieve a truly excellent and functional public defense system, we're going to need to work toward both public defenders and also toward resourcing these folks. And there may be ways to do that outside of simply throwing money at an hourly rate. There may be ways to look at finding group insurance policies. There may be ways to look at expanding retirement programs. There may be ways to do that. There's a memorandum that I'd be happy to circulate from one of my staff on a loan payment program that would bring parity toward, or closer to parity toward the opportunity prosecutors have to receive loan forgiveness. It's likely that on a per defender basis, it's less expensive to do that with employees who have access to state benefits and the economy of scale available there than it is to provision every private attorney that way. It's also likely that in some areas, in particular, private attorneys can provide the services more efficiently because of the infrastructure costs of a brick and mortar defense office that wouldn't necessarily need to be borne everywhere. In addition to that, there are some things outside of sort of budget and relationship with our attorneys that MCILS is working on. We want to thank Representative Harnett for his willingness to sponsor a bill dealing with jail recording issues. Some of you may have seen a media report yesterday on jail recording issues, and I know it's something we've talked about before. It is a very, very serious issue, and it is severely impacting some cases, and it's severely impacting all cases because defense counsel don't trust that they can talk to their clients safely. And in this era where frequently they can't access jails directly because of the pandemic and jail lockdown rules in particular, as a result, it causes a true interruption in the provision of client services for there to be this specter that calls are going to be recorded. As some of you may know, I experienced that directly and personally in my practice in a number of cases. And then the solution was go visit the client. Today, that's not possible. So it's a high agenda for MCILS to work with you and with the rest of the legislature toward a solution to that problem. In addition to that, there are some proposed amendments to the bill prohibiting contact between unrepresented defendants and prosecutors. We continue to support and thank you for that legislation. There's some tweaks that will make it more workable. And I want to say more workable just doesn't mean easier for us, like we can't meet our obligations, but rather it will foster defendants reaching out to us earlier, communicating with us more effectively, and our ability to provide opportunities for counsel earlier in the process. So that's the high level overview. Again, I try not to prattle too much. I would be happy to answer any questions or go into any detail on any subject that anybody'd like to hear about.
Thank you very much. We appreciate that high level overview. And I see that there are some questions. I'm sure there will be quite a number. Representative Reckitt, go ahead with your question, please.
Thank you. I have actually a couple of areas, one of which might have a known answer, and the other might not have a known answer as yet. It's more like a suggestion as opposed to a known answer. My first question is, I want to understand if you're caught up on cases and you're feeling okay, and yet you have an inability to hire paralegals, what is the impact of that inability on your practice in NCILS?
So I guess there are a few places where that comes together. So MCILS had an operational structure, at least theoretically, before last year. It operated not quite in compliance with its own rules. Over the last year, we've done a lot better at operating within the rules that we have and abiding by them. And doing that has taken the 4 attorneys who we were able to hire, has taken them doing operational administrative level tasks. And so an example is the audit staff doing all of the voucher review directly personally. An example is the training and supervision staff dealing with all of the cases that come in where the assignment is not one that we can approve. And all of those things take a fair amount of work. And it's fine. They're doing that work. That work's getting done, and we're therefore within our stricture, which is excellent. But it takes away from the ability of those 4 people to be developing the protocols and processes for going forward. They are working on them. It's not that it's not happening, but that they're spreading their time across time that really should be support time, and that takes away from their ability to continue to evolve us. And so where that's going to further be a problem is as we get into actually doing field audits of cases or of attorneys, and as we get into actually doing formal assessments of attorney performance and working to provide support and education and remediation to specific attorneys, ultimately we're going to need more staff than we have to do that statewide anyway, but to do it at all would probably exceed the capacity of the existing crew. So having those paralegals would free up some time to do that. Again, not enough time. I don't want to set an unreasonable expectation. I think I've said this before. By way of example, the ABA standard for supervising attorneys in a public defense system is a 10-to-1 ratio, which suggests we need approximately 30 people more out doing supervision. Practically speaking, I don't know who those 30 people are in the state of Maine. I don't know. If I had them today, I wouldn't have them. If I had the authority today, I wouldn't have those employees tomorrow. And so there's some other issues there. But getting anybody out in the field at all to do that work will be difficult while we don't have that support staff.
My other, if I could, Madam Chair, my other question or the thought that came to me as you were talking is the, do you have a working relationship / idea exchange with the law school as to what might be a good learning thing for law students that might actually end up being able to help you as well? So that's my, I'm thinking of the number of things that have happened that have, helped with prosecutions and other kinds of areas like the domestic violence stuff that happens in Lewiston, those kinds of pieces. So I'm curious whether you've thought of that or talked to anybody about it.
Yes, the answer is yes. And although what we've been able to implement there so far has been limited, the new dean of students, Sherry Mason, and I may inadvertently call her Sherry Fowler because that's how I knew her first. But Dean Mason is been in communication with us and is very supportive of helping develop channels for her students who are interested in criminal defense and child protective to enter the sort of the arena. And so we do have a lot of support there. And we've also explored some ways of getting in and inspiring folks there, including through our National Association of Criminal Defense Lawyer grant partners. They've offered to come into the law school and do some specific sort of trainings that would be both substantive and exciting for students. And so I hope that comes to fruition. We anticipate, when it's safe to do so, going into the school and doing brown bags. And, again, a combination of cheerleading, inspiring, and education about what the options are. My understanding is, and I don't purport to speak for the school here, but my understanding is that the school itself is extremely stressed at this point, in that there's limited bandwidth among the faculty and staff there other than Dean Fowler to participate directly in that stuff. And so I'm not sure what the school can do except open its doors to us to come in. Now, one of the things that we've been thinking about doing is a set of programs that would allow and I just want to make a note and come back to something, is allow students who are interested to either work as clerks or as young lawyers through some sort of contract with us to provide clerk services at an appropriate clerk wage, or young associate or new associate services at an appropriate wage. Because one of the issues is it's difficult for attorneys to bring young attorneys forward when they're not able to contribute significantly to paying their own overhead, or for clerks. In my office, most of the time we had clerks. We saw that as part of our duty, but it was not a trivial expense, and it would have been impossible for me to do if my practice had been exclusively court assigned. And so those are some of the things that are happening. The concept might be that an attorney, I'm not sure whether the contract would flow to the attorney or to the clerk. We have a lot of detailing to figure out, but that they would foster and do professional development with those people, help bring them forward. The note that I made is there's a bill to support the opening of an annex to the Cumberland Legal Aid Clinic in Aroostook County. I don't know all of the details of that. That hasn't been shared with me yet. But in general principle, it's also an excellent idea for bringing students forward into an opportunity to practice. And I think if it were part of the clinic, I hope that it would be open to the student practice rules, so we could actually get people in and getting experience. One of the issues we have, and you mentioned the prosecutor's offices, one of the issues we have is that under the existing rules, we can't have defense attorneys or child protective attorneys work with our counsel and provide student representation the way the clinic can or the way prosecutor's offices can.
Thank you very much for that answer.
Representative Moriarty, go ahead with your questions.
Thank you, Madam Chair. Mr. Andrus, last fall I was able to attend some of your commission meetings electronically, and I recall one in particular where you discussed the results of the survey among participating attorneys. And 2 points kind of stand out of my memory. One is the quantity of opinion to the effect that participating attorneys are not respected by members of the bench or by the court system generally. And that was a major problem for them. Another related issue was the disparity in procedures and practices between, or rather among, the various district courts, which made it difficult for attorneys to juggle multiple clients with the charges pending in multiple prosecutorial areas. The question is there an appropriate way for the commission to bring the judicial branch into the loop and to discuss these perceptions candidly and openly?
I think that dialogue has begun. So to answer the question, can they be brought into the loop, or is there a way for this committee to do it? I think it's already started, and so I think that's great. I will say that I have frequent and open communication with Chief Justice Stanfill. Certainly, we're not always of a mind when we talk about what a solution to a problem might be, I don't want to speak for the court, of course, but I have communicated with a number of jurists and a number of clerks who perceive that they're struggling as hard as they can to support the attorney's needs, while the attorneys feel like what's happening still doesn't support their practice needs. And so the issue is one of broadly of resources generally, to sort of both sides of the equation. And I've diverged from the question, how do we get them all in the room, into the substance of it? So you can rein me in. But there are certainly instances where I'm aware of specific instances where a court has not followed the judicial branch order about Zoom appearances, or in some other way has made things specifically difficult for counsel. But at the same time, we're in this vicious loop where there's pressure on the court, as I understand it, because due to counsel being scattered in different places, sometimes the court feels like it can't schedule. And so we're working together to try and solve that. That doesn't mean that those attorneys who were slighted or felt slighted are wrong, that they weren't slighted or they're wrong to feel slighted. I think those things are real and they have happened. But I don't think that what I'm seeing is disdain or disengagement at this point from the court. And I'm really happy about that, because I did feel that way in the summer, and I reported that. I think it just took us a little while for the gears to mesh and for that conversation to start becoming productive, but it has been really productive during that interval. There isn't an obvious solution to me to the problem of courts needing to move cases. For me, it's not a goal. Move a case, not a goal. Ensure that a case is timely heard is a different goal from get it moved. And so I think solutions here look at not just attorney availability, but the availability of jurists, courtrooms, adequate staff for the court to be able to have as many cases properly heard as possible. And also, I hope some work from the district attorney's offices on determining what's really necessary to go forward. So,
as a quick follow-up, would it be appropriate to bring the chief judge of the district court and the chief justice of the superior court to the table?
Absolutely. And they are, I should just say, they have been much more engaged, particularly Justice Mullen, but also the chiefs of the district court. I think we got over again, the transmission didn't mesh at first, but I think we've gotten to the communication. But I do think having us all, or them specifically before you, might give you insight into what's happening from the other side, and might give them insight into what your appropriate expectations are, being mindful of the separation of powers issues. So yeah.
Okay, thank you.
Representative Harnett, you're next.
Thank you, Madam Chair. Nice to see you again, Mr. Andrus. Thank you very much for the work that you've been doing and for being here today. Representative Moriarty raised some of the issues, and I'm sure we'll hear more about them today, about the concerns raised by rostered attorneys, particularly those that were expressed at the December meeting that many of us were able to attend. And clearly we have some issues that we need to resolve there, because right now we are relying almost exclusively on rostered attorneys to do this work, and we're going to have to continue to do that. There's no doubt about that. And those problems need to be addressed in a meaningful way and corrected wherever possible. But I wanted to talk to you about the Commission's current thinking about public defenders. Because you mentioned a couple of things, and over the last couple of years, we began first with the Sixth Amendment Center report talking about setting up a pilot project in our most populated county, down in Cumberland County. Then the legislature looked at putting something in Kennebec County. Obviously, funding was an issue and concern that was not fully addressed. But today you use a term that I don't think I'd heard before, a flying squad. I'm assuming we're not going to have aircraft for them, but I get the point. And I'm wondering what is the commission's current thinking about how to, one, do we roll out a pilot project with public defenders, full-time hired personnel? Is it necessarily brick and mortar, or do we start with something different? Is there a uniform view on the commission? I guess I'm just wondering where that stands. There seems like there were a lot of moving parts and different possibilities and different models that are being explored. I hope that's not too overly broad.
I don't think it is, although I'll lead with, we have at least one attorney who is using an aircraft because it nets out to be less expensive to fly to Aroostook County from Cumberland County when you can fly yourself than it does to drive. So I'm thinking about how best to frame this, because there are two complementary pieces here. One is the cost efficiency and one is the operational efficiency. As to whether there is uniformity, there is uniformity of the commission voice that employed attorneys are necessary, and it remains the voted on will of the commission that there be a public defender, employed public defender function. As expressed last year or 2020, the sort of principle for the brick and mortar office in Kennebec would have been an 80-20 split, with 80% of the cases to the public defender office. So it was always a hybrid model. I think the reality is that split probably doesn't wind up being 80-20. I think it winds up being half and half or something like that. A brick and mortar public defender office in a place with the density to support it makes sense for a lot of reasons. There is no question that there is an efficiency to be had in training new lawyers and supervising new lawyers to the practice, getting them the experience they need to be very high quality defenders through a brick and mortar public defender process with oversight. And Commissioner Schneider tends to use the expression that the office would operate as a law firm. And having come from a law firm background, I share that managerial perspective. But there's a lot of training and support, mentoring, shadowing, and things that could be done that way. And I think that would be useful. I also think that the oversight and the mentorship and the reviewing structures that come out of that can be made available to the contract counsel as well. And so the management functions of that office, not the direct management of the inside attorneys, but the management structure of the practice is then applicable to people outside. And there's an efficiency there to be had. Then I sort of counter that with the idea that today in Kennebec County, I'm staffing the cases relatively effortless. Some cases take some work, but this is not the place where I have the highest need for the ability to assign counsel by fiat. And that's where the flying squad concept comes from. In my imaginary universe, I have a van kitted out as an office, and I'm sending pairs of attorneys out to go to where the clients are. A lot of the clients in a lot of the state are not mobile. In the cities, that's less of a problem. They can get transportation to come to an office and see a lawyer. When you get to places where there's no transportation and not much taxi service, that becomes a real problem. The ability to say, I'm going to send my pair of attorneys to Washington County this cycle would be operationally very efficient. I can't justify necessarily with the caseload volume why there should be a brick and mortar public defender office in Washington County. It would be better. If the budget were no issue, it would be better to have a brick and mortar public defender's office everywhere, supporting both those attorneys who worked inside of it and those who worked contracted. It will lead to better local knowledge. Local knowledge is important both in terms of understanding the judges and also the local jury pool. It would lead to better access for the client to be able to go to a place if they could go to a place and see counsel or do whatever. No question that would be better. But as a step before that, with much greater efficiency, if I could work with the courts to say, okay, I'm going to send my 2 attorneys to Washington County to take the caseload that's necessary, and the court's going to work with us to schedule those people so they could go up there for 2-3 days and deal with all their cases, then that could be done very, very efficiently and at less expense than having a full-time defender office in Washington County. Commission hasn't voted out exactly what to do with those details. Instead, they've said, go work it up. And that's what we're sort of trying to figure that out. And to some extent, ultimately, my question to the committee would be, is that something the committee would like to hear about? Because here we are. But I haven't known that until that point. So I don't know if that answered all of the elements of the question you posed.
It does. Thank you. And may I have a short follow-up, Senator Carney?
Yes.
Is it fair to say, and it seems pretty obvious to me, that Maine, and I assume the commission recognizes that we will need to continue to rely on the hardworking private attorneys that are rostered, that are doing this work, while at the same time trying to improve their working conditions, not just as related to the hourly rate, but the other issues you touched upon in insurance, loan forgiveness, et cetera, so that at best in the near term, we are looking at the continuation of a hybrid model, even if we do some form of public defense work. Is that fair to say?
I think without question. And so I also think that there's some sort of cultural work to be done with the bar surrounding this issue as if we move into it. There's no question that it needs to be a hybrid system. And in fact, in almost everywhere, it's a hybrid system, even where there are public defense offices. That's number one. Number two, a lot of our bar sort of style itself as sort of rugged individualist gunslinger, for lack of a better word, attorney. They like the autonomy to feel like it's them against the world. We want to support them in that, but in being good attorneys by having a system behind it. But I'm not sure, had I been asked to join a public defender office as a condition of continuing doing the work, that I would have wanted to do that while recognizing the value. So there is a place for that experience and those people that way. The other side, one of my staff came to me and said he was confused after a meeting a couple of weeks ago because it seemed like the attorneys were saying they want the things that come with being an employee, but there's resistance to becoming an employee. And I think particularly for the younger attorneys, for a lot of them anyway, being an employee is a necessary step to allowing them to remain in the defense function, not just for us to provide the oversight, but for them to be able to survive and practice in the business. Something like 40% of those who responded to me about their student loan debt are making interest-only payments, or not even paying all the interest. For example, the opportunity to participate and get to a loan forgiveness, I think, is necessary. So there's places on both sides. Another example, and I think this is important because I left it out of my memorandum, for which I apologize. But the existing system is impossible for moms. It's also impossible for dads who want to take paternity leave. But moms in particular, there's no support and system for them to serve as contract counsel and survive a period where perhaps it's appropriate for them not to be working as hard or as full-time or exposing themselves to disease or basically taking care of themselves. And so, we have a system that needs both elements. I think we all do recognize that.
Thank you very much, Mr. Anderson. Thank you, Chair Carney.
You're welcome. I have one follow-up actually on Representative Harnet's question, and then we'll turn to you, Representative Evangelos. What do you think from a supporting the panel perspective, what's the lever that would be most helpful that we could exert some pressure on? Is it health insurance? Is it something else? Where should we focus our efforts if we had to pick one thing?
I think it's probably health insurance and loan forgiveness. The thing I hear about most often is loan forgiveness and legal research tools. The reason I would direct the committee's focus to the two things I mentioned rather than legal research is it's more discreet and may be possible to solve more easily. We may come and ask for a budget kick in the next biennium, modest to deal with having found a way to provide those legal research tools. The cost of providing health insurance to themselves is astronomical, and the student loan situation is utterly intolerable for most people. So of folks who responded, it was interesting. So all of my respondents were on average older than I expected, but the break in the average ages for who had loan problems and who didn't, or loan balances and who didn't, is 59 to 45. And so it's very clear that the younger you get in our program, the more that's a genuine obstacle. And we have done some preliminary work on ideas and canvassed other states about how they have like loan payment programs. We can't do loan forgiveness because the CFR is written the way it is, and it's not something we can address with our contractors.
Thank you. Representative Evangelos, go ahead with your questions.
Thank you, Madam Chair. Good morning, Justin.
Morning.
Justin, could you tell me whereabouts the roster stands right now?
Haven't run it today. The last time I ran it was about 279 people accepting cases, and there were about 325 people who had active cases. And one of the things that's happened that's interesting and good is as we gave the attorneys the ability to opt in and out of cases, and as we switched away from monthly rosters to essentially daily rosters, but eligibility updating daily, it's allowing attorneys to opt in and out as their caseload permits. And so it's been 279 people on a number of different days, but it's not always the same 279 people. It's perfect. It means it's that part means it's working.
And then this question is directed to the chairs or to the commissioners or to anybody that wants to answer it. And if we're going to get to it later in the meeting, then just say that. But I know that Justice Alexander and Mr. Cummins and Schneider, and others have all made recommendations about what we need to do to fix the current situation, including bills that will have a fiscal note attached to it. So I guess to the chairs, at what point are we going to cobble together some bills to address these deficiencies to improve the functionality? Can I get some advice on that?
I can give you an answer to that. Under the legislation that, under the statute that applies to MCILS and our committee's role, we are authorized to report out legislation following the receipt of this report. And so right now we're in an exploratory phase, understanding what legislation might be needed and then what the next steps are. So this is a really important first step. And I'm glad that you asked the question and also that you mentioned the others. And at some point, I would like to invite them to join the panel and provide additional information to us. But I want to make sure that we completely finish with Justin Andrus's presentation before we do that.
Okay. Thank you. That's great.
Okay. Did you have any other questions for Justin Andrus?
No, not this time. Thanks. I just want to make sure that we're going to tackle some things, and it sounds like we are. So thank you.
Representative Recca, go ahead.
Thank you. I'm sort of a numbers person, which is to say I started college as a math major before I bailed to something else. But the point is, I'm looking at the figures on page 5 of your report to us, which is the one that talks about the attorney costs of the various kinds of cases. And I'm looking at particularly the child protection petitions and the review of child protective orders. I'm sure there's probably other things that involve children, including some review of counsel juvenile and stuff, but my question is, it looks to me like there is 27% of the vouchers paid have to do with child protection or child protection orders. And it also looks to me like that represents 11% of the new cases. So my question to you is two-part. One is there a continuing number of cases in those two areas that would make it logical that the billing is as high as it is for that subset of the cases? Or are these cases particularly lengthy, difficult, and costly? Or, I mean, I'm trying to understand this particular section, which I clearly know more about than I do about, felony cases. I mean, just because of what I did with my life. But so I'm curious about that disparity between the new cases and the overall cases and the amounts of money.
So there are a couple of phenomena there. First, it is in a child protective case, there are a number of stages. There's their preliminary protection order stage, the jeopardy stage, there are judicial reviews, and then if there isn't dismissal of the case in favor of the parent, there's a termination of parental rights hearing or a permanency guardianship hearing. Each one of those stages is historically been a time when an attorney is required to submit a voucher. It is now an opportunity to submit a voucher. They can submit a voucher at an end. So we've just changed that rule. But as a result, all or substantially all child protective cases produce multiple vouchers, which is why the voucher count is higher than the case count. Now, it is possible in a criminal case historically and now for somebody to submit an interim voucher if the case is delayed for some reason or there's no appropriate reason. So that could happen, but it didn't happen in every case. So that's phenomenon number one, driving the voucher count number. The average voucher price number is higher for two reasons. First, it is very, very common for there to be companion criminal cases. So I might represent a guy on an assault and he might get a violation of conditions of release while he's on bail, and those two cases that get resolved together. As a result, substantially all of the work gets billed in the assault case because it was necessary to the assault case, but not much work gets billed to the VCR case, the violation of conditions of release case, because it's just going along in parallel. There might be a few entries that are specific to that case. And as a result, you might get a $1,000 voucher for the assault, and you might get a $90 voucher for the VCR. And that average is artificially low for the actual cost of representation of the client during the period. Does that make sense, that description?
Yeah, it did actually, yeah.
Okay, and so that's a phenomenon. And then the third phenomenon is that, I could get myself in trouble with the bar for this, but I did both criminal work and child protective work. The typical child protective case was harder and took more work than the typical criminal case. It's not true of all criminal cases. Some criminal cases took a staggering amount of work. Child protective cases invariably involve, in addition to the court appearances, family team meetings, and a lot of social work with the client. And most of my lawyers are not social workers, some are, but we wound up becoming social workers to do child protective work supporting our clients appropriately. I'm not suggesting we're actually practicing social work without some kind of license, just that a lot of it is that kind of work. And so when I practiced, my highest bills for trial level cases were invariably in child protective cases over criminal cases. Occasionally there was an outlier criminal case. So those, I said there were two phenomena. One has those two subparts, so it's really three phenomena, but that's why those numbers look the way they do.
I have to, if I could just comment for a second, it strikes me as interesting that I have long thought that in terms of guardians ad litem, which I know we're not talking about, that they really need a team of a lawyer and a advocate or social worker to do the job right. It's not what happens, but that's what I think would make it better. It sounds like your lawyers are having to do both parts of those roles. in these child protection cases. It's a similar kind of thing to me that, that's you're turning your lawyers into sort of parasocial workers to get through the case. So, but I just think it's intriguing that the two sides of that question. So.
It is, there was a lot of social work involved with it. And in an ideal universe, we would have dedicated social workers to work cases from the parent's attorney side. I mean, there are DHS caseworkers, but while they're there in principle to support family reunification, they're not there to support the parents directly. It's not the role that happens. And so as a child protective attorney, you spend a lot of time talking to rehabs, finding placements, finding that kind of stuff. You spend a lot of time in the appropriate attorney counselor side of the role, working with clients to say, here's what you need to do. Here's why you need to do it. Here's how I need to help you find the motivation to get sober and stay sober. I don't doubt you love your kid, but here's what you need to hear, and here's where you need to go with it. And I hope that we're going to be providing better training to attorneys on that, frankly, because we don't have social work training. And so, yeah, your observation is right.
Representative Babbage?
Thank you, Madam Chair. Good morning, Ms. Dandris. And first of all, I just wanted to clarify something you said. I didn't quite get it. The survey results from the attorneys said that the student loan issue was particularly applicable to what range of age did you mention?
So the most direct answer is to the younger they were, the more it was an issue.
Did you say 59 to 45 or below 45? Or
I did. So there's a problem with I don't want to draw a conclusion that sort of goes beyond the significant digits of the data that I have. So because the average age of everyone answering was 52, I had very, very few truly younger attorneys in the responses. Now I have some more responses since I did that memorandum on the 21st, but the numbers anecdotally are holding approximately true. I now have the occasional 32-year-old in the results, but I really didn't at the outset. So from the sample that I had, given the average age of 52, I then looked at the average ages of those who said they had student loan debt and those who didn't. The ones who said they didn't have student loan debt were 59 on average, and the ones who did have student loan debt were 45 on average. And that's different from saying the average person with student loan debt is necessarily 45. But what it does reflect is the reality that, unsurprisingly, it's a question of how old you are, whether you're likely to have student loan debt, both because you've had longer to pay it off if you're older, but also because there was less student loan debt on the older members of the bar than on the younger members of the bar. So those broad principles, I think we can draw from the data, but probably not more yet.
Thank you. That was very helpful. I have one more, if it's all right, Madam Chair. I just wanted to say that our work here as a committee over recent years, and the work of many people, and of course your front and center, Mr. Andrus, has given me a great optimism and satisfaction in the direction that we're going regarding indigent legal services. And we are faced with rationing resources, but we don't want to ration justice. And could you just clarify me before your testimony ends? The exploration of the public defender's office with you talked about the hybrid model and what is proposed, and I'd like to clarify where you think that's going in the future as far as desirability. Thanks.
Sure. So I don't have a fixed ratio in my mind of where the break point between the private bar and the employed bar is. As I think I mentioned, the assumption in the 2020 initiative for the public defender's offices was that there would be an 80-20 split. 80% would go to employed defenders, 20% would go to contract defenders. I think the employment world reality and the fiscal reality both support the proposition that at the outset, if it were 80-20, it would be 80-20 in the other direction. The public defender's office's costs can be fixed and totally predictable. And then the caseload for the public defender's offices should be fixed in proportion to the budget with reference to the ABA standards for appropriate caseload for defenders. And we can generate that for you if you'd like. What does that look like? And then in a given county, ultimately, the percentage of cases going to the public defender's office versus private counsel might vary based on caseload, because the defender's office could never exceed the appropriate caseload. What that proportion starts out as is your call. I think that the most important part of the public defender office at the outset, two parts. One is the route to entry for new defenders. And two is the ability of the management tier of the public defender's office to manage not only the employed defenders, but also to provide oversight and the training and supervision directly to, in the courtroom, in the practice, directly to the contract attorneys as well. And so that's how I would build it. I would build it with some folks on board with experience, some folks on board as new attorneys, just like in the prosecutor's offices. And I might build that lighter than it would later become. I would build the second tier of it fully in each place it was going to be. And then I said earlier, to do the oversight function, there's supposed to be a 10-to-1 attorney supervisor ratio. Rather than stick 3 people in this office, I see those people as being in the management tier of the public defender office, is managing both the employed counsel and the assigned counsel. I don't know if that was articulate enough to follow, but that's the model I see coming out. I think that at the outset, it would be heavily skewed with work going to contract counsel, because that's who's here to do the work. That's how most people report wanting to do the work. And we can improve the way the system provides that work. I'm sorry, I don't have the ability to silence that phone, but it will stop in a second. Over the time, I anticipate that it's likely to be more people in the public defender's office, at least at the beginning of their careers, because as people come out of school now, hanging a shingle is a difficult proposition for them. I would point out in the context of the conversation that defenders' offices nationwide are having difficulty recruiting people, as are law firms generally, frankly. New Hampshire, which has a model where the state essentially contracts with an outside entity who then operates like a public defender office, which would be a fine model if we're funded properly. They're crashing to some extent. In their case, their attorney numbers are crashing. They're having difficulty staffing cases. And I'm on a number of listservs and in groups for public defense executives. The conversation nationwide is about recruitment and retention for people into these positions. So if you suddenly said, Justin, here's an unlimited budget, you can have all the people you want, I still couldn't hire those people. They don't exist. And so that 80-20 split's probably in the wrong direction at the outset.
Thank you very much for that elaboration. Thank you, Madam Chair.
Senator Kime?
Thank you. Thanks for being here, Mr. Andrus. I don't have really a lot of questions for you. I think when I do have questions, I reach out. You're very responsive, and I really appreciate that. So just a couple comments. Really, I appreciate your energy in this and your creativity. I feel very confident having MCLS under your direction, under your leadership, and I appreciate all the work that you're putting in. I know it requires a lot from you and your staff. One of the things that I recognize in almost everyone we're talking to, whether it's the courts or whether it's child welfare, it's the lack of ability to hire people to do the work that we need to have done. And I appreciate that you're, trying to work with the school and looking at, some options to try to help you with the hiring, making something attractive to folks. But the reality is there just aren't enough folks out there everywhere. It's really what we're being told constantly. So that's a difficulty facing everything in Maine. And I'm not sure, where we go with that. One question I did have for you, just for clarification, and it's just a quick one. You did mention you were able to hire the audit staff, and then you were unable to, and I can't remember how many that was, but you were unable to hire paralegals. And I just didn't know, just in a short answer, if you could tell me what the difference is there and why you think you were able to hire the audit staff and not paralegals.
The audit staff are both attorneys. And so it's audit director Brochu and audit counsel Washer, and they had salaries available to them that were good for them, especially with the benefits that come from the state and stuff. So they were attractive, and we got candidates. I think the paralegal position, candidly, is undervalued by the state. That's not this committee or the legislature's decision, frankly. That's where our pay rates are, our pay grades are, for the most part, in the state. And anecdotally, I hear from a paralegal in my life, my wife, who's been getting cold calls from law firms or from recruiters from law firms at rates, very, very much higher. I don't mean a couple of dollars an hour. I mean, $10, $15 an hour more than what the state offered. So there is the problem of not enough people generally. And then there's the problem of, from the available pool, us not necessarily being competitive yet. But I do think that and I know you asked for a short answer, I do think the problem of being able to hire, we need to think about in every aspect of what we do, because, the reality is, given the slots, we'd be hard pressed to fill any of them necessarily. And whatever we do from here, at least in the short term, needs to reflect that reality.
Thank you for that. And thank you for your work. Thank you for being here today.
Thank you.
Committee members, are there any additional questions? I'm not seeing any hands. I did have a question for you, Justin. In your, this is a problem that we tried to fix and we haven't found the right statutory fix, but in your responses to the OPEGA and Sixth Amendment Center reports that you sent to the governor and Chief Justice Stanfill, you mentioned the problem with the financial eligibility screenings, and that them being located, the indigency screenings being located within MCILS versus being located within the court system, within the judicial branch. And I know that both of those options seem to create concerns about a conflict of interest. Have you spent any time thinking about whether there's a third option that we could use and create a statutory fix for?
I have thought about it, but I haven't found the solution.
Oh, darn.
Thought about it a lot. And I've had conversations with the acting court administrator and also with some of the jurists themselves. And at the end of every conversation, we smile at each other and say, no problem as long as it isn't me. It doesn't have to be you. I don't have a solution. We don't have a state-run statutory sort of early intervention stuff, like Maine Pretrial Services is private, that sort of stuff. It's not super private. It's not a state agency. One of the things that I'd like to see in the longer term is a codified diversion program. And that's going to need some folks to operate it. I think ultimately that leads to cost savings in addition to better justice, because it's going to divert some people out of the program. So I think it pays for itself. But perhaps an organization whose job is to do that early work with somebody to see if they're appropriate for diversion, determine whether they're eligible for counsel, that might be the solution. I don't see an existing entity in the state who really should have that function either.
I think there might be something covering your microphone. Occasionally, you sound like you're literally underwater.
I apologize. I was proud to come to the office today so that you weren't going to be subject to my satellite internet to discover that the office internet is weak today. So that's what's happening. I keep getting a bandwidth warning on my screen.
Okay, that's what it is. I wish it was as simple as moving a piece of paper. I just wanted to have a follow-up. You spoke about how in fact most states, even if they have a public defender office, and they all do other than Maine, that they have these hybrid systems to a greater or lesser extent. Do you know what the solution that those other states is using for indigency screenings when they've got the hybrid system?
I don't, but I can find out what some of those options are.
Okay, thank you. I think it's a really important problem to address, and it seems like one that would be fixable. Appreciate your thoughts on that. Representative Newell?
Thank you, Madam Chair. Good morning, Mr. Andrus.
Andrus, yep.
Representative Newell from Washington County. You mentioned the county earlier in your overview. I just have a quick question relating to the number page from your attorney costs, where it lists by case type. I'm interested in whether or not you have separate data that reflects by county, breakdown of cases by county. Is that available?
It is. I can produce that for you.
Wonderful. Thank you.
Committee members, any additional questions? I'm not seeing any. We really appreciate all of the work that you're doing, and in addition, really appreciate you presenting the report today. And at this point, committee members, I think it's important for us to bring over some of the other commission members. And I will actually, before we do that, I would like to give the virtual floor to Josh Tardy, who is the chair of the commission, to present any additional remarks or information that he has.
Nothing additional, Madam Chair. Thank you for the opportunity, and thank you for taking the time to hear the director's report.
Thank you. And at this point, we'll bring over some other members, and I'm going to ask, so I'll ask you, Commissioner Tardy, should we bring over all three of the commissioners who are here at this point in one fell swoop?
Yeah, I think that makes sense.
Okay, I'll do that. And I know that the interim executive director, Ellie Maciag, is here. Should I bring her over as well?
No, I don't think she's planning on presenting.
Okay.
Only if there's a specific question.
All right, thank you. So, commission members, you'll feel yourselves going through cyberspace. And I did want to let everybody know that we also have Julia Finn, a representative from the judicial branch, who's available if we have questions for her. And so thank you all so much for joining us today. And I'm not actually sure where to begin. So I will, I see that Justice Alexander, your microphone is off, so we can begin with you. Go ahead.
Oh, well, good morning, Madam Chair. Thank you. I don't know that I want to say I think it's a tremendous thing that I haven't had much to do with, but the evolution over the last year is absolutely dramatic. And that's largely the responsibility of Josh Tardy, the chair, who helped recruit Justin Andrews. Justin Andrews, who's been the executive director of the commission, and I don't know how he finds time in 24 hours a day to make the transition he's made. And the third is you folks. I mean, your work, legislation, support for resources and all was absolutely essential to make this transition. to where the commission is just didn't have any accountability, responsibility. We're now getting on top of things. We had some challenges with attorneys who were, not billing efficiently before, and because they didn't like the new systems, there was some withdrawal for a while. They're coming back now, and all. And I just say that the change has been dramatic, and you folks have a large role in that. And I thank you. I think going forward, I basically endorse the things that Justin said, and that the report that was provided by Joss and Justin and by the commission after discussion last week resulted in. I want to thank you too. A number of you members of the legislature have, joined our committee meetings from time to time, and we very much appreciate it. To that, beyond that, unless you have specific questions, I don't have much to add. Justin's already touched on some of the key things that are important for recruiting, which I prepared a memorandum on for the commission a couple months ago. Student debt forgiveness. There's no reason that people who do a lot of, even if it isn't all their work, but people who do a lot of court-appointed work and necessarily public service didn't have the same type of forgiveness as prosecutors do, or veterinarians do, or things like that. I think that's critical. Health insurance is important. We've got to find a way to do that. And I think we're exploring that, whether we could get sort of a group of attorneys that do a significant amount of work and be able to get the prices down close to the state level, or have a state supported system for attorneys that do a lot of public defender work. But beyond that, what I say is really repetitive of what Justin said and what Justin and Josh have reported to you. And beyond that, and I can answer any other questions, I just want to thank you for all of you for your engagement and for your joining with us in basically turning this system around. And it's, don't be shy about taking credit for that. You were there on the ground. You did a lot of the work. Thank you.
Well, on behalf of the whole committee, you're welcome. We appreciate all the work that you're doing on the commission, and also appreciate your acknowledgement of the work we're doing. We really appreciate that. Could you please, I think there may be some committee questions for you, but could you just please introduce yourself? I think everybody on the committee knows you, but there may be members of the public watching on YouTube.
I'm sorry. My name is Donald Alexander. I'm a retired justice of the Maine Supreme Judicial Court, but being retired means I don't have to do any more judge work. I can do other stuff, and I was privileged to be appointed to the commission by the governor. That's who I am, and that's why I'm here.
Thank you. Let's see if there are any committee questions. Committee members, are there any questions for Justice Alexander? And I am not seeing any. Again, we appreciate you coming to our meeting today. And next we'll hear from Ron Schneider. And could you please also start out with a brief introduction and then any remarks you'd like to make?
Thank you very much. I appreciate it. My name is Ron Schneider. I'm a lawyer in Portland, although I'm still working remotely largely, like many people. I was part of the original Clifford Commission that ended up creating the Maine Commission on Digital Legal Services. And I was the original, the first chair for 3 years, for the first 3 years, and now very happy to be back on the commission after Governor Mills was elected and appointed me to be back on the commission. I want to share Justice Alexander's thank you to this committee. I think that your work this year, last year, this year has helped us tremendously. We have needed to move forward for a long time, and your support and your advocacy has been tremendously helpful. I do want to say, though, that one of my biggest disappointments last year was the fact that we didn't move forward with the funding for a public defender's office. And that was the only thing we didn't do of all the things we were talking about doing. And I I think it's really important for this committee, for everyone to remember that the state of Maine paid with taxpayer dollars for experts to do a deep dive into Maine's system and to provide their findings and their recommendations. And the Sixth Amendment Center were the experts that were hired. And they came out with a report recommending a number of things, one of which was a public defender's office, and not solely a public defender's office just everywhere, but just saying, look, we need to have a public defender's office somewhere, you know, and part of a hybrid system and how you build that. It's just not one thing or another. And I think that's what we want to make clear. And I think Justin's made it clear as well. But the Sixth Amendment Center made it clear. It is important to know that the Sixth Amendment Center is not alone in recommending and advocating as a standard to have a public defender's office. The ABA, the American Bar Association, it's part of their 10 principles of a defense delivery system, that there be a public defender's office somewhere. The National Association for Criminal Defense Attorneys, defense lawyers, NACDL, not MACDL, not the Maine Association, but the National Association, declares it's also that there should be full-time lawyers, the public defender's office in a state. We remain the only state in the nation without a public defender's office somewhere as part of a hybrid system. The only state. And I've said it before, we're just not that special. Maine is a very special place, unique in many ways, but not so special and not so unique that a public defender's office would not be appropriate here. One of the things, as Justin said, we have heard from people, and this could actually explain a bit of what's going on with younger people not coming into the system, is we have heard that they're looking for everything that employment gives them, right? They're looking for training, support, guidance, administrative support, sick time, vacation time, health insurance, life insurance, disability insurance, retirement plans. That's what they're looking for. They're looking for legal research help, loan forgiveness. And I want to make a point about loan forgiveness that was made to me, and I think it's a great point. We're talking about the possibility, and let me just also add something about LRAP, loan forgiveness programs, loan repayment assistance programs. When I was at the law school a long time ago now, I was the president of the Maine Association for Public Interest Law for 2 years. And one of the things that we started, and I was part of starting, was the seed money for an LRAP program. I think we started with $10,000. Now the law school offers participation in LRAP for lawyers who are earning $55,000 or less, full-time employment somewhere doing public interest work. Okay. But what we're talking about is, we are talking about sort of cobbling together some attempt to get loan repayment to people. Because loan repayment is I mean, loans are crushing at this point. They were difficult for me, and I graduated 20 something years ago. But what if we do this as a state and somehow develop, using taxpayer dollars, a loan forgiveness program available to lawyers who are assigned in the system? We're going to be throwing away federal dollars. Right now, there's a loan forgiveness that is federal money that these lawyers can access if they're fully employed. The state of Maine would create one and fund it. We would, and for assigned lawyers, and make some special arrangement for them. We'd be throwing away, we'd be spending state money and throwing away and not taking advantage of federal money. And I'm on the budget board in my town. If we get a federal match or a state match, or we can use federal money or state money rather than local taxpayer money, I think we usually try to use that federal or state money and not access the local taxpayers. I think that's a great point that I quite frankly had not thought about, but it was made to me. And I think it's a point that we cannot forget as we're talking about something that really does inhibit lawyers from taking jobs at a lower pay. I will just say it is difficult sometimes to get lawyers just to work in Maine, where the compensation is lower than Boston or New York. If they come from some other state with 200,000, $250,000 in debt, which is a real thing. It's not easy for them to come and move to Maine because we don't pay our lawyers, even in the private law firms, anything close to what you can get in Boston, New York, or DC, or anywhere else. I do want to, though, also say that and reiterate for that what Justin put forward in his report. We are doing better, but looking at the ABA principles, the 10 principles of a defense delivery system, we are failing. We do get a failing grade. We are not. I know that's hard to hear because we're doing better, but we still get a failing grade when you apply those 10 principles to us. And so I'm just here to say thank you, but also to say we need to keep moving forward. And one of the things we really need to do is have some kind of institutionalized employment-based public defender's office in this state, both at the trial level and at the appellate level. Thank you very much.
Thank you. And I see that there are a number of questions. Representative Thorne, go ahead.
Thank you, Madam Chair. Welcome and thank you, Mr. Snyder, for your comments and suggestions. And sometimes I'm slow on the uptake of these things. I'm just a freshman legislator, so bear with me. When you mention loan forgiveness program on a federal level versus a state level, what prevents that from being instituted right now? Is that a in order to enact federal loan forgiveness program, is that an action of the legislature versus an act of the MCILS?
Right. It's my understanding, and Justin has looked into this, and maybe Commissioner Alexander has as well. But it's my understanding that there is a federal program for people who are employed, but you have to be employed. If you are merely if you're a private lawyer who gets assigned cases, that does not make you eligible for the loan forgiveness program. We are talking about whenever there's a discussion about getting loan forgiveness to lawyers who are commission assigned lawyers, that would require some legislative fix. I'm not sure that it's possible to fix it at the federal level, but some legislative fix within the state of Maine. We cannot ourselves, I don't believe, we don't have the money, the endowment, or the funds to provide loan forgiveness to private lawyers. I think that comes with a whole host of problems too, because just let me say, we have private lawyers who are running, some of them do almost exclusively assigned cases, but there are others who have their own firm and they are running other cases. They're doing other kinds of work. They'll do there are people who do personal injury work. They're general practitioners. And what you would be suggesting is that the state fund loan forgiveness for those people who are running their own business, essentially. Someone who hangs a shingle, runs their own law firm. And I think that could be a complication. I don't know enough about how you sort through that. My bigger point, though, is if you do this fix at a state level and spend state money, you wouldn't be taking advantage of the federal money by having employed lawyers. And let me also say that the expense that we're talking about, I think this is also important as we keep increasing our funding, as we should. I'm not suggesting our funding is out of control, but I think some people may view it that way. But as we keep increasing our funding to permit lawyers to be able to cover overhead, have a retirement plan, do these other things. You start to ask a more serious question is how much are we spending money to cobble things together rather than to have an organized system with a consistent, predictable budget, which is what a public defender system by and large offers. We're spending money to track our money. I mean, we're spending a tremendous amount of focused time and effort and money on how the money is spent rather than it's the quantitative question rather than the qualitative question.
And to go back to the student loan forgiveness aspect of it, your contention is that that would only apply to salaried attorneys versus commissioned attorneys?
Correct. And that's true for the state, the UMaine Law School loan repayment assistance program as well. You have to be fully employed in a public service job. Like Pine Tree Legal Assistance or Volunteer Lawyers Project or Elderly, I'm sorry, I'm forgetting the official name.
And you're thinking of that more as a incentive versus a retention incentive, or both?
I think it's both. I think that the crushing debt, I mean, people have debt that's with payments required of them that are larger than a mortgage. Even with house prices up high, the ultimate monthly payment could be higher for some people, unless they extend their loans over 25 years, right? The original loan payment is 10 years. So you're looking at trying to pay, for some people, between $150,000 and $200,000 back over 10 years. It's a lot of money.
Thank you. My phone's done ringing now. Appreciate your answer. Thank you, Madam Chair.
Yeah, thank you both. Representative Moriarty, go ahead.
Thank you, Madam Chair. Mr. Schneider, if we begin to move toward a public defender system, it seems to me that it more likely is going to take place over a series of phases or steps, so to speak. What are your thoughts on a pilot project involving one or more counties, or I was thinking perhaps a single prosecutorial district? And specifically, I was thinking of Kennebec and Somerset. Somerset being clearly one of the more rural counties, Kennebec less so. And you might be sort of encompassing a microcosm of Maine by using that district. So any thoughts on that point?
Yeah, I guess my view is, and I think it's a shared view, is where this happens is not necessarily as important as that it happens. And I think the idea that you would have a district that shares different characteristics to see how it would work would be a good thing. One of the, as you've heard, we do have an issue in rural counties. And so there's a question about, well, why are we thinking about replacing, putting a PD's office in Kennebec or Somerset when we don't have a significant issue with lawyers there now? But it's the reality is that there are more reasons to have a PD's office than to just replace lawyers. Right? We're not looking to necessarily just replace lawyers or have enough lawyers. So I think it would be a good idea. And I also think that one of the things, as Justin's talking about, is with his quote flying squad, is that there would be lawyers also that could be part of either employed, you call them employed, or public defenders, whatever you wanted to call them, I guess, that would travel, just as some of the prosecutors do, or you could actually set up an actual office in a county. I mean, we just have to remember that it's not only the high population areas that could benefit from either system or from a public defender system. And you just take, for example, other states that some states cover every county, even rural counties, with a public defender's office. So I do think some kind of system like that would allow you to look at how it would work in two kind of different kinds of counties would be a good idea.
So it makes sense to you to begin with a pilot project and learn and move forward?
Yeah, I don't think you could start with a statewide. Absolutely. I should have been clear about that. Thank you for that question, because we're not advocating to start statewide on a trial level. I think on the appellate level, that would be a bit easier because it doesn't require necessarily brick and mortar individual offices necessarily, but that might be easier to do on a statewide basis,
Yes.
an appellate level.
Sure. Okay, thanks.
Representative Harnett?
Thank you, Madam Chair. Thank you for being here today, Ron. Nice to see you again. You mentioned other things that rostered attorneys need in addition to loan forgiveness. And I know from my days on the Maine Bar Foundation, which is now almost 20 years ago, that the LRAP program was instrumental in recruitment and retention for the legal service entities that you mentioned. And back then there were people with $200,000 to $300,000 in debt. I mean, it was just staggering to see. But you also talked about training, support, administrative support, life insurance, health insurance, disability insurance, retirement options. If we continue with, and we are going to continue with a hybrid program, hopefully with a public defender as well, with full-time employees, how do you address those issues? Because we heard that over and over again from the rostered attorneys in December when they testified to the commission.
Well, I think part of that has to do with the hourly rate, but I also think as you evolve, the truth is that most likely that a public defender's office would evolve to a larger system, whereas, as Justin said, it's more like a large law firm, maybe with 100 lawyers or 120 lawyers, like the AG's office, right? The AG's office works kind of like a law firm with over 100 lawyers. And public defender's offices often act that way. So the lawyers, the 15 to 20, maybe 30%, I don't know, lawyers who are doing the conflict work or other kinds of work in the hybrid system, you would have to provide a higher rate to allow them to run their business. That's also a problem. But overall, the ability to provide people in the system who are employed with these things that young people are looking for and young people are getting, right? Young people come out of school and they're being offered as an employment all of the things that I talked about. Amados will pay you $20 an hour or $25 an hour with a $1,500 signing bonus and profit sharing. Yeah, but other people, kids are coming out of school and they're getting all of these things: life insurance, disability insurance. It's how you're going to bring young people into the system who are interested in doing this kind of work but they can't do for $80 an hour and support themselves and their family.
Thank you. And may I have a quick follow-up, Senator Carney? A lot of the discussion we've had over the last couple of years has used a phrase I'm not really fond of, but it's about leveling the playing field between the prosecution and the defense of indigent defendants. And the state of Maine has an attorney general. We have lots of district attorneys and assistant district attorneys. As a first step, or as one of the first steps, do we need a public defender? A position of on the same level as an attorney general or a district attorney, not just a public defender's office, but the position of public defender.
Yes, I think we need a chief public defender. If that's not the executive director of the Maine Commission, right? That's a question. We are missing that person at the table, or if you want to call it the one of the three legs of the three-legged stool. I mean, we are missing that person who is at the table and must be at the table whenever there's a discussion of policy, who can coordinate efforts to counter the prosecution. Who does coordinate? They don't do all the same. I'm not saying every office or every ADA or every DA is exactly the same, but they do meet, they do coordinate. We talk about it, we offer things, we say we're doing this, we're doing that, but we don't have the same level of coordination. When there are policies regarding bail, we don't mandate that every lawyer file a particular motion or advocate necessarily. I mean, Justin does a great job of trying to talk to people and offer things up, but it's not the same. We end up, this was early today, whether what position we have at the table. We're almost like we're getting better, but it's still almost knocking at the door to see if we can be let in.
Thank you for that. Thank you, Madam Chair.
Representative Evangelos, go ahead.
Hi, Rob. Rob, we make $12,000 a year as legislators. Do you know if Amato's is throwing pizza in on that offer?
I've often thought about how much fun it would be to actually be in the legislature. I think what you guys do is really interesting, but I don't think I could take the pay cut. But Amato's maybe, I don't know.
Did you have another question, Representative Evangelos?
No, just being fresh.
Okay. I do have a follow-up question regarding the public defender's office, and we heard the executive director speak at length about kind of his vision for what the public defender's office could be like, at least initially, with a deployable team. Have you spent time thinking about that, and do you have a vision that is different, or if you're thinking of the same vision, is there anything you'd like to add to his vision? I'm really curious to hear more about how that would work.
I think what Justin's idea of as a deployable team is a function of necessity and not necessarily something that would be desirable as a long-term solution. What you'd prefer is a group of people who interact in a system with the prosecutors, just like the prosecutors have the ability to have a consistent approach within their district. But as a starting point, as a way to try to solve some of the problems we have, and it may be, quite frankly, something that is necessary in the future. So let's just say if you had an office in Kennebec, in the building where MCILS is now, but you said, okay, well, we've got 2 days we have to cover up in Aroostook, we have nobody to do that. Well, that might be that we either find a place in the courthouse, like the prosecutors have a place in the courthouse. We find a place in the courthouse for those attorneys to go. That may be a longer term need, but I don't think it's necessarily preferable. I mean, right now, I think it's a good idea, I guess I would say. But my vision, my thought about this system is not that that's something that we do on a regular basis, unless I will say, perhaps, with respect to cases like murder cases, right? The AG's office has, they prosecute murders. They move all about the state with their team doing that kind of specialized work. So I suppose you could have a movable, deployable team doing specialized, highly niche work.
Mhm. Could you also utilize that system for appellate work?
Oh, definitely. I think the ease of the way appellate work goes is a lot of it is done just alone. You know, you're looking at records, you're reading, you're writing. I think that can be done anywhere. I do think it's important to have an office where people, some place where people can go and meet and have resources and assistance and administration and admin report. But I don't know that you would say, I mean, someone could disagree with me, but I don't know why a lawyer in Portland couldn't handle an appellate case out of Aroostook County.
Thank you very much for your answers to the questions from all of us today. Committee members, any final questions for Commissioner Snyder? Okay, I am not seeing any, and so now we'll turn to
Thank you very much.
You're welcome. We'll turn to Commissioner Cummins. Commissioner, if you could activate your camera so that we could see you. I know you're on the screen a moment ago.
I'm here. Yep. Thank you.
Welcome. Could you please introduce yourself and then provide any comments that you have? And then I'm sure we'll have some questions as well.
I'm happy to do so and consider it a privilege to be here. Thank you. I'm about to conclude my 60th year as a trial lawyer who has tried a number of serious criminal cases, both in state and federal court, mostly on a pro bono basis because my typical practice is as a plaintiff's trial lawyer. I've worked with and involved in public defense efforts for almost all of that 60 years. I came to Maine 7 years ago at the invitation of Peter Detroit to join his firm as of counsel. I came here shortly before I knew much about the public defense system in Maine, and it didn't take me long to figure out that it just doesn't work. Now, I want to add the congratulations that were extended to your legislative efforts. I want to congratulate Justin for all the good work he's done in connection with improving the functioning of MCILS, and I'm emphasizing improving the functioning of MCILS, and for Josh in the fashion that he's led our efforts, and along with Ron, who has had his hands in this water for a long time. And I wanted to do that before I throw a wet blanket on all of this discussion, because I think there's a reality that we really have to consider here. Starting at the end, I think Steve Moriarty asked about, what about a pilot project? Well, we have a bill that needs to be funded. That bill is ready to go. We can proceed, but let me speak more broadly, if I may, and really try to bring some reality to this. In the fall, we conducted a survey of our rostered council. I don't know how many of you members of the legislature have had an opportunity to review the results of that survey. I would suggest it would make your hair stand on end. It was described by some that we're operating in a Kafkaesque circumstance here in Maine. That survey was followed up, and it was alluded to earlier. I know Representative Moriarty and Harnett and Evangelos, I think, participated. That survey was followed up with a forum on December 9th. And that forum conveyed to all who were listening, excuse me, that the system in Maine is not working. Our dedicated, hardworking lawyers remain underfunded, remain without resources, have too many cases. And while Justin's first 5 minutes of the presentation made it sound like things are moving in the right direction, and I think they are. But the fact is that we still have too many cases, too few qualified lawyers, and too many burdens on those lawyers who have dedicated their service to the indigent. I had submitted to the commission for consideration a letter that would have gone to the governor, to the legislature, and to the judicial branch, suggesting that there be a conference to address these issues on a broad scale. You've asked how we can approach these issues. I don't think discussing loan forgiveness or any of the other specifics of all the myriad problems that our rostered lawyers face is the way to go. We need, and this would be of great help to the legislature, I believe, we need a commission established to look at this on a broader scale, to face the reality that we don't have parity between the defense function and the prosecution function in the state of Maine. For example, if I were to try a murder case today and it involved the issue of ballistics, forensics, maybe even lie detector issues, unique discovery issues, without the resources that are available to the criminal defense lawyer in private practice, it's essentially impossible to do that. I'm not sure that I have all the answers, but I do recognize one thing. Our system is not working in Maine. Our lawyers are overburdened. There's not enough money to fund the needed improvements. And until that changes, you can put a patch on a tire, but if the threads are gone, it's not going to help. I'd be happy to answer all kinds of questions, but I would not want this legislative body to leave this meeting thinking in any way, shape, or form that the public defense system in Maine is improved to the point that it should be. That's just not the reality. And I defy anybody to challenge that statement. There's an element of our profession that mandates that we contribute our pro bono services. And I believe in that. But to put the burdens on these rostered lawyers that we have without providing the adequate support is it's simply unfair. And harking back to an observation Ron made, we've been told for decades through one report or independent reports that the system in Maine is constitutionally defective. Think about that for a moment. We have a constitutionally defective defender system. How can that be tolerated? And I suggest it can. We need the funding, but more importantly, we need to corral the necessary folks who are in a position to make the changes that are needed. We have to bring to their attention the problems. We have to bring to their attention potential solutions. And until something like that on a broad basis is accomplished, we can continue to patch the tire, but it's not going to help. I don't want to sound completely negative because after the forum, I spoke with a number of the rostered lawyers about the problems they face, how enthused they are about the possibility of seeing things change. A first step is fund the pending bill for the Kennebec pilot project. It's not a total solution. Do we need an appellate defender office? Sure we do. And that's a statewide function. Do we need a chief public defender in the state of Maine? A great idea. Do we need to figure out loan forgiveness? Terrific. Do we need to figure out how to get resources to the rostered lawyers? Absolutely. The problems are manifest, but I'll leave you with one thought. Are we going to close this meeting understanding that we have a constitutionally defective defender system and not immediately want to solve that problem? What's the responsibility that we face when we address that reality? What is the responsibility that we have to try to repair a constitutionally defective defender system? I don't have all the answers. I have some, and I'll just footnote for one moment something 25 years ago or more. I guess it's 50 now. I'm sorry. When you get to be, I'm approaching 90, so sometimes I forget how well time has passed. 50 years ago, a group of private lawyers, I was privileged to be a co-chair of a commission that over a 2-year period reformed the criminal justice system in Cook County, Illinois. I have the report on my desk. I'd be happy to share it. We need something like that for the defender system in Maine. And I'm willing to spend 24/7 to participate in that. I know that others are willing to do the same. Things have got to change. And as hardworking as Justin has been in solving a lot of our problems, as effective as Josh has been in corralling the commission and moving in the right direction, as wonderful has been the suggestions of Don Alexander and the work of Rod Snyder and others on the commission, we're not going to be able to do it without a broad-based approach to this problem. Thanks.
Thank you very much. And I do want to assure you that, and we are here, we're committed to fixing the problem, and that's why all of you have had our attention today, and we appreciate you working with us to try to bring us to the right solution.
Thank you. I know you are. That's evident from the legislative efforts you pursued and passed. We increased the amount of money. We got paid to our rostered lawyers. You did those other things that are so important. The one bill has not passed. It should be funded. We need more funding. I won't repeat what you know is obvious. Thank you.
Thank you. Committee members, could you please raise your hand if you have questions for Commissioner Cummins? I am not seeing any questions at this point. Thank you all three of you commissioners for presenting your thoughts today. And just one final ask of committee members, are there any questions for any of the three commissioners who are with us this morning? Not seeing any questions. At this point, we do have Representative Evangelos. Go ahead with your question.
Just wanted to contribute a fact that I've uncovered in research in other states. In the public defender offices, the paralegal administrative support and all the other ancillary costs are paid separately and not taken out of the attorney's pay.
Thank you very much. At this point, since it seems like we don't have any questions for the commissioners, I would really like to see if committee members have any discussion on the matters that we've heard. I know we've heard a lot and people may want to digest a little bit, but I also feel like it would be very important for those of us who want to share thoughts to go ahead and share them in reaction to the report we've heard today. And as Representative Evangelos raised the issue earlier, we do have the authority to report out committee legislation in response to this report. And so I think what I'll do is I'm going to move the commissioners back onto the attendee part of the meeting, and you can continue to listen. And we may have questions for you either today or at some later point. And at this point, I'd like to initiate any committee discussion that committee members' thoughts, reflections, suggestions. And Representative Babbage,
Thank you.
Can begin us.
Yes, thank you, Madam Chair. I want to commend all those folks that testified this morning. We are blessed to have such able people contributing to this cause. I want to ask the chair or clarify to the chair that this commission's report, being an annual report, authorizing the ability of the committee to go forward with legislation expires with this session, and that a new legislature would begin anew, but of course beginning perhaps another report. But the authorization we get from this report expires with this session. I just want to.
Yeah, I can clarify, Representative Babbage and other members of the committee. So the authorization we have is not a creature of the report. It is a creature of statute. We have the authority to report out legislation. So it could be one bill, it could be more than one bill. And that is the mechanism that we use when we reported out the legislation. There were, I think, 3 bills that we reported out last session that resulted in the increased funding. Those were committee bills that were reported out in response to this report. And so the authorization doesn't kind of expire. It is renewed every year upon issuance of the commission's report. The report comes out in January, and then we have authority that I believe endures until the legislature adjourns to report out legislation.
Thank you for that, because when we often discuss creating a commission or a study or whatever, we also justify that by the fact that the legislature would be authorized to do so, but the legislator's authority is not from the authorization of the commission or study. It's in statute.
Yep, the obligation to issue the report as well as the authority for us to generate legislation, those are both contained within the statute.
Thank you so much.
You're welcome. Representative Moriarty?
Thank you, Madam Chair. I have a similar a status update question to follow on Representative Babbage. With respect to the pilot project issue, I've lost the thread. Was that bill held over? Is it still pending? Or do you envision that as being part of legislation that we might report out this session?
That is a very good question. And I think I know the answer, but I don't want to make a mistake on that because it's a really important issue. And I would just ask our OPLA analyst, Peggy, if you either have the answer in your encyclopedic memory of the work that this committee has done, or if you could look into it for us, please.
Yes, I'd be happy to. I know that there is, I was thinking that it had been carried over on the Appropriations Committee table, but I'm not seeing that as listed in my list. So I'm going to investigate that and get back to you.
Thank you. Great question, Representative Moriarty. Representative Harnett, I think you're next.
Thank you very much, Madam Chair. And I look forward to Peggy's conclusion. It was my understanding it was on the appropriations table, but our analyst understands these issues far better than I do. Clearly, we've heard a lot of discussion about this. For those of you who are on the committee in the 129th, it's now been we're in our fourth year of hearing this. But that doesn't mean we don't need time to digest. But I would just sort of point out, we did make some progress, but we've heard from every member of the commission that spoke, even though they have different strategies as to how to improve things in some ways, that I think we must look at funding a public defender's office, regardless of where that stands in appropriations. I think we must look at establishing an appellate division of a public defender's office, which could effectively operate statewide. But we also heard that to assist the rostered attorneys, I think we need to revisit the hourly rate that we have set. In the 129th, we requested $100 an hour. That was changed to 80 in appropriations. I wouldn't say we are awash in money right now, but there is more money available to improve what is a fundamental right that needs to be protected, and that's that indigent legal defendants receive adequate representation, both in criminal matters and in matters where they're facing the loss of a child through non-criminal proceedings. So I, for one, want to, when we consider reporting out legislation, keep those three things in mind. And also, if we learn that the funding of a pilot project, regardless of where it is established, resides in the Appropriations Committee, that we make clear to that committee that this is a priority of the Judiciary Committee moving forward. Thank you.
Thank you very much. Representative Evangelos, you're next.
Thank you, Madam Chair. Total agreement with Representative Harnett. And I just, I don't know what the proper lines of communications are, whether it goes to the chief executive or whoever regarding the money, but we are sitting on $1 billion now. And I think a communication needs to be delivered that we're operating in violation of constitutional law. It's extremely serious. And we're not asking for that much of that money, but they need to be put on notice that we're coming. We need to fix this. And the commitment is there from everyone that's been working together. So I don't know if the chairs want to pass that along to the appropriate parties that we're going to need some money, and the money's there. So don't spend it all. We need a little. Thank you.
Thank you, Representative Evangelos. And I did want to point out that I think our most powerful voice is the legislation that we can report out as a committee. And so I think we should start working in that direction. I see that our analyst has rejoined us.
Yes, so LD 1686 was one of those 3 bills you reported out last year, and it is carried over on the Appropriations Committee's appropriations table.
Thank you.
Thank you so much. Representative Reckitt, you're next. And then Representative Thorne, were you trying to raise your hand as well?
I just wanted to catch the LD number again.
It's LD 1686.
Thank you. That was it.
Thank you. Representative Reckitt, go ahead.
Yeah, I have a question, and I suspect where I want to ask it is totally inappropriate. So if I do that, I may want to redirect it to you, Senator Carney, or to the analyst. I'm not sure. I don't think the analyst is the right one. I think it's either you or, but the person I want to ask a question of is Senator Keim. And I know that this is not a moment when we ask each other questions, but to me, it's important to understand, because Senator Keim has been deeply involved in these discussions for all my time on the Judiciary Committee and has frequently come up with ideas that I think had merit, some of which moved, some of which haven't. And so I'm curious to know the reaction to what we've heard today, particularly from Director Andrus, whether or not there are some pieces that are less troublesome now, some that are still there. I don't know what I want to know, except I want to know your opinion, Senator Keim. And if you have to do it through Senator Carney, fine. But or whether I have to wait till work session, I'd rather not, because I'd like to think about it for a bit. So that my question is, what do you think?
That's a very appropriate question. This is our committee discussion. And Senator Keim, did you want to share your thoughts?
Sure. Thank you for that, Representative Reckitt. I have been sitting here thinking about, what we could propose and how to keep moving forward, even if it's marginally. Part of the money that we have now, I think all of us recognize it doesn't represent money that we have continually. We had a large influx of money from the federal government that's one-time funding. And so a big concern is going to be in appropriations that we don't create liabilities that we don't have funding for in the future. But then we have this issue, and I think a constitutional issue with both the fact that we're not having timely trials, right? So there's no speedy trial happening in Maine, and not a great way to get there either. And then we don't have, and we still have the problem with the representation. And I see both of them as constitutional issues, and both of them as resource issues. And so I was sitting here thinking about, how are we balancing the need on both of these, because I think they're asks from our committee. Both of them are asked on our committee. Both of them are constitutional issues. So I'm not sure one is even more important than the other right now, because I think they both rise to the level of extreme at this point. The backlog is horrendous. So when I think about spending money, I'm thinking, okay, how do we balance what's coming in front of us, which are so major? So I didn't know if there was a way. I appreciated Justin's flying squad reference. I thought it was, creative and help me think in a different way of what we're facing, because it's true in Kennebec, as he said, there's lawyers available, and then in other counties there aren't. So I would love to explore the idea of increasing what we can give, even if it's giving it to MCILS, increasing the number of lawyers, and then capturing what I think it was Commissioner Schneider was bringing up about the different tax benefits or student loan benefits that might come from, which we might actually capture with increasing how many lawyers they employ. So this is just my my mind is thinking of just different ideas, maybe different than what we have in front of appropriations right now, because if it's bigger than we can do, can we do something? Can we still move the needle? I don't have answers, and I think all of those things I mentioned are things we would want to run by the executive director and say, where could we go? But yeah, I would love for us to discuss that, to see, can we go part way? And if we have the ability to put out more than one bill, maybe we do. And, we fight for what we can in appropriations. But again, just I think balancing the two things we have coming in front of us, like we have to fight really hard for the judicial branch as well, and MCILS, in my opinion.
Thank you for sharing your thoughts. Representative Recca, did you have any
No, I
follow-up
just wanted
questions?
the same thing you just said. The only other odd thing that I had thought about after you talked, Senator Keim, is I started thinking about the student loan issue and whether or not it could be directed somehow, and it's probably illegal to do this, but that's the benefit of not being a lawyer, is I can say illegal things and I have suggestions and you could just correct me. But the point is, if we've got a huge problem, which I know we have in some counties of not having attorneys, if there's a way to direct student loan repayment initiatives to those counties where there are insufficient attorneys, to say, if you practice here, like they do for the doctors, I think in the rural areas, if you sign a contract to work in this underserved area for 3 years, we'll give you X number of dollars of loan repayment. I mean, I think my head's going in those kinds of directions, which I have no idea if they're legal or possible or even fit into the scheme, but they go into my head trying to figure out how we could do something partial that might also move the needle in the rural areas of the state. So I just throw that out for thought.
Could I respond, Madam Chair?
Yes, please do.
Yes. So I was actually trying to send Peggy some messages about figuring out what we had already going on in that direction of, I knew we had a rural lawyers bill. And so maybe that's something we just need a quick overview on what there is out there that we're offering lawyers currently, that if that becomes part of a package deal that's then offered to that any increased lawyers hired by MCLS could take advantage of these. If we had an idea of what the package is out there, maybe then we're jumping in on that and we're saying, hey, let's take advantage. And not only is that a good selling point to whoever they might be hiring, but it's also a great selling point for us to the Appropriations Committee to say, look, if we hire these lawyers, look what other benefits they're just automatically going to be eligible for.
Thank you both. I see that Executive Director Andrus is, his camera is off, but he's still on the panel with us. And I was wondering, Executive Director, if you could activate your camera and then let us know which counties or which prosecutorial districts you feel have the most acute lawyer shortage and are the most underserved from the perspective of contract counsel for MCILS.
Sorry about having a little bit of a Zoom problem there. So from an operational perspective, I would say that the counties where I have the biggest problems are Aroostook County for certain specific case types, and Washington County at the moment. Some others come up now and then, like Piscataquis will come up because there's a low attorney count, but it's also a low case volume. So I run into the issue less often there. And as we think about this, and I probably didn't say this earlier, in an ideal world, I would have some flexibility with child protective stuff, not just with criminal stuff. And so those people may cross over or they may not. As a matter of policy, and Commissioner Schneider said something, and I didn't do a good job of articulating this, but my idea is a little bit of a stopgap. I think I put it in terms of better would be brick and mortar in all these places, but that the budget may not be there for that. Also better would be that the child protective folks were distinct from the criminal people, so they could be really specialists in that area. But if that weren't possible, there are probably people who could serve in both roles. So that's, I think, the short answer.
Just to follow up, because you said for certain types of cases there are shortages in Aroostook County. What are those types of cases, please?
It varies from time to time, but it tends to be that we can get like murders. We get people from out of the county, people will take them. And so it tends to be the sort of complicated cases, felony cases, but not the marquee cases, for lack of a better expression.
So complex, serious felonies, but not murders.
Right. So I don't necessarily have murder-focused attorney there on the roster. They're living up there, but we do have folks that will travel to do it. It's the intermediate stuff. The best analogy I can give you is when I was in the rescue service, people would turn out for the heart attacks and the car accidents, but it's hard to get people for the basic medical costs. And so that's kind of the same, when you're thinking about it, it's the same sort of, it's interesting and challenging. Okay, somebody will take it from far away.
Understood. Thank you. And thanks for reappearing on the panel for us. I see that there are some additional questions, but before I turn to them, Representative Reckitt or Senator Keim, did you want to have any more dialogue on this particular issue?
I did, which is why my hand is up, actually.
Okay.
The thought that came to me as you were talking, Mr. Andrus, is on the child protective issue and the funding issue. It seems to me that the tenor of the legislature overall and multiple committees talking about child protection issues, that it might be a time when we could do a carve out in that arena to get specialized attorney or attorneys, particularly in the areas where there are high numbers of those cases. If it would free up also, if we could get specialized attorneys in that area, in whatever the appropriate place is, or flying around the state, I don't know, whether or not that would free up some attorney time for other serious issues and I just think it'd be the Appropriations Committee itself, as well as the legislature as a whole might be more empathetic to a increased funding issue around child protective attorneys for MCILS. So I just throw that out as a suggestion. May or may not be good.
I think having specialists and having people who are focused in special places, even if they're traveling there to have the moment of focus, has the potential to improve quality of service and net cost savings. Because go back to what we're talking about, the court and the court struggling with attorneys being all over the place, and yet attorneys going places to serve the courts. So an attorney who can't appear in Cumberland County frustrates the Cumberland County court to go to Aroostook County, is in Aroostook County at the request of that court. And so similarly, child protective scheduling sort of works against criminal scheduling. So an attorney who's doing both has the potential to frustrate themselves and the court and the clients. And I don't mean the attorney's doing the frustrating. I mean, the situation is frustrating. And so it's absolutely the case that any specialist that is doing some specialized work frees up capacity in other parts of the system, and that without taking away from those people who are able and want to go to Aroostook County, for example, from say Kennebec County to do a case, they don't have to. It saves a lot of time, it saves a lot of money that we pay for travel and sometimes for lodging, and it begins to be a step toward alleviating one of the pressures that's causing an issue with, excuse me, resolution of cases where attorney availability may be part of the issue. So I see that as not just serving the function you suggest, and I agree it does, but actually all of those functions, everything starts to get a lot more efficient. All of it's dependent on the court agreeing to schedule it in a way that makes it work for these folks. But the court's been pretty invested in working with me to find solutions. I suspect that it will do that. I don't speak for it, but I'm hopeful and anticipate that sort of joint cooperation.
Thank you. Representative Babbage, go ahead.
Thank you very much, Madam Chair. Mr. Andrus, if I may continue with you just for a minute. Could you respond to part of the discussion that we've talked about? I'm interested as we hopefully go forward with implementation of a public defender's model. Can you talk out loud about geographic specificity versus an anchor with flexibility of assignment?
I'm happy to. There seem to be a lot of subjects there. If you want to prompt me in the direction you most want to hear about them, that would help me, or I can talk about it more generally.
Well, I'm thinking about I'm thinking about addressing need, but I also was wondering about excuse me, being part of a hybrid, what impact that might have on private attorneys participating in particular areas as well. I mean, there are consequences that I'm trying to, go through here, but the primary thing I'm looking for is if we had a Kennebec Somerset model that is specific to Kennebec Somerset, or if we had a model like that, but with some flexibility to go to Washington County if needed, or whatever. I want you to help me with that. Thank you.
So, a couple of pieces as I come into this. The first is, one of my first principles is never let the perfect be the enemy of the good. And I agree with those who have spoken up to say we have fundamental problems that need to be addressed systemically and at a very high level in terms of the structure, and I agree with that, while simultaneously focusing on these immediate term solutions. And then the next piece of that is that not only do I, in my role, and I hear from the commissioners today as well, support and honor the attorneys who do the work, but I also recognize that we absolutely need them. As I said earlier, there's no world where we can drive them away and function. And so looking at the effect on them as we move into this kind of a program, I think is really an important step. So I believe that there is enough work for anyone who wants to do indigent defense as assigned counsel to continue to do that in basically any location in the state, irrespective of the introduction of a public defender model, because I don't anticipate introduction of a public defender model at a scale in any given place to absorb all the work. And so I think that addresses most directly the question. There's been discussion about where to put the first brick and mortar. I have a preference, an operational preference, which is that the first brick and mortar, in fact, be in Kennebec County, because that's where I go to work. And we got new digs in December. We're in the old state auditor building across from the Capitol now, diagonally. And there's the other half of this building, it's two houses joined by a breezeway, is available. And so we could conceivably park that unit there. They have a home, they're integrated with us, communication is facile, appreciate Zooms, but where possible, I think it's more productive to be able to meet in person. And so from an administrability perspective, that is really good. And then that, in terms of where I would then send people, if I had included in that package some people to send, that vary day to day or month to month anyway, depending upon the changes. But I get calls from say Washington County or Aroostook County from the attorneys saying, goodness, I'm trying to do this work. I want to serve these people, but it's too much work. And I always tell them the same thing, which is their duties to their clients, my duties to the system, and that, you know, they are not responsible for saving the system. But I'm not hearing from them if some cases went somewhere else that they're going to struggle or that their business is going to be in trouble. And so that they're going to have to leave and do another model. There may be someone somewhere in the system, to be fair and honest, that this doesn't apply to. There may be someone who gets frozen out, but I really don't see it happening at any kind of systemic level. I'm not trivializing that person's experience, but I seems unlikely.
Thank you for that, Representative Harnett and Commissioner Cummins. Alluded to the chief public defender possibility. How would you see that working with your office?
So I think, at least conceptually, if not literally, the Maine Commission on Indigent Legal Services needs to be rebranded as the Office of Public Defense. And the payment agency that was created in 2010 to administer payment to attorneys is not the function that must be at the top of the food chain. Paying people needs to be subordinate to working to provide a functional indigent defense system across the board. So whether it's this office or whether this office becomes subordinate to somebody else, I'm agnostic about. Personally, I'd prefer the job of muckraker and chief public defender more than I'd enjoy the job of payment administrator. But it's not a power grab. It could go however. But I think that the executive function here needs to be recognized by statute as responsible and empowered to participate in the dialogue at the highest levels. And that includes some stuff, and I am talking from my perspective as executive director. We're beyond the scope of things I've discussed with the commission, okay? But that includes all sorts of stuff. That includes being brought in, as folks have said earlier, at the same level as the AG. Not the elected public defenders, by the way. Prosecutors, by the way. At the level of the AG for the purposes of this function. That includes statutory access to information, statutory access to meetings and decision making. It doesn't mean a superior vote, but it means an equal vote. It means there are a lot of things that need to happen there. I mean, and then we can get into the weeds, and I'll stay mostly out of them. But for example, MCILS cannot currently take litigation action to solve any of the problems that we face. So I've been asked by the media, why did MCILS never litigate the issue of the jail calls, for example? I don't have standing. And so really what there needs to be is an AG analog for the defense function.
Thank you. Thank you for that. And Madam Chair, I have just a comment to the committee as we have this work session. I think it's imperative that we as Judiciary Committee members be the flaggers to all that a constitutional obligation is still not being met. And so as we hopefully move forward to try to implement some sort of public defender administration, whether that be immediate or where we can at least administratively set up something with the funding that appears to be available at this point, or at least authorize a schedule of implementation. I think it's incumbent on us to be the champions of that cause. Thank you, Madam Chair.
Thank you. Committee members, our time this morning is drawing somewhat to a close, and I think that it would be really helpful for us if we could come up with a list of additional information that we feel we need from our analyst and or from the commission and potentially from other sources like the judicial branch. And then we reschedule in the very near future another follow-up discussion once we have that information so that we can really get into the nitty-gritty of what steps we want to take using the tools that are available to us, namely reporting out legislation. So can I just have committee members raise hands and articulate information that you believe we need? Senator Keim, you can go ahead.
Thank you. I really appreciate the interchange that just happened, because one of the conversations I was having with Justin after the meeting where the lawyers came and talked about the issues they were having. One of the things I've noticed for a while now is that MCILS doesn't have the political power, I think, that they need in the system to speak and to speak up for. So maybe actually renaming it is a great idea. So I would love to have more information on what that would look like to rename it, and whatever the other things mentioned, like other things statutorily that might be involved in that change. I would also like to have sort of an overview on what's available for lawyers if they were to be hired as public defenders or indigent legal services. And I think I would also like to hear more from Justin if he were to, part of the thing about having a public defender's office in Kennebec is that there's ready access to lawyers there already. So I would love to hear a little bit more from him around the idea of have him think about if he had sort of a hybrid model where the lawyers weren't necessarily expecting to stay in Kennebec County, but they were part of his system, but they were the lawyers that he would be sending out to the other counties where there's need. And also the idea he mentioned that I think he raised the idea of needing specialized attorneys or appellate public defender office being above the idea of the brick and mortar at Kennebec. So I think I'd just like to have him give us a tiered idea again of where he sees his greatest needs, so that we just have that in black and white. I think that would be helpful, because what I maybe heard him say isn't what I think I heard him say last time. That's about all my questions.
That is a great list. Thank you. Representative Moriarty, go ahead.
Thank you, Madam Chair.
Actually, Representative, before you, I just wanted to, Peggy, I know that you and I think have both been writing down these requests. Did you have anything you wanted to ask Senator Keim before we move on to Representative Moriarty?
Actually, yes, if you don't mind, Senator Keim, your second point, I'm not really sure what you're looking for. You said attorneys hired as public defenders. What information are you looking for about that?
So I think just the full scope of what would be available to them, whether it's federal tax breaks and just all that. And I know that we've considered other bills and that they have offerings available to them from the Maine School of Law. So just so we would have a really broad idea of everything that would attract attorneys to be serving either one in rural communities, or two, whether it would just be in some sort of public realm like that.
Okay, thank you.
Mm-hmm. Thank you,
Senator Carney.
Go ahead, Representative Moriarty.
Okay, thank you. Following up on Senator Keim's questions.
Steve, I think,
would, if the executive branch is amenable to that's only on a pilot basis. And also, I think it would be good to know the approximate fiscal impact in advance, as opposed to getting a cold shower at the end of a lot of work. Because if we're talking salary, health insurance, retirement benefits, and the whole 9 yards, even if it's a relatively modest pilot project, the cost will still be significant. And with that, what is the tolerance or willingness of the executive branch to accommodate those costs?
thank you. Committee members, other requests for information? Peggy, I had two other points that I was hoping you might be able to look into. And I know that the executive director of the commission is also looking into it, but what is the third option for where the financial screeners can be located in order to avoid that concern about conflict of interests? And then this is a very minor thing, but one of the aspects of the report spoke to the challenges for contract counsel regarding attending continuing legal education because they're not paid for their time attending the training. And is that something that we would be able to incorporate either currently or in the future into a strengthened system? Thank you. Committee members, any other requests for information? Well, if we will probably, or undoubtedly, as we're eating our lunch, think of other things. And we can, if you can email Peggy if you have any other questions, and please copy other committee members as well. Yeah, I guess at this point, it looks like we're getting close to the end of our presentation this morning. Peggy, is there anything else that you feel that we need to address before we wrap up today?
No, I think this is a great start to identify what you need to know, what you'd like to have in front of you at the next meeting. You do have authority to report out legislation, so it's good to put all the pieces together.
Thanks. Committee members, anybody else have any final thoughts before we adjourn take a recess for lunch? Okay, I'm not seeing any. Executive Director Andrus, if you are still on the panel, can you? That's great. We wanted to see you so that we could thank you in person virtually. Thank you very much for all of the information and also thanks to the commissioners for all of their contributions to the presentation this morning and for all your hard work.
Well, thank you for your interest and for your work, and we appreciate it. So thank you.
You're welcome. Committee members, feel free to speak out if you also would like to add anything. Okay, I think we're all set. So we'll take a recess and we're going to resume at 1 o'clock with some presentations by the Maine Human Rights Commission and the Right to Know Advisory Committee and the Public Access Ombudsman. So we'll have a full afternoon. Hope everybody enjoys their break, and please remember to deactivate your audio and video before you leave your computers.
Okay.
Thank you, everyone.
Thanks. See you later.
We also have a work session at 2:30.
Yeah, thank you for the reminder. Thank you.
Just in case people are listening out there, you're still, as far as I know, you're still planning it.
Yes, we have a work session at 2:30 on 1918. Thank you, everyone.
Welcome. Actually, Madam Chair, it's on.
Yeah, I'm still here.
There you are. It's on 1529.
Oh, okay.
Representative O'Neill's bill.
Thank you. My eyes were straining to look at something that was far away from where I was sitting.
I totally get it. When you screen share, it goes to 8 font and I can't read anything. So have a good lunch, everybody.
Thank you.
Hi, Peggy. I told Ann I will be leaving to present a bill in another committee at 1:15
Okay.
because I thought it was going to happen a long time ago, but life doesn't always work out. So I will be gone for a bit, and she might have to switch up Brenda and my presentations.
Okay.
Okay. Thanks. So I'll
Okay.
leave
Yep.
at 1:13. They promised me they start on time. We'll see.
Great. Okay. Thanks.
How are you doing? You all right?
Good. Yeah, we're okay. The heat's on over here, so that's good.
Yeah.
Are we live streaming right now?
Yes, we are, Lois.
Okay. I'll send Ann Carney a note about why it is I have to disappear for a half hour at 2 o'clock. I mean, I'm gonna have to switch to my iPad from my computer for a half an hour, so I'll still be on the meeting, but I just have to go elsewhere in the house, so.
Lois, I just heard you say that. That's fine. Thank you for letting me know.
Yeah. It's a job interview going on in the next room at
Okay.
that point, so. But it reminded me that I gotta find my iPad, which I knew where it was a minute ago.
So Peggy, thank you for sending around the language reviews for us to do this afternoon.
Oh, happy to do it.
I'm adding it to the 100 stickies on my desktop so that I may overlook it, but I won't forget it.
Okay. Great. So Senator Carney, Representative Harnett told you that if he's still in this other committee. Okay, I'm just contacting Brenda Kelty, the Public Access Ombudsman, to see if she will be available early.
Thank you.
Thanks.
You're welcome.
It's 1 o'clock, but I think some committee members are still returning from our lunch recess. So to all of those who are listening and waiting for us to begin, we'll begin shortly. Thank you. Thank you, committee members, for activating your video. I think we're just about ready to begin, and I am going to bring onto the panel the Executive Director of the Maine Human Rights Commission, and then we'll get started. And while she is joining us, just to review this afternoon's plan, we are going to begin with the Human Rights Commission Government Evaluation Act report. That will take us to 1:30. And then we'll have presentations related to Maine's right to know law. And we're going to probably start in reverse order with the Public Access Ombudsman annual report, and then turn to the Right to Know Advisory Committee annual report and recommendations, because Representative Harnett, who co-chairs this committee, will be reviewing the Right to Know Advisory Committee report, and he has to be in another committee meeting for a little while. Representative Evangelos, did you wish to be recognized?
There goes my phone, sorry. Ledge Council's at 1:30 and I have to go for a while. I just want to let you know.
Thank you for letting us know. And then we will do the a work session on the constitutional amendment related to a right to privacy. That's LD 1529. And then we have 2 language reviews on bills that the committee has already voted on, LD 344 and LD 1774. So that is our work for this afternoon. And at this point, we'll begin the Human Rights Commission Government Evaluation Act report presentation. We have here today Amy Sneerson, who is the Executive Director of the Maine Human Rights Commission. And Director Sneerson, you can begin whenever you're ready.
Thank you. Good afternoon, Senator Carney, Representative Harnett, and members of the Joint Standing Committee on the Judiciary, and Ms. Reinsch. It's lovely to see you as well. Thank you for inviting the Maine Human Rights Commission to go over our government evaluation program evaluation pursuant to the State Government Evaluation Act. We submitted our report in November, and I'm going to walk through it briefly. It sounds like you've got a packed afternoon, and we did submit a fair amount of documents with our report. So I'll just walk through it, and please let me know if I'm talking too fast or if you have any questions along the way. The first item in the program evaluation report is our enabling or authorizing law or other relevant mandates. Tab A, or rather item A, starts at page 1 and includes the existing Maine Human Rights Act along with copies of 2 bills that had been enacted and were effective at the time we submitted our report, but the revisor's office had not published the incorporation. So together, those 2 documents and the Maine Human Rights Act represent what was, as of November 1st, our enacting or enabling law. The next item is the description of each program administered by the agency, including our priorities, performance measures, and assessment as to how we're doing on those. If you look at page 66, that is part B, and we identified our established priorities as providing administrative forum for determining if unlawful discrimination occurred, providing an opportunity to resolve disputes about discrimination and retaliation, and providing redress after a finding that there may be cause to believe unlawful discrimination occurred, and providing information to people of Maine about what is and is not unlawful discrimination or retaliation. Our assessment of the extent to which we're meeting priorities, I included data from our annual reports for the last several years indicating that the number of complaints do continue to go up. The number of complaints resolved voluntarily, which I'll talk about later on, is worth noting that it hovers around 46 to 47 or 49%, which is also, I mean, that reflects to us success on one of our mandates to help the parties resolve disputes. Outreach each year, we're doing between 53 and 58 or more outreach opportunities or educational opportunities. So that tells us that we are sharing information with the public. I will say our pending inventory, we were doing really well in cutting our inventory. And then when COVID happened, our inventory, we got more complaints and resolved fewer of them because it's just harder right now. And so our pending inventory has gone up. So we do believe that we are meeting each of our priorities, and our explanation for why we think that is provided on pages 67 and 68. The next item is organizational structure, and that is on page 70. We've provided an organizational chart indicating the lines of supervision and source of funding for each position that we have currently. The next item, item E, is a financial summary, including our sources of funding and amounts allocated and appropriated over the past 10 years. That is provided in the chart, our 10-year history provided on page, I think it must be 72. It doesn't have a number, but I think it's page 72.
Yeah, in the materials that we received, it is numbered 70.
Yes. Oh, you're right. It's just in a different place. Thank you. Item G is identification of areas where we have coordinated our efforts with other state and federal agencies to achieve program objectives. That includes, but is not limited to, cooperative arrangements. We actually have several. We have 2 long-standing partnership agreements with federal agencies to work together to enforce anti-discrimination laws, one in employment and one in housing. So we have partnership agreements with HUD and EEOC. We also have longstanding agreements with the United States Department of Justice related to disability discrimination and immigration issues. And on page 76, we went through agreements and work sharing that we do with several state agencies as well. Item H is identification of constituencies that our agency or program serves, including any changes or projected changes. And I'll tell you, there are a lot of days where it seems like we serve every constituency. And so I've listed every one that I can possibly think of. And in terms of new constituencies, there's a chart on page 79 that indicates several areas that were added as of November of 2021, or October rather. Victims of domestic violence who have obtained a permanent order of protection, that's a new protected class in the Maine Human Rights Act for employment and housing. So that is a new constituency, and age is now covered in public accommodations. That is a new constituency. And familial status is a new protected class in employment. And the definition of familial status has been broadened in housing to include dependent adults. Item I is a summary of efforts by our agency to use alternative delivery systems to meet our goals. And I've gone through on pages 81 and 82, sort of some key areas where we have tried to use alternative delivery methods. One is in mediation, having a formal program to help parties resolve disputes. And the version that we are using now seems to be quite successful. And in fact, we keep running out of money in our allotment to pay our mediators because we do so many of them, even though we've increased that allotment several times over the years. We also, pursuant to our work sharing agreement with HUD, they occasionally make partnership funds available. And we have, to date, I can think of only one instance in the 10 years that I've been here that we have not applied for and gotten partnership funding through HUD to accomplish some great projects that we couldn't do otherwise. And our electronic data management portal system is really worth mentioning because that was new funding to us several years ago. And for a relatively minor sum, we have created a really fantastic internal system. The goal was to create it internally and then to create a portal for the public with the goal, and we'll talk later on about decreasing paperwork and improving customer service. And the intent of this has been to make electronic filing and documents available to the public to decrease the public's frustration with our process. And COVID got in the way of that. We are still hoping to start work on that piece of it very shortly. Item J, identification of emerging issues. If you look at page 84, we have identified several key emerging issues. The first is exemptions from objections to public health mandates. Our agency seems to be, other than court, where a lot of issues about exceptions or reasonable accommodations to vaccine mandates or mask mandates. We have quite a few of those intakes, complaints, cases, and they are at various stages in our process, but it's going to be an issue for several years to come. What is a place of public accommodation? Traditionally, the definition meant a physical place, but that has developed over years to be understood in most places to be services delivered by a company, including things via the internet. In fact, we are involved in ongoing litigation with Uber, which defended itself, saying we're not a public accommodation. So that's an issue that will be going on for years to come. And I will skip over the third one to just mention the applicability of the Maine Whistleblowers Protection Act in unionized workplaces. We actually have a bill that will be at public hearing in the Labor and Housing Committee next week, LD 1889, which seeks to address a recent Maine law court ruling about whether the Whistleblowers Protection Act can be a remedy for employees in unionized workplaces due to federal preemption issues. Item K is other information specifically requested by judiciary, and we are not aware of any. Item L, a comparison of related federal laws and regulations to the Maine Human Rights Act, Maine Whistleblower Protection Act, and other regulations and statutes that we enforce. And we've tried to, there aren't always precise comparators, but we've tried to go through here and provide what we can towards that. Item M is agency policies for collecting, managing, and using personal information over the internet and information technology, and our adherence to the fair information practice principles of notice, choice, access, integrity, and enforcement. And these are actually things that are incredibly important to us. Number one, though we are indeed subject to FOIA and constantly get requests for documents, we're an agency that collects a lot of tremendously personal information about people, their religion, their medical history, their diagnoses, their social security numbers, and we are very serious about keeping that information private. The Maine Human Rights Act itself mandates that third parties can't be identified, and so every single FOIA request that we get requires, and I think I described this a bit, an extensive process of reviewing every word and every line and every page of the document. I was just redacting a 1,000-page document the other day to make sure no protected information is inadvertently revealed. In terms of notice, we take that extremely seriously too. If we become aware at the last moment of a hearing that there was not proper notice and an opportunity to respond, we will pull a case back, we will table it, we will start over again if we have to. And unfortunately, those things do occasionally happen, but we do take notice and due process very, very seriously. Item N is a list of reports and other paperwork that our agency requires the public to file, and the statutory obligation mandates for those. And we do, when we serve notice of a complaint, usually accompany that with a request for information to the respondent that seeks answers to the complaint and also some questions, and it seeks documents as well. The commission does have the power to subpoena documents. We rarely need to invoke that. Other than that, we are working to reduce filing requirements and paperwork duplication. We now do most of our, even before COVID, we did our hearing preparation entirely electronically. And at this point, because of the combination of COVID and our new electronic data management system, which we were starting to create even before COVID, we estimate that about 90% of our agency work does happen via electronic means at this point. Item O is a list of reports that the legislature requires our agency to prepare or submit. Assuming that you're talking about specific reports and not just annual reports to the Office of the Governor, and financial reports. The only other report that we're aware of, as noted on page 102, is a report required by 5 MRS 12023 regarding quasi-independent agency procurements, contributions, and policies. Item P, which is on page 104, asks about organizational units and programs. These are informal organizations, but we've tried to explain sort of how we organize our work. I'm not sure if that is what the report was seeking, but that is what we have explained on page 104. And item Q was identification of provisions in our enabling statutes that may require legislative review to determine the necessity of amendment to align us with federal or state law. And we're not aware of any other than what we've already identified. So I am sorry if that was unnecessarily quick, but I know I have a half an hour and I wanted to leave time for any questions if you had any. Thank you.
Thank you very much. Representative Evangelos, go ahead with your question.
Thank you very much. Thank you very much, Madam Chair. Hello, Ms. Nearson. In those cases regarding FOIA you mentioned, is there any kind of lawyer-client relationship privilege that would help?
We do. There are some documents that are shielded by attorney-client privilege if our in-house counsel is providing advice to me or our commissioners or to our investigators. But other than that, most documents are defined under the Maine Human Rights Act as part of a case file subject to FOIA, if they're not otherwise made confidential.
And I just wanted to compliment you. This is an incredible body of work you've produced for us today, over 200 pages. And listening to you today reminds me of Aldous Huxley's Brave New World. I mean, look at the changes you are undergoing, like in a 2-year period. It's
Who would have ever thought it?
really.
Oh, thank you. I think most state agencies are building the plane as we're flying it.
Yeah, well, I'll read everything. Thank you.
Thank you very much.
Thank you for the question, Representative. I had two completely unrelated questions, but one of them actually related to what you just mentioned regarding accommodating changes related to the pandemic. It looks like, based on your stats, that you actually increased the number of outreach events during 2020. And I wanted to commend you on that and ask if there was anything you wanted to add to that to give us a broader idea of what occurred.
Thank you for the question. I do think that's accurate. I think in 2020, like a lot of other organizations, all of us were a bit stunned and waiting for the pandemic to be over and just canceled outreach events. And by the time 2021 came around, we all were adapting and determining that we needed to go on. We had a number of HUD grants that required outreach. And so we adapted and we delivered them for the most part electronically. It's not perfect, but it is better than nothing.
And how did you find the attendance relative to when you do an in-person event?
That's a great question. In the limited experience that I have, it depends what type of outreach you're doing. When we did outreach to organizations that had a built-in constituency or an employer that was seeking information, attendance was very good because people were required to be there. If we were doing outreach to about a general topic and hoping for participation, it was generally lower.
Thank you.
Thanks.
And then one other question on, as you were going through Part J, emerging issues.
Yes.
You referred to gender identity discrimination as being a point that you would come back to. And I wasn't sure if you had fully covered that and wanted to know if you could just address it a little bit more, please.
Thank you. I'm sorry I did not go back to it. The item on page 85 refers to gender identity discrimination being an emerging issue, in that it has never gone away as an issue that we are continually needing, despite the fact that the statute has been changed to include that as a protected class since 2005. it remains a flashpoint. And because we have never been able to promulgate regulations in education related to gender identity, it's in this as an emerging issue because we are preparing regulations. So we will be promulgating those.
Can you give us a little bit of an idea of your time frame and also whether the regulations will relate just to this specific area, or are you doing regulations related to a kind of a broader range of issues? We don't need the details about the regulations because we can look those up, but
yeah, that's a great question. The timeline was supposed to be, we were going to be sending them out in February, but our commission council now has COVID. So we are probably delayed a bit, but she has a huge task because they are going to be omnibus regulatory changes, not limited to just one topic. So she's been going piece by piece, and we've presented our commissioners with some of the subject areas, but we are still working on, I believe, education is among the most challenging areas that we have left because it's so delicate. And there's so much to do because the statute hadn't been amended in so long. Religion wasn't part of the education part of the statute. Ancestry wasn't part of it. I think there were still things like marital status in part of the education regulations. So it's a lot of updates. So when you'll be seeing those, hopefully in the next few months, we will be presenting all of them to our commissioners and having public hearings.
thank you. And thank you for all your careful work on the updates to your regulations. So I jumped in and monopolized the questions. Committee members, are there any other questions for Executive Director Sneerson? I am not seeing any. And as you were presenting your report, I was tracking the GEA report content requirements that are statutorily required. Peggy, did you want to speak to this or should I just keep going?
Sounds like you're on a roll. Keep going. But
Okay.
if you want me to talk, I can.
Okay. I was tracking, and it seems like you have really thoroughly covered everything that is required under the statute that requires you to do this review. And I think, as Representative Evangelos mentioned, you did a really thorough job and provided us with a lot of really important and helpful information that reflects all of the hard work that the commission does. And I want to extend a thanks to you on behalf of all of the committee members.
Thank you very much. And thank you for all that all of you are doing and are going to do as soon as you hang up from me.
You're welcome. And with that, I think we have concluded the review. And so we'll close this portion of our meeting today. And in a moment, we will start with the right to know public access ombudsman. I'm probably getting some words wrong there, but thank you once again, Executive Director Sneerson, for being with us today.
Thank you so much for your time.
Okay, committee members, thank you. And thanks for all your focus on the Human Rights Commission's work. We have a couple of minutes before the ombudsman will be here. That word is a real tongue twister. And I need to just get a glass of water, actually. So I'm going to go do that, and we'll start up again in just one moment. Thank you. My tongue was getting tied up because I was so thirsty. I also practiced saying ombudsman during that brief break. And at this point, I'm going to bring Brenda Kelty, who is the ombudsman, over to our panel. Hello, Brenda Kelty. Thanks for agreeing to take the earlier spot in this afternoon's presentation.
Not a problem. Thank you, Senator Carney, members of the committee. So nice to see you all. I'm going to be presenting today on the 2021 annual data that I collect as ombudsman that includes numbers having to do with inquiries and complaints to my office, and also FOA activity for the 14 executive branch state agencies. So I'll be working my way through, and I think Peggy sent out an electronic copy of the report. I apologize for the lateness of it. Some of the state agencies have been dealing with personnel changes and a few other challenges, and their numbers were very late coming. And in fact, we are missing the data from one agency. But as soon as I do get that, I'll update the report.
Thank you.
You're welcome. I think the most interesting aspect of the data from my office this year was the significant increase in contacts that I had. I've had a fairly level number between 400 and 500 per year. And this year, it was 584. So it's really a significant spike. And remember, these are contacts from either agency representatives or elected officials or members of the public. And so, of course, I'm wondering why such a significant increase in this particular year. And I have some theories, but I can't really connect a cause and effect. But I would say that the environment around government and the public's interaction with government, I think, was different this year with the combination of the COVID conditions, with sort of ideological differences and divisiveness, and maybe a increased lack of trust in government. I'm not really sure, but I do think it was more of an environmental situation. And because there wasn't necessarily any particular group that stands out as accounting for that large increase alone, it was kind of across the board. So that's my theory. And let's look at some of the numbers and see if anything stands out to you that you think accounts for it. But it was a significant increase. The method of contact, again, I was primarily remote, as most state employees. So I have been utilizing email and directing my phone calls into my email and using that primarily. I don't necessarily like that better. I really like to talk to people on the phone, but I don't have a work phone. I don't have a work cell phone. So I did use email, and that was, the bulk of my contact was email. In terms of the contact categories, I still see similar percentages to the past. In other words, most of the contacts that I have are inquiries, questions about how the law works. How do I use this law to try to get what I want? How do we as an agency implement this law so that we're in compliance? So mostly inquiries, but again, I had 76 situations where there was a a real dispute between parties, and there needed to be some facilitation or some sort of way to resolve that dispute. And so those fell into the complaint categories. And then again, I also welcome suggestions from the public about questions. And I got several of those and redirected to the Right to Know Advisory Committee, which is just a wonderful format, a venue for sort of fleshing out emerging questions or things that we want to talk about in a broad way. So those were similar percentages to what I've seen in the past. In terms of the kinds of questions related to public records, I think the largest increase I saw there had to do with fees and costs. And we had questions about the application of the waiver provision, but we had a lot of questions because, of course, the law was amended to increase the hourly fee effective with the October effective date, and changes to the per page fee. So that, as would be expected, that generated questions. And I did see more related to that. But again, in the other areas having to do with public records, I still see sort of a consistency from year to year in the kinds of questions that we have. So the application of the statute into real life sort of predictably raises certain kinds of questions. And this year was not any different from others. For instance, a very, very common question I get is a person will have received a denial or a redaction or something's held back from the response, and they don't understand why or what they should do, what they can do, what their options are at that point. And so a lot of times the service that I'm offering to people is really to help them understand what the law is and understand that, when there's a reference to a statute or something is confidential according to attorney-client privilege, what exactly does that mean? Because if you're not a lawyer, you might not know. So I still get a very, very large number of questions related to that kind of thing. But fees and costs were definitely came up a lot this year. And then in terms of the contacts that concerned the public meeting side of the law, as we would expect, remote participation really accounted for a lot of those questions. And again, because we had an amendment to the statute, and anytime that you're introducing new language, there's always room for the places where there's room for interpretation. A lot of another area was, how do we as an agency draft a good remote participation policy? What's a good policy? What should we be thinking about? So I did a lot of work on that side once that law was passed to help implement it. And so that was, again, the other questions around public meetings, again, are sort of characteristic in what you would expect. Questions about executive session or lots of questions about agendas, which of course the statute doesn't address. It says nothing about agendas. But that is a question I get quite a bit. Public comment during meetings, that's another common question. So the remote participation was a big chunk of it in 2021. The next data point that I track is the source of the inquiries and complaints. In other words, who is it that is contacting me with a question? And this year was similar to past years in that private citizen category is the largest number. And I think that in this, again, we're meeting the intent of the ombudsman position by offering to the public a resource to help guide them through how to work with this law. Lots and lots of private citizens. And that was the largest increase I saw this year. So that also relates to the question of why this significant increase in contacts. a very large percentage of that was private citizens wanting to understand how to work with FOA. The other area that I saw the most increase in were state agency contacts. So here we had agencies calling the ombudsman's office to try to get assistance with how do we process FOA requests? How do we handle the denial? You know, how do we handle the fees? How do we have a good process, compliant process in place? And then the other area where I saw the most increase, in fact, this number doubled from 2020, was members of the media contacting me with questions. So that was also interesting to me because there's always a high level of media FOA activity. And in this case, that activity on my end doubled. So I think that also has something to do with the large overall increase. But the other areas, law enforcement, the legislature, municipalities, school districts, executive branch, and other entities remained fairly constant. So then the next data point is the focus of the inquiries and complaints. In other words, when someone contacts me, what is it that they're talking about? Are they talking about a state agency that they're dealing with? Are they talking about a municipality? And in this case, I did see two large increases in this category. In the municipal category, the numbers increased from 67 last year to 124 this year. So there's almost a doubling of situations where the person who was contacting me had questions about what a municipality was doing in terms of FOA. So that doubled, almost doubled. And then the other area that saw a very large increase was county, on the county level. So in 2020, I had 7 contacts that related to county government. And in 2021, I had 25 that related to county government. So again, I think that many of those contacts had to do with remote meeting policies and procedures and dealing with how the meetings were taking place. But those were 2 areas that I saw increases in. The other categories were not significant changes in terms of percentages. But that municipal and county area was definitely a big increase. And then in terms of outcomes, we track whether the questions were answered, whether my role was more in terms of facilitating resolution of a dispute, and whether the inquiry had to be declined or because it was unsubstantiated. In other words, sometimes I'll have to ask for more information in order to move forward. And if I don't get that information, I categorize it as unsubstantiated. I just don't have enough to do anything with it. And in this case, 499 were queries answered. So a lot of questions answered. And I facilitated 62 situations. So that would have involved quite a bit of interaction with the parties and work with trying to bring people together to come to a resolution. Oftentimes that involved asking an agency to improve their process and noting that something that they were doing that's not compliant, and this is what you should do in order to be implementing this statute in a compliant way. So, mostly queries, mostly questions, lots of questions. You never know every day what the question is going to be. And then in terms of outreach and training, I do outreach and training on all levels of government, and this year was the same, although almost everything I did was remote this year. And there was more demand this year for one-on-one training. So I would get a person who just became a public access officer, either on the state or municipal level, asking me to sit down with them for an hour and a half and just really help them put a process in place. So there was a lot more of that this year. And then something new this year that I'm pretty excited about and honored about was that I was appointed to the Archives Advisory Board as the Attorney General designee. And so the Archives Advisory Board has been newly reconstituted and acts in an advisory capacity to the archivist to help with records management, record schedules, and questions around, for instance, what kinds of records are going to have historical value and ought to be kept forever, and how is that going to happen? So the Archives Advisory Board is very interesting too. I deal with government records all the time, but I don't often deal with the historical records. And it's just so interesting. We have such a wealth of historical records in the state of Maine. And so it's great to be on this board with historians and others who really see the long-term view, because they like to be looking back 100 years and looking at the records from 100 years ago. And so it really helps you to understand the value of the documentation that we're creating today for the future. We don't often think of that. We're just thinking, what do I do with my email? But these folks really are thinking, how are we going to preserve this? What do we need to preserve for how long in order to make sure that the people down the road in Maine who want to understand, what were the challenges facing us? What were our accomplishments? What were our aspirations? That our records can show that to them. So this is a really great board. But, as I think I've said this before, that the Freedom of Access Act provides a very important right to access public records. But if those records are not maintained well, then that right becomes fairly meaningless. If the records have been lost or they've been unlawfully destroyed, they haven't been, you can't find them. All of those are barriers to accessing. So I'm very much interested in ensuring that we've got modern record systems that are allowing destruction that's appropriate, but maintaining in a way that is available to everyone. And of course, we have so many challenging now platforms. We have social media, we have all kinds of other things happening. And so there's a lot of work being done on that archive side to try to understand how best to manage those records. And this is all very important from FOLA's point of view. So I'm involved with that as well. Now, in terms of the state agency FOA reporting, there's a chart in my report with the different data points that they are giving to me. And we have found in the past that there are certain aspects of this data that are extremely helpful in understanding not only the volume and the kind of level of FOA activity that's happening, at least for these 14 executive branch state agencies, but also how quickly are they responding? Because what we tend to hear about, and we should hear about, are the situations where the response is taking too long and there's delay and the requester is not getting what they need and there's not good reasons for it.
Okay,
and we hear about those. But what we tend to not hear about is where the agency is producing and producing quickly, because it's not, they're doing, what we would want them to do. But this data does help to illuminate a little bit those numbers. So again, I have one agency that hasn't reported out to me yet. And so there may be some small alterations to the totals here. But for 2021, the 14 executive of the 13 that reported had a total of 3,060 FOA requests. And also remember to put in context that we're only talking about requests that are handled in the FOA process. That doesn't reflect the number of requests for information in the ordinary course of business, because agencies, this is a core function for them. And so there's lots and lots and lots of requests for information that never involve FOA. And this is just the segment where the agency responded pursuant to FOA. And so that 3,060 number is an increase from 2020 of 408. So those executive branch state agencies also saw an increase in FOA activity, just like I saw an increase on my end. And the response times, we measure out the initial response time in 0 to 5 days. That means that they produced the records that were requested in 0 to 5 days. And here, 46.73% of the time, the records are produced in 0 to 5 days. So almost half are in a very, very short time frame. And that was very similar to 2020. That was 48.19%. It's a little bit lower, but a similar number. So that number I always like to look at, because we want to be sure that the requests that are not difficult, don't involve complex confidentiality questions, records that are readily available. We want those to move really fast and get that out as quickly as possible. So some, good percentage that is happening. At the other end of the response time frame, we have the requests that are greater than 60 days, greater than 6 months, greater than a year. This means that it's taking that long to produce the responsive records and close the request. Now, sometimes there can be rolling productions, which means that the requester may have received a partial production. But if the request is open, the agencies have to show that it's still, it's still there, it's still open, or it's taken over a year to produce. And here, the total we have are 233 that fall into that category of those 3 types, which is 7.61% of the total. And that's actually a lower percentage than 2020. In 2020, it was 15.65%. So again, it's really good to realize that according to this data, 46.73% is being produced in 0 to 5 days, and 7.61% are those outliers that are taking longer. Now, there's only one other thing that's complicates that data, is that we do have a category for pending requests, which means that at the time that the agency gave me this data, those requests had not been filled, and they were ongoing. So they may have just got them in December. They may be fairly new. And we have a significant number in that pending category. So I don't know. What I don't know is how long those have been pending. So if those have only been pending since December, it wouldn't be a significant impact on these numbers. But if those had been pending for a full year, then I would want to know that. But I don't usually ask that question. We'd have to, further break down the data, and I don't have that information. So I'm just leaving that as a caveat, that I don't know how long those have been pending. But even setting that aside, we're seeing fairly consistent, fairly high number of percentage requests being responded to, being produced early on. And the question is, what is it that makes these longer ones take so long? And why? And so I do invite the agencies to provide explanation or any information that they think is helpful in explaining their numbers. So the next 2 pages following that chart are some of the agencies offered some discussion of, what their numbers were all about. And so I would encourage you to take a look at that if you have questions about a specific agency. But if you asked me, do we have a problem with state agency FOA requests taking too long? I would say if there's a single one that takes too long, we have a problem. It doesn't really, you know what I mean? Because every single one is very important. And just saying, well, the numbers aren't that high sort of hides the fact that the statute, you know, is looking for a prompt response, because in most situations, the request for information needs to be timely. It's time sensitive. It matters now, usually, to people who are asking for something. And things that take a year to respond to, that's problematic. So I think I've said in the past, I didn't put it in my recommendations this year, but I do see a couple of issues that until these get addressed sufficiently, I do think we will continue to have numbers in that category over 6 months that we don't want to see. The first thing is technological support for the agencies. We do have some OIT support now for electronic record searching. That is very, very helpful, but it's not enough in my mind. I think that I think as the records become more complex and the management systems for records become more complex, we are going to have more technology to deal with it. And in the area that I see this the most going into 2022 is social media. How are we going to deal with that? And I know also that Archives is working on a project right now, a pilot project to sort of test out what platforms are out there and what is it that would sufficiently provide the records management and the production aspect for agencies to be able to handle social media. That's one thing. And then the second thing is that, you know, most agencies don't dedicate human resources specifically to FOA. So the public access officer who's handling the FOA also has another job, and we're asking them to do this on top of everything else they do. Or, you know, it's just not typical that there is a person whose job is to do FOA in an agency. So there are always going to be time constraints, and that's going to be reflected in the length of time it takes to respond. So those two things, those two elements, I think, do impact the ability to move more of those numbers up into the 0 to 5 slot, which is where we'd like to see them. So that is the agency data. And then in terms of recommendations, I kept it really simple this year because we did so much last year. I'm so grateful that the legislature was willing to look at the remote participation and really, really thoughtfully craft an amendment to the statute that would allow us to move forward in a really, reasoned way to incorporate this remote technology into this environment in which we've been primarily in person. And there was strong sentiment that there's a value to face-to-face communication and the public being able to see their elected officials face-to-face. And so we moved into this, remote environment, and it's been an enormous amount of work for agencies to do that, and with lots of great success. But one area that I did see a problem was that we have agencies that or boards and committees that have been created since the statute changed, since the state of emergency, right? So they're new. You have a new board and they don't have a remote policy. And under the statute, they have to meet in person to adopt a remote policy to meet remotely. And the problem we've seen is that we've had an ongoing COVID situation where a lot of entities do not want to meet in person. So who would have thought that it would go on this long and we'd continue to have, something that we could categorize as potentially an emergency. It's not a official state of emergency declared by the governor, but there are plenty of new boards or committees that have been hesitant to meet in person and they don't have a policy. So what do? So my advice has been, under this statute, you have to meet in person. And in order to adopt your policy, to then go into remote meetings. So that has been a problem. And the Right to Know Advisory Committee, which will speak to this more specifically next, worked on that question. There's some proposed language for the statute. I thank Peggy very, very much for her work on that, to try to make it possible for the chair of a board or committee that doesn't yet have a policy to declare that there is a sufficient emergency to convene remotely, and then have the members of that committee vote on first on whether they agree that the conditions are sufficient to call the meeting remotely. And then if that's a yay, then second, to deliberate, have public comment, and vote on a policy for remote participation. So this way, a new board or committee could put a remote policy in place without having to have met in person. And if their members, if the membership doesn't agree that the conditions allow for it, then they won't be able to adopt a policy, because it has to be done in person. Because they won't be able to get through that, over that threshold of agreeing that there's an emergency condition that allows them to meet remotely to pass the policy. So it has been a problem. And so I hope that there's some language there that might be a way to solve that problem. And then the last thing I would say in terms of the remote participation provision, there are boards and committees out there who do not want to meet remotely. And they think that there's a real value in being in person. Their public wants them to be in person. Their public, wants to attend in person. And the way the statute was written, I think, reflects the local control sort of idea that we have in Maine, that you can decide locally for your community and your constituency what's going to work best for you. So we've had very big differences of opinion out there about whether or not there should be a remote policy and whether or not to invoke it. Lots of different things. I've seen boards meeting fully remotely. I've seen hybrid meetings. I've seen meetings in person. All kinds of things are happening out there. And I think that's the way the statute was written, the amendment was written, that was the idea. If there is a change to that remote 403B provision, I would just want to be sure to consider that, like, there's a lot of good feedback about the level of participation that's increased due to having remote participation from the public. But there's also input that that some of that has not been really have the same quality, or that there's some element that's lost, maybe a little bit more intangible. And that there are some communities that want to be able to meet in person. They want to be able to see the people that they've elected. And I think just that quality of the interaction, or the loss of connection, or a potential loss of understanding, ought to be considered, even on the other hand, while there's great benefits to electronic communication and the remote meeting aspects. So I do think that the amendment to the statute that we have in place for remote participation really balanced those different needs very well. And I think it's worked pretty well from what I've seen. I know that there's some who think that it should be looser. We should be able to meet remotely no matter what. But I wonder if that does take into account that constituency that sees the value in direct communication, or those pockets of communities that still want to be in person and would feel like they have lost something if everything went remote. So that's just something to think about. I know that the Right to Know Committee will bring the specific language forward for that amendment to deal with that one situation that I've talked about. But I think that's it for me, and I'm happy to take any questions that you might have.
Thank you so much for that thorough review of your report and for compiling all of that information. It's really interesting to see this perspective on the right to know laws. And I see that we do have a couple of committee questions. Representative Babbage, you can go first.
Thank you very much, Madam Chair. I have three. Hopefully, I won't take much elaboration on the part of Ms. Kelty. Ms. Kelty, thanks for being in front of us again. Always good to hear this report. My first question has to do with the, as you know, when we pass a statute, the often rulemaking takes place, and that's where, you know, the pavement hits the road, or what I'm not sure what the expression is. I want to know, but I would like to ask if you could share with us implementation guidelines for remote that you have communicated with municipalities.
Well, first of all, I incorporated some new frequently asked questions onto the website related to remote participation. So we had information up online during the state of emergency and during that initial phase. And then once the statute was amended, put some new information up on that. So that is a primary source for answering some of the questions that were out there. And then in terms of for the municipalities, I did not give municipalities, for instance, a template policy, because there's just so many ways to write that policy that I didn't feel like it was really possible. All you would really do is just sort of repeat the law. So my advice is generally, like, you know, in emails or one-on-one consultations. So I don't necessarily have a model policy written up. I think that's what you're asking for. And I don't necessarily have that.
I guess I'm looking for a little bit of consistency as to responsibility. I mean, the Constitution, what is it, Article 115, Section 15, does talk about the right to assemble, the right to give instructions to your representatives, and the right to request redress. You know, and those don't change whether it's Portland or Stonington. The implementation may vary because we've allowed that within the law, but I know Portland. We on this committee have discussed this for a long time. And the tide was against remote participation for a long time. And I was a voice in the minority at that time, trying to see where remote could be used practically.
Right.
With COVID, the tide has completely changed.
Right.
And now I find my voice saying, we still have constitutional responsibilities to respect with the application of remote. And so I'm very interested in, the applications for people that find remote very efficient and convenient, but are, as would be expected, some representative groups would rather not meet. And what responsibility would they have? There's no longer a civil emergency. So we've put it in the hands of the municipalities to have a process whereby they're responsible for doing what decisions they're going to make be done publicly and with some public input, hopefully. So I'm interested in that. I'll look at those questions. I appreciate that. Secondly, I don't think in the report you included the agency that's not included in the data. Can you share that with us? Which one is not?
Yeah, it shows as a blank in the chart. It's the Department of Economic and Community Development.
Okay.
And the reason is, yeah, they just had a change of personnel.
Right.
And so they, sometimes that handoff does not go entirely smoothly, and they just didn't have the data ready for me.
And
they are going to provide that as soon as it's ready.
And past submissions by them would change the data by what percent, do you think?
Not by much. They've had, in the past, they've had very few actual FOA requests, and even in 2020, it was very few. So it would be surprising if it was large.
Yeah. My last question is, congratulations, we've hit, I've been serving for a long time, but when the Ombudsman's office was created was when I happened to be out of the legislature. But you're celebrating a decade this year.
Yeah.
My question really goes to the fact that you obviously do good. But is it, there's data collection, there's education, and there's encouragement to do better. Could you explain to me what the stick is for accountability?
Well, the role of the ombudsman is not the stick. And I don't think it was ever designed to be the stick. This is intended to put resources toward the front of the process to try to prevent problems. So the stick is an aggrieved party can bring you to court if they're unhappy with how you handled FOA. That's really, legislatively, that's the way it's designed. So what I'm doing is up at the front end, long before we get to the point where parties are entirely adversarial, lawyers are involved, and it really needs the structure and formality of the judicial system in order to untangle it. This is really way up in the front. Can we avoid some of that with good training? Can we avoid some of that if an agency is still at the point where they're willing to hear, look, you need to do this better. This is not okay. Here's a better process. Because many times what I see is people just don't, they're just not aware, or they're a little bit in over their head, and all of a sudden, the thing snowballs, and now you're really in trouble. You really haven't handled this correctly. And a lot of times, in my experience, if you establish the right kind of relationship, if you are working in a positive way toward a resolution, which means not, you're not accountable for this. That's not what it means. The resolution is that was not done right. And this is what needs to happen in order to improve, in order for that to not happen again. So ultimately, that's what we're looking for. It's remedial in nature. The statute itself is a remedial statute. The penalties are not the severe stick. You can go to court, but even then, we're really focused on, first of all, helping people who have no other resources navigate the law, which is always intimidating. It's just always intimidating. But the second thing is having an open channel into agencies, having them willing to talk with you, having them willing to admit that this needs to be better, and then showing them how to do that. So that's the focus of this position. And is there accountability in that? I think there is. I don't think anybody wants to get a phone call from the Attorney General's office.
Thank you. Well, that's where I was going. In other words, you're not referring to elsewhere in the Attorney General's office for them to take action. I just worry that the data that goes from year to year, which I have really not compared, might see a consistent pattern on the part of a certain agency, and that agency may not have malicious intent. It may be a staffing issue or whatever, but if the law is not being complied to regarding FOA, then litigation could in fact require the funding to address that problem or whatever.
Right,
But
well,
you're
right.
saying right now it's a private litigation matter that would be the ultimate stick.
The way the statute is written, there's two elements there. The aggrieved party can appeal, right, to Superior Court. And then there's that one provision where the Attorney General's office can bring a suit for a willful non-compliance. And so those are two different tracks. I don't do any litigation, right? So those two tracks are there, but
Thank you. I didn't know about that latter option,
yeah.
but for that to happen, you would make a recommendation to the office?
Yes.
Thank you very much for that and allowing that, Madam Chair.
Senator Kime?
Thank you. Good afternoon, Ms. Kilty. Thank you for being here and for this report. I had a few different questions. So, and I think they're all pretty succinct. So one is in the report, you have not offered advisory opinions, but I just would like a reminder on what are advisory opinions?
Right. Well, it's written into the statute that I can provide advisory opinions, but there's some little bit of potential confusion there because we typically think of Attorney General advisory opinions, which have a certain authority as coming from the Attorney General and or assigned from the Attorney General involving lawyers in the office. So I have not used the term advisory opinion because I think it's too confusing related to what the Attorney General's office is charged with doing. But what will typically happen if I've had a situation that is a complaint that requires complete fact finding, a complete application of the law to the facts, then that often results in a letter from me that is essentially an opinion. These are the facts that we've established. Here's the application of the law to the facts. Here's my conclusion. And then it usually follows up with, and this is what I think needs to happen. Now, oh, sorry, go ahead.
So those types of letters then would be what would be classified as an advisory opinion, and you did not send any of those this last year?
I just I don't call it advisory opinion because I think it's too confusing. It's potentially very confused with what an Attorney General advisory opinion is. So that would just be a resolution, usually facilitated in my complaint category.
Okay. So I guess it's just confusing that it is a column in the outcomes if you actually are never going to issue something that you would call that.
I know. I just think it would not be fully reflective if I didn't have the column there because it's something that I can do.
Okay.
But in consultation with the AG's office over the years, I've sort of come to this conclusion that I really shouldn't label something an advisory opinion, and I do not.
Senator Kime?
Yes.
I'm sorry to interrupt your questions, but Representative Harnett is scheduled to present the Right to Know Advisory Committee report, and he has to leave our committee meeting in 14 minutes. And so can we switch over and let him present, and then we can return to your questions to the Ombudsman?
Sure, thank you.
Okay, thank you. And thank you, Brenda Kilty, for staying. Representative Harnett, you have the floor.
Thank you very, very much. And I apologize for the time constraint, but it's with people above my pay grade. So I do have to leave at 2:30. I'm here to talk to you about the 16th annual report of the Right to Know Advisory Committee. And this reflects the third report on which I chaired the committee, and the fourth time I've delivered it to this committee because I delivered one in the first year I was in the legislature that for a committee that had been chaired by someone else. And I always start out by really thanking the members of this committee. It is a phenomenally hard working group. We met 5 times. We have 3 subcommittees. Everybody participates in subcommittees. We have some people that participate on every subcommittee. They really are a joy to work with. I do want to just take a second with a bit of a sad note, and that is last weekend, we lost one of the members of this committee, Suzanne Goucher, who's the head of the Maine Press Association. Suzanne was, I think she may have been on this committee since it started. If not, she's been on it for a very, very long time. She was always active. She always showed up. And she always had this wry smile that I know I noticed all the time. And you could tell if she thought what you were saying was perhaps not as well said as it could have been. So I just want to acknowledge her work and take just a short moment to reflect on that, because she really was a remarkable asset to the state of Maine. And I know I appreciated her work very much. The committee met 5 times over the year, which is more than we had to, right, Peggy? I think it's one more than we're required to by statute because we had so much fun. You have the report. It's a very thorough report. Because of my time constraints, I am going to run through the recommendations of the report, try to answer any questions. If I can't answer those before I leave, I'll make myself available to do so later. So the committee made 8 recommendations. One was, you may remember last year, we enacted Chapter 375 of the Public Laws of 2021, where we changed the way that people requesting records were billed. We basically increased the number of hours of free time that they got, but then increased the hourly rate to more reflect the cost of the municipality or the state agency for meeting that recommendation. That was a near unanimous suggestion by the committee 2 years ago. But we do want to see how it's working. So the first recommendation is we're asking the public access ombudsman, who I need to thank one for stepping in for going out of order today. And she's an incredible asset to the committee. But we've requested the public access ombudsman and the Maine Municipal Association to gather data to see what those changes in law did related to the fees charged for public records, and report back to the advisory committee no later than November 1st, 2022. What we think we're going to find is that for most people, it actually saved them money because of the increase in the number of free hours they got, and that the only impact was on large scale requests that are often not from individuals, but we don't know that. So we're going to study that and have that report back by early November. We also, Brenda mentioned, Ms. Kelty mentioned that we worked more with the state archivist this year, Ms. Kate McBrien, who was also a wonderful asset to the committee. And Ms. O'Brien let us know that under the archives law, the confidentiality provisions only protect records for 75 years. You, members of this committee, should recall that every time there's a public records exception, I run through a matrix to make sure that the exception is narrowly tailored, that it is not preventing public information from being accessible to members of the public. We are going to adopt that matrix, or we're recommending to adopt that matrix to reflect the fact that what we deem confidential is no longer confidential after 75 years, that people need to know that. And if people want to address that in some manner, that's going to have to be changed. A minor recommendation and that was to amend the aquaculture laws to make some data that is submitted to municipalities by aquaculture lessees confidential. We would amend that public records exception. Excuse me. Another recommendation is that when you go through the statutes in Maine, we sometimes use the word confidential. We sometimes use the word not subject to disclosure under the Freedom of Access Act, or not a public record. We are recommending that that term be uniform and that the proper term is confidential. So all records that are not subject to disclosure under the Freedom of Access Act should be deemed confidential. We also, and Brenda touched on this, recommend enacting legislation to amend the remote participation law to address situations when a public body has not adopted a remote participation policy, but they need to meet immediately. One of the first things the Right to Know Advisory Committee needed to do was to adopt its own policy so that we could meet remotely. This is to give some flexibility to municipalities or agencies that might find that the emergency prevented them from adopting the policy. And Ms. Kelty went through that, I think, very thoroughly. One of the issues that we discussed more than others is we are recommending to the Judiciary Committee that it convene an informal working group to study participation in the legislative process by residents of correctional facilities and the issues that must be resolved to allow participation. You may recall last year that we had a bill regarding parole and/or the study of parole before our committee, at which a lot of persons who are residents of correctional facilities wanted to testify. They were limited to providing that testimony in written fashion, but did not have the opportunity to provide it orally that all other members of the public have. I'll point out that this year, the Criminal Records Review Committee had a member who was an incarcerated individual, Foster Bates, who was a very active member of that committee, added a lot to the discussion, and was allowed to participate remotely because the main correctional facility had that ability to allow him to do so. But this is not an easy thing to fix. There are victims' rights issues. There are issues about the amount of space and technology in county jails and state prisons. So we are recommending that this committee, the Judiciary Committee, convene an informal working group, unstaffed by the nonpartisan staff, to look into this issue and bring it back to the Right to Know Advisory Committee this year for further action. You heard, and I think Brenda, Ms. Kelty articulated it very clearly, so much of what, in response to Representative Babbage's questions, that we need to do is to make sure that people who are responsible, particularly at the municipal and local level, know what their obligations are under the Freedom of Access Act, so that they don't get into trouble, so that they don't fall behind in responding to requests. So we are encouraging the Maine Municipal Association and the Maine County Commissioners Association to consider sending out annual reminders to their members about record retention schedules and, more importantly, available training resources. People don't have to train themselves. There are a lot of trainings out there provided by MMA and by the Maine County Commissioners. We also want to encourage legislative committees through legislative leadership to add to the committee orientation process additional freedom of access training so that all legislators and staff are aware of their obligations, their legal obligations under that law. And they would be conducted by both Ms. Kelty or whoever is the public access ombudsman and Ms. McBride as the state archivist. Because as we learned this last summer and fall and winter, in these meetings, there are a lot of people that just don't know their obligations, or staff has been turnover in agencies and turnover at the municipal and local level, and we have to ensure that we are regularly training people. And that specifically applies to digital records, including social media platforms. We had 3 subcommittees this year: the Remote Participation Subcommittee, the Public Records Exception Subcommittee, which meets every year. But this year we formed a subcommittee on technology. And again, Ms. Kelty touched on these things. There are more platforms now where information is transmitted and obtained, retained, and shared by state agencies and people in acting with state agencies and the legislature. Things like MailChimp and a lot of things that I don't understand, but we have email and text and voicemail and social media. We need to be looking at those issues to make sure that those new platforms are not used as a way to circumvent the public's right to access information to which they are entitled under the Freedom of Access laws. So those are the major recommendations of the Right to Know Advisory Committee. You will be seeing two statutes, one very shortly. One is the proposed statute that Ms. Kelty spoke about, and that is, what do you do for an agency that has not had the opportunity to adopt a remote participation policy, but they find themselves in an emergency setting where they need to do that and have a remote meeting. You will be seeing that, and you will also be seeing LD, and I think I have the number right, and it might be next Tuesday, LD 1772, that will give some more flexibility, and it's mostly to municipalities, but it will cover state agencies as well, to allow the chair or other person in charge of that entity to declare an emergency even if there is not a civil emergency. As you know, the civil emergency regarding COVID ended a while ago, but we have seen that the problems caused by COVID and the various, poor language, various variants are ongoing, and that there may be times, and this particularly relates to the requirement that even if there is remote participation or a hybrid meeting, that there always be a fixed location to which members of the public can go to attend a meeting. One of the things the committee heard loudly and clearly, and Representative Babbage touched on this, there are a lot of people, and sometimes it's an age demographic, that don't want to participate remotely. They want to be able to go to the meeting. They want to be able to look their municipal leaders, representatives in the eye and have that person-to-person contact. But we did want to provide, or we're recommending to provide, some flexibility if there are emergencies. The current statutes allows for sort of special dispensation when it's an emergency, say a terrible snowstorm or bridges out, that physically accessing the fixed location is not possible, but it will also allow agencies to make that determination if they think it's a matter of public safety or a public health policy. I have no idea how the committee is going to feel about that when it sees it, but I believe that is coming up on next Tuesday, February 1st. So I know that this was very rushed.
Representative Harnett, can I ask
Yes.
you a quick question? The
Sure.
last legislation that you were describing, is that a bill that you are sponsoring rather than a bill that the committee is going to ask to have printed?
That is correct. It is a
Okay.
bill that I am sponsoring at the request of the Maine Municipal Association, but it was the subject of discussion at many of the Right to Know Advisory Committee meetings, particularly the remote participation subcommittee.
Thank you.
I do know that there are members of the committee here in the participant, in the waiting room. And I would invite them to, if anybody has something to amplify what I said, correct what I said, or just wants to share with the committee their views on the work that they have done with the Right to Know Advisory Committee, to raise their hands if that is what the chair would like, so that they have an opportunity to weigh in. And again, I know this was rushed, and I will be back.
Thank you so much, Representative. So committee members, I think this is how we're going to proceed right now. First, I'll ask the members of the Right to Know Advisory Committee who are in the attendee, excuse me, part of the meeting, if they want to join the committee to add anything to the report that Representative Harnett delivered so accurately and concisely. And then will speak to the committee about requesting that the two pieces of legislation that are contained as appendices in the report, that we have those printed and referred to our committee. And so first I will turn to Representative Harnett. Would you like me to deactivate your video?
I am sending you just a chat, and then I'm going to sign off.
Oh, great. Okay, thank you. So first, I will ask if any member of the Right to Know Advisory Committee in the attendee portion of our meeting would like to address the committee or respond to or add to anything that Representative Harnett said earlier. If so, can you please raise your electronic hand? And I am not seeing any hands raised. I did want to, Peggy, did you have something to share with the committee?
No, I was just ready to share the appendices of the legislation that Right to Know was recommending that this committee have printed and then referred back.
Okay,
So
thank
whenever
you.
you're ready.
Okay, yeah, and so Representative Harnett can answer additional questions when he comes back. I apologize for the rushed nature of this. We had a little more to cover, I think, than we realized when we were scheduling these meetings. And so there is some thanks and concurrence from members of the committee regarding what the Ombudsman and Representative Harnett, the chair of the Right to Know Advisory Committee, indicated. And so with that, we will, and I know Senator Keim, you have some questions to continue to ask, but let's first wrap up the report and ask Peggy if you could please screen share the two pieces of legislation that the committee should consider requesting be printed.
Great, thank you. So the first one is, Brenda Kelty also mentioned this. It's amending the existing remote participation law to deal with the situation where an entity has not had an opportunity to meet in person. They need to meet remotely, but they haven't met in person to adopt a remote participation policy. So this actually allows them. It would amend that section of law and add in 2 subparagraphs under paragraph A to say that if they haven't already adopted a policy, the chair of that entity, that whatever public entity that's covered by the Freedom of Access Act, convenes a meeting, says there is an emergency situation or an urgent issue exists that requires them to meet and meet remotely, convenes the meeting, the notice goes out, the notice is clear about how members of the public can participate in that meeting, because the law right now says in order to adopt a policy, you have to have notice and hearing. So you have to give an opportunity for the public to weigh in. That's the whole idea of the notice and hearing. So step 1 is the chair convenes a meeting, sends out the notice. Step 2, at the meeting, there are 2 questions the members have to vote on. The first one is whether they agree with the chair's determination that an emergency or an urgent issue exists. So here's step 2. The members vote to determine if that's true, and then if they do, then the members vote on whether to adopt a policy authorizing remote participation under this section. So it's not saying the policy has to be different. It's just the way of getting with the chair's determination of the policy So that is the remote participation bill.
Thank you very much, Peggy. Committee members, does anybody have questions about this for Peggy or for any of the members of the committee? I was also on that committee, so I can endeavor to answer questions as well. Representative Babbitt, your hand is up. Go ahead.
Yes, thank you. My question really went to whether the 2 bills that are in the report as part of appendices, D and F, needed a motion. But I'm a little confused about what Representative Harnett said. Is this a sponsored by Representative Harnett at the request of the MMA, or actually Or is that all true, but it's actually being proposed by the Right to Know Committee?
No, completely different issues. LD 1772 is Representative Harnet's bill it amends the same section, and it does something completely different.
Oh, okay.
And he put that in on behalf of the Maine Municipal Association. You'll hear that next week. This is a very discrete issue about getting to the point of adopting a policy when you can't meet in person.
I was under the impression this was 1772, but
No,
it is not.
it is not.
Thank you for that clarification. Gotcha.
Committee members, any additional questions related to this particular piece of legislation that's being recommended by the Right to Know Advisory Committee? I am not seeing any hands up. And then Peggy, you're going to walk us through the second one.
Yeah, the second one. So there's a subcommittee of the Right to Know Advisory Committee that reviews all existing public records exceptions. And the only one that the subcommittee recommended a change to and the full advisory committee supports is in the aquaculture laws in Title 12 that it's when a lessee submits to the Department a seeding and harvesting report. That report is confidential, but it is available to the municipalities where that aquaculture site is located, either in or abutting the aquaculture site. And the department can share the report with the municipality if they request it. And all they wanted to make sure was if the report is given to the municipality, it continues to be confidential. And so that's what this does. It amends that to say, new sentence, a copy of the report provided to municipality pursuant to this paragraph is confidential. So once that report is submitted to the department, it remains confidential.
Committee members, any questions for Peggy or for any member of the committee regarding this proposed or recommended piece of legislation? Representative Babich, did you have a question on this one?
Yes, thank you. I wanted to ask Peggy if the definition of confidential is standardized at 75 years, or if there is flexibility for a different category that need not be held from public view for that long.
So, this was a kind of a revelation, I think, to the Right to Know Advisory Committee. We talked about it a little bit last year with regard to juvenile records. So the statute says that records that are in the archive statute says that records that are in the possession of archives. So once it's no longer an agency record, it gets turned over to the state archives, subject, because that's what the record retention schedule says, that this has archival value. We're going to retain this record forever or indefinitely. And so what the archive statute says is if we need to keep this forever, then 75 years after that record has been created, that becomes a public record. If we're keeping it, if it has archival value, then it should be available to the public at some point. We're saying in the statute, it's available to the public after 75 years. So anything right now that we say is confidential, once it gets transferred to the archives, it will be accessible to the public after 75 years after its creation. If the legislature says, oh, we actually want to keep this confidential only for 25 years, then you can say that in whatever statute it is that is designating the record as confidential. Or if you think it needs to be confidential for 100 years, you can say that. You say, notwithstanding that section of the archives law, this remains confidential for 100 years. Otherwise, the default is 75 years. So that applies across the board without anybody doing anything.
So is there a default for municipal records right now, Peggy?
It turns out that's if they're turned over to the archives. If if an agency retains those records in-house according to their retention schedule, if a municipality retains the records in-house according to the retention schedule, then that 75 years doesn't apply. They actually have to be in the possession of the archives. Yep.
We're not able to hear you,
Yeah,
Representative.
I'm sorry. I was getting into actually some work session discussion. So thank you. I'm done with that. Thank you very much, Madam Chair.
Okay.
Thank you. Okay, any other questions on the proposed legislation or recommended legislation that's Appendix D? It does not look like we have any more. So committee members, at this point, I would ask you whether the committee is in agreement that we are going to, that we would like to have legislation printed regarding Appendix D and F. Representative Babbage, go ahead.
So moved.
Got a motion. Is there a second? Seconded by Senator Keim. Thank you. And committee members, this is something that we could do by consensus or by a vote. So let's just see if we are all in agreement, then we can move on. So if you are in agreement, please raise your actual physical hand. And if there is a lack of unanimity, we'll do a roll call vote. So if you're in agreement on having these two recommended legislations printed, raise your physical hand, please.
I'm seeing only 6 on the screen.
Well, that's because you've got me off.
Oh, okay. I didn't cut you off, honey, did I?
No, I think it says the host shut me off. Is that you? Yeah.
No, I did because you had walked away from your desk.
Right. Yeah, I had to. Yeah.
With the camera on. So,
yeah.
Okay, so let's do a roll call vote on this because there is not unanimity.
Madam Chair, are you okay?
Yes,
Okay.
we're ready when you are. Thank you.
Thank you very much. Representative Galgay-Reckett.
Well, I'd like to wait a minute, and second, if you could put me on, I'm still not on the screen, so.
I don't believe
I will try to do that while
All right.
Supi moves forward with the roll call.
Thank you very much. Representative Newell. Representative Evangelos. Representative Poirier.
Yes.
Representative Poirier votes yes. Senator Keim.
Yes.
Senator Keim votes yes. Senator Sanborn. Senator Carney.
Yes.
Senator Carney votes yes. Representative Harnett. Representative Babbage.
Yes.
Representative Babbage votes yes. Representative Thorne. Representative Sheehan.
Yes.
Representative Sheehan votes yes. Representative Moriarty. Representative Hagan. Representative Libby.
No.
Representative Libby votes no. I will recall the absentees. Representative Galgay-Reckett.
Well, I'm trying to say yes. Can you hear me now?
Yes, I can hear you and I can.
Okay, all right.
Thank you very much. Representative Galgay-Reckett votes yes. Representative Newell. Representative Newell is absent. Representative Evangelos. Representative Evangelos is absent. Senator Sanborn. Senator Sanborn is absent. Representative Harnett. Representative Harnett is absent. Representative Thorne. Representative Thorne is absent. I'm doing my math real fast in my head and it's not coming up. Let's see.
Oh, Representative Newell is here.
That would be great. Representative Newell, would you like to vote?
Yes.
Representative Newell.
Yes.
Representative Newell votes yes. Thank you very much. So I have 4. I don't know why I'm not coming out with the right number.
I have 7 in favor of
What
the
I have.
motion, 1 opposed, and 6 absent.
Oh, well, that's my problem. I have 4. Thank you, Peggy. I didn't do the lines as well. Madam Chair, would you like me to repeat what Peggy just said?
Yes, please.
Thank you. And thank you, Peggy. 7 members voting in the affirmative, 1 member voting in the negative, and 6 members are absent. That is the vote of the committee.
Thank you very much. And the second issue that we have to consider as a committee relates to the recommendation that the judiciary convene an informal working group on the participation of residents of correctional facilities in public proceedings. This would be an informal working group. The meetings would be open to the public, be publicly noticed, and publicly either publicly accessible or potentially available publicly in the same online format as our committee meetings. So I again would ask, this is to form a working group. It's not to look at the issue, but no substantive decision is being made by this vote. And I would again ask committee members, let's first see if there's well, actually, I think it's better to just simply do a roll call vote. That will be I think the clearest way to do it. So this would be I'll formulate the motion and ask a member of the committee to make the motion. The motion would be to form an informal working group to look at the participation of residents of correctional facilities in public proceedings. Do I have a motion to form such a working group? Motion by Representative Reckitt. Is there a second? Seconded by Representative Sheehan. And Soupy, I think, oh, well, is there any discussion of the motion? I am not seeing any. I think we're ready for the vote.
Thank you very much, Madam Chair. Representative Galgay Reckitt.
Yes.
Representative Galgay Reckitt votes yes. Representative Newell.
Yes.
Representative Newell votes yes. Representative Evangelos. Representative Poirier.
No.
Representative Poirier votes no. Senator Kime.
No.
Senator Kime votes no. Senator Sanborn. Representative Carney. Excuse me, Senator Carney.
Yes.
My apologies. Senator Carney votes yes. Representative Harnett. Representative Babbage.
Yes.
Representative Babbage votes yes. Representative Thorne. Representative Sheehan.
Yes.
Representative Sheehan votes yes. Representative Moriarty. Representative Hagan.
No.
Representative Hagan votes no. Representative Libby.
No.
Representative Libby votes no. I will recall the absentees. Representative Evangelos. Representative Evangelos is absent. Senator Sanborn. Senator Sanborn is absent. Representative Harnett. Representative Harnett is absent. Representative Thorne. Representative Thorne is absent. Representative Moriarty. Representative Moriarty is absent. Madam Chair, I have 5 members voting in the affirmative, 4 members in the negative, and 5 members are absent. That is the vote of the committee.
Thank you very much. And we will give our colleagues who were absent today, and I know people have been pulled in a lot of directions this afternoon, we'll give them the usual 48 hours to vote that we have extended in similar situations. And so the next order of business, and thank you everyone for your work on those 2 issues, is that Senator Kime had a few additional questions for Brenda Keelty. And so Brenda, if you are able to activate your video again and join us on the panel, thank you so much. Senator Kime, did you want to continue with your questions?
Yes, thank you. I need to change views here, I think. Okay, there we go. So, okay, so I think where I was at was, before I forget it, is to tell you that I have had many people mention your name and how helpful your agency has been, just helping them understand the process and navigate and answer questions. So I did want to pass that on, and more this, I've obviously been in the committee a while, but it's been more this past year than other years. And so a couple of questions for you. The municipal government is always the largest category, but would you say this year that the queries about the access to municipal government information is up because of so many remote meetings? Would that be your overall take of that?
Yes, I think that since remote participation is happening across the board pretty much, it generates a lot of questions. And so, yes, I do think on the municipal level that there have been a lot that have come from that. So even though I think the statute is, like I said, balanced, and even with a balanced statute, the implementation can, cause some problems. There's technology aspects of this. There's the quality of the meeting. There's accessibility issues. So I do think that it was sort of to be expected that there'd be more questions about it. And indeed, yes, there were.
Yeah, and I mean, it's what I expected, but then the pending requests category, I glanced through what some of the agencies gave in response, and some of them are, much older than a year. And so I'm wondering why wouldn't they automatically go into the category of response times that are over 60 days, over 6 months, over a year? Why do we have a pending request category that doesn't get categorized by how much time it's been waiting?
Well, I think that it's a little bit unclear because there are also requests that come from the year before.
I saw that, 2019.
So these are pending 2021 requests, but there can be a request that was logged as a 2020 request and was listed as pending on the 2020 report that now comes into the 2021 report and may be one of the greater than a year numbers. So I don't know that there is an uncomplicated way to try to separate out without having a spreadsheet of every single request and what happened to it, right? So the ones that are pending 2021 may be very recent, but those are requests that came in 2021. So I don't know, the ones that are holdovers from the year before, first of all, I don't think that's a large number, but we don't have a separate category for that. So I agree, it's a little bit unclear.
Okay, and then so when we look at, the overall responses, and I think it was like 60% or something that were responded in the 0 to 5 days, what I'm wondering is these categories don't give us a full picture of lack of responsiveness, possibly around certain topic areas or certain issues. And I was wondering if you look at the requests that are delayed or are seriously delayed, and looking sort of deeper to see if there's a problem based on sort of shielding certain type of information.
You're correct. This collection of data does not go to the content of the request. So this does not reflect at all whether or not there is either a category of requesters who are being sort of held from the information, or certain kinds of information that takes a lot longer to get. I can say though that anecdotally, email, and particularly commissioner level email, generally is taking a long time. And so some of these probably are asking for email. And one of the reasons I think that does take a longer time is that it generally needs a very high level review. And the people who would do that review are extremely busy. So I do think though, if we were to try to uncover what requests are the ones that tend to take the longest, I believe we would find that they're asking for email, and it's probably commissioner level email. It's an inquiry across agencies that I have not done, and I'm certainly willing to do such an inquiry if the committee feels like that would be valuable information to them. And it does relate again to my comment earlier that there are also two things that stand in the way of always prompt responses, aside from bad faith. Bad faith is always out there, and if that's going to happen, then all of this is not going to change that necessarily. But the fact that we need more OIT support to deal with electronic records, because the requests are vast, and we're talking about thousands of emails, thousands of electronic records, right? All of which have to be reviewed, collected, and reviewed. And then the second thing is that we don't have designated people handling FOA. It's nobody's job, but we're all responsible for it. And so that can be a problem too. But in terms of content area, I am more than happy to try to uncover, if you feel like that's information that would be valuable, if there is some sort of area of a problematic content area. I would also say though, that records that are covered by confidentiality statutes, it generally takes longer to do those reviews because the confidentiality review itself can be complicated. Yeah. And that may result in a denial, but it's still going to take a while to get there. And those will be reflected as taking a longer amount of time. So I'm happy to look at any issue, Senator, if there's something there that you want me to dig into.
Mm-hmm. Yeah, I will definitely give that. I will definitely give that some thought. So generally across the board, you're not asking any of the agencies to tell you what types of requests have been sitting out there for a long time. That's not information that they're giving to you.
Not in this collection of data. They're not collecting that. And I am asking them to collect a new piece of information going into this year to help us try to determine how effective the 2 free hours is. So I am asking them to give me another piece of information. And but in this collection of data, no, it doesn't ask about content.
Mm-hmm. Okay, yes. And then another question I had so 2 more questions. So one is the actual requests, is it confidential information to find out which requests are sort of long-term lying out there? I mean, could we, as a legislator or just even as a general public person, could you ask, say, DAFs or whatever, what are the public information requests that you have currently pending?
Yeah, a Freedom of Access Act request itself is not confidential.
Okay.
So for instance, on the federal level, under FOIA and the implementation of FOIA, agencies actually have forward-facing databases that show who all the requests, who the requester is, what they asked for, the status. you can find out on the federal level what requests have gone to an agency. I've seen it done by a couple of municipalities that had a high activity level of FOA, and they just decided to post online on their website the FOAs that they were receiving. But yes, it is, and agencies do get FOAs about FOAs. So yes,
Interesting.
that
Yeah.
does happen. Yeah.
But if it isn't privileged information, you can just ask for the information. You don't have to actually go through like say this is a FOA request, right? Because it's not privileged information anyway.
Right. Well, you can always just ask for something without, invoking FOA.
Okay. Yeah. And then the other question I had, you mentioned that the AG was sort of one of the sticks. It was going back to Representative Babbitt's questions, but you said that the AG can bring suit, and that would be on your recommendation. I was just curious, have you ever recommended that? Has that ever been a recommendation of yours in the decade that this has been?
I just want to make it clear, it doesn't have to be on my recommendation. So the statute gives the AG's office authority to bring suit. I think that Representative Babbage's question was, would you? And yes, if I see something egregious that I think the office ought to take a look at, there have been situations where I've brought something to the attention of the office, and there may be other areas involved, something on the criminal side or investigations, or there may be something else going on that looked like it warranted a referral. I don't know if you remember the situation with the Blue Ribbon Commission on Education. I'm forgetting what year that was, but Governor LePage had convened a commission to talk about education, and their initial meeting was at the Blaine House, and they closed the doors to the press. And I made quite a stink. Because it was clearly a public meeting, and they were trying to say that it was a meet and greet, and it was they were convening. So we did get the AG's office involved in that, and I believe that there was a suit was filed and maybe settled, as I recall.
Okay.
It was some time ago, but. So that would be an example where I just felt like this is so egregious, and it really needs to be addressed quickly and in a really big way. And it was, so those are a couple of examples of the way that might work.
Okay. All right. So that's all my questions. Thank you so much.
You're welcome.
Committee members, any additional questions for the Public Access Ombudsman? Not seeing any. Brenda Kilty, thank you so much for being here and for answering all of our questions and for your thorough report. And then I also would very much like to thank the members of the Right to Know Advisory Committee who also attended today and listened to our discussion and were available for questions. And with that, we will end our work on the Right to Know Advisory Law and the 2 reports we received today. And we are going to open our work session. But before we do that, committee members have been in attendance for 2 hours. And so I think that committee members and staff might need a 5-minute break or so before we open our work session on LD. And I do not on LD 1529. And so it is, let's see, 6 after 3. Let's take a break until 3:11, and then we'll open that work session. Thank you, everyone. And committee members, please remember to deactivate your video during the break. Thank you. Committee members, if you are able to activate your video and return to the meeting, we can get started with our work session. Thank you. I was muted. We're going to do a work session on 1529, and then we have two, I think, rather quick language reviews on LD 344 and 1774 ahead of us this afternoon. And I am going to start bringing over the bill sponsor from the attendee part of the meeting. It's Representative O'Neill. Okay, and for some, oh, I am not, I don't know that Representative O'Neill is able to join us at this very moment. Peggy, could we perhaps take one of the language reviews right now? I'm getting a message that the request to join the panel is being declined.
Yes. Let me pull up the amendment. So Janet and Janet's actually in another room and she's monitoring another meeting. So let me just make sure that she's aware. But I'm going to ask you to, is Representative O'Neill? Oh, she's right there.
Yeah, and I'm still getting a sign that Representative O'Neill cannot join us. So if we could go ahead with one of the language reviews, I think that'd be great.
Great. How about I have LD 344. This is Representative Galgay Rector's constitutional resolution. The majority report is just a fiscal note. And this is what the fiscal note is. I'm sharing the screen. This is the standard fiscal note for a constitutional resolution because it requires the question to go out to referendum. And so this is the standard fiscal note. It does not at this point require an appropriation. It will go to the appropriations table unless they exempt it.
Thank you. Committee members, are there any questions regarding this amendment to 344?
And we have the voting sheet here. So if anybody needs to see the voting sheet. And I can't.
All right, does anybody need any other information before? And then we don't have to vote on the language reviews, do we, Peggy?
No, this is just for your information. You need to have a chance to see it before it gets reported out of committee.
Okay. Is everybody comfortable with that? Thank you very much.
Thank you.
Not seeing any questions. Okay, and then LD 1774.
That's Janet.
Thank you, Janet.
Thanks for that,
I
Peggy.
just had to remember to unmute myself. Sorry. So LD 1774, I just included the original bill here just to remind you. This is a bill that writes a provision by moving some language around, stating the rights of adults subject to guardianship. The new language is here in paragraph C about the right to retain an attorney for any reason and to contact and communicate freely with certain others, including counsel, the court, an ombudsman, and advocate. Your amendment, which was a 13-to-1 report, also removes a specific subsection of a different statute. If you remember, section 5-315 talks about some of the duties of the guardians who are guardians for adults. And one of those provisions talks about the guardian's duty not to inhibit the right of that adult to communicate with others. And there are certain limitations on when the guardian can limit the contact with others. And that provision of law doesn't apply to any guardianship established before September 1st, 2019. And so the majority report is to remove that limitation so that all of the restrictions on how a guardian limits the adult's communications with others, all those restrictions apply to all guardianships. That was the goal of that amendment. So that's what it does just by getting rid of that subsection. There was a fiscal review done and there is no fiscal impact.
And I'm shut out again.
I can reactivate you, Representative Reckett. Give me one moment. And I apologize if anybody can hear my dog barking in the background. I don't know why she's barking.
She's got my dog barking.
Maybe they don't like my voice, so I'll be quiet.
I think it might have been a UPS truck, Janet, which comes with treats.
They're barking because they're dogs.
Representative Reckett. Okay, great. You can join us. Thanks, Janet. And are there any questions, committee members, about the language, the final language in the bill? Okay, and everybody's all set with both of those language reviews then? All right, then thanks so much, Peggy and Janet. Appreciate, and then Supi, did you have a question for us?
Yes, please. This may be an appropriate time to bring this up because this is the first time you've had language reviews. And so the procedure this year is going to be a little different. It's going to be the committee clerks are going to handle this. I think we've talked about this before. Now that you have a final vote, you had an amendment review. The next step is that I am going to be getting the jackets ready and I'm going to be sending them to you via email, and you then have to send back your approval. That will come directly to me. So I just wanted you to be sort of look out for that because that's what's going to happen from now on. What I'm going to do is I'm going to send you a copy of the vote sheet. I'm going to send you a copy of what the jacket looks like. And all I need to do is have you send back that, yes, I approve. Please only do, if you could only just say, yes, I approve or no, I don't approve, that would be excellent. And just send that directly to me. And I'll try to write that all in the email. But while I've got you all here, I thought I'd take advantage. And I thank you, Madam Chair, for that ability.
And that's going to be the process for all divided reports.
That is correct as of right now.
And the email is going to come from you, Supi?
Yes, correct.
Okay.
Sort of like when you miss a vote on the absentees, you know, look out for that. But the difference is the absentees, you send it to your respective presiding officers. Yeah. In this particular case, we have been told, and again, I have to put that caveat as of today, you are sending that back directly to me.
Sometimes the title of the email, if the beginning of that is the same every time, that'd be helpful. But if it's from you, that's also
okay,
helpful. So
good,
thank you.
Voter approval maybe, or vote approval?
That sounds perfect. Thank you.
Thank you.
And great suggestion, Representative Babbage. Yeah, and as a reminder, committee members, it's important to turn those around quickly because that helps us move our bills through all of the paperwork part of the legislative process so that they get to the floor of the House and the Senate in a timely fashion. All right, thank you. And I believe that the bill sponsor for 1529 is here. And so let me bring Representative O'Neill onto the panel and we'll begin our work session. Hello, Representative O'Neill. Welcome to the Judiciary Committee. And we are going to open the work session on LD 1529. And I understand that for this work session, you are going to speak to us just to catch us up on what work you've done on the bill since the public hearing that happened, I believe, last May. And then you have two experts who you think would are going to give us a brief presentation that you think will help us give us some context for understanding the bill. And then we'll open it up to committee questions for the bill sponsor and for others who might be in the attendee part of the meeting who we have questions for. And so with that, we'll turn it over to you, Representative O'Neill.
Thank you very much. Good afternoon, members of the Judiciary Committee. I'm Maggie O'Neill. I represent House District 15, which is in Saco. And so for your work session today, just because it's been a year, I wanted to refresh everybody's memory a bit. that both former Representative Justin Fecto and I had put in separate bills to create a right to privacy. And we realized it pretty early on before session even started. So we decided to team up on it. And one of our co-sponsors was also Representative Billy Bob Falkingham. So when we last met, we had asked for some more time to talk with stakeholders and really work our language. So in the off session, we had already consulted with a bunch of folks, but we talked with Major Scott from the Maine State Police, privacy professors at Maine Law, privacy practitioners and experts, the ACLU, defense attorneys. We checked in with the governor's office, with Senator Donna Bailey, and then other stakeholders like Billy Bob, Justin Fecto, and myself. And we're grateful for everyone's time and attention on this. I wanted to go through the three parts of the agreed upon language that we had shown you a year ago, just to refresh your memory, because it's not posted online. So I'm going to ask Peggy to share that attachment, which is titled Proposed Amendment, on the screen. And while she gets it up, I'll tell you that there are really three parts to it. The first is adding privacy to Maine's natural rights section. The second creates a right to privacy. And the third adds electronic data and communications to houses, papers, and effects under our Article 5, which is Maine's version of the Fourth Amendment, that protects against unreasonable searches and seizures. And I'll also touch on other states, because during your working session, folks had asked me if I could bring some more information about other state constitutions and what they do. And currently, there are 13 plus states that have provisions that protect personal privacy. There are Alaska, Arizona, California, Florida, Hawaii, Illinois, Louisiana, Michigan, Missouri, Montana, New Hampshire, South Carolina, and Washington. Montana has one on the ballot this year. My testimony from the public hearing outlines each of those provisions, so you can see the actual text of it. So for the first part that you can see on your screen, it adds the phrase privacy to Maine's natural rights section, reading that all people are born equally free and independent and have certain natural, inherent, and unalienable rights, among which are those of enjoying and defending life and liberty, of acquiring, possessing, and protecting property, of privacy, which is where that's centered, and of pursuing and obtaining safety and happiness. So as you can see, the natural rights section is already about liberty and other natural rights. This language came, this was Justin's original proposal, and I had also included it in my own because it came suggested by a privacy professor at the University of Maine Law School. So we were excited that we both independently thought of the same thing. And if you want to look, there's no analog for this particular section at the federal level. And something that I was interested in and learned about in school was that state constitutional protections typically stick with what's done at the federal level, but that there's an opportunity to do something more and go beyond what the federal government does in the federal constitution. So I thought it was a neat space to take advantage of that, since there's no federal analog to this. But the closest thing I could find in a state constitution was that California has a clause quite like this that explicitly protects privacy, and it looks a lot like this natural rights section. And I think it just makes sense. Privacy is a traditional concept. It's implicit in other rights. And since Justice Brandeis started talking about it in the late 1800s in response to emerging technology and encroachments, it just really makes sense to put it there so we can chart our own course on it. And then the second piece that you'll see is adding electronic data and communications to Article 5, to Section 5 of Article 1. So I think this is just something we would think was intuitive. Right now, persons, houses, papers, and possessions are protected from unreasonable searches and seizures, and government has to get a warrant for a search. And what we want to make clear is that electronic data and electronic communications are included among those things where the process would be get a warrant. This language stays the same as I had originally presented it. I worked on that language with input from all the stakeholders I listed, and especially with the legislators I mentioned, Billy Bob and Justin, Donna Bailey, faculty from the law school, practitioners. I consulted quite a bit with state police and their lawyers on it, and it was really important for me to take that time and walk through it and get input on how it would look in practice. And the feedback that I got, and there I have two experts here today, one of whom is a legal expert that can give you a little more information to have questions. But the picture that I got was that it would affirm requirements that are already in place right now, but they're a bit flimsy because an example is if you had information contained in a Facebook message or search history in a Google app, for example. The Supreme Court hasn't yet said that's protected. I would say it is. Statute wouldn't have as strong as a protection, and we would want this to be a backstop to say that that was protected, because right now the only thing that's making that practice common is that Facebook has a policy of requiring a warrant. So it really just reinforces that practice, and it makes it future-proof because a lot of privacy risks arise in relation to quickly changing technology, and we're always rushing to keep up to add those protections in statute as legislators. So I'm happy to answer more questions about the third-party doctrine and the concept behind that, but just some things to know are that courts, legislators are always playing catch up to protect privacy. Until 2014, we didn't know for sure that a warrant was required to open your cell phone and search it. Until 2018, we didn't know that government needed a warrant to access your cell phone location information at the federal level. Maine had gone ahead and put a statute because we value that, but in novel circumstances that aren't in statute, we wouldn't have that protection for sure in our Constitution. So I want to make that explicit. And so just again, I got that input from law enforcement, MACDL, that it would be helpful to make it explicit in law. And other states who have done similar things, just as examples, are Missouri, who was the first state to provide explicit protection for electronic data and communication. They did that in 2014. And you'll see 75% of voters passed that, which is a pretty high margin for the first state to pass that. Michigan in 2020 adopted the same protection in their Fourth Amendment equivalent. Their legislature unanimously supported the amendment, and nearly 89% of voters supported it. So it really shows how popular these issues are among the public. Supporters range from Americans for Tax Reform to ACLU. And I took some time to meet with folks in Michigan just to get background on their process, what the conversations were, what they had learned from law enforcement, et cetera. And it was very similar to my conversation with state police here. about enforcing that practice of getting a warrant. And when there's a question, just making sure that we have that clarity. And something else to note is that the Montana legislature approved this and then also sent it out to voters. So they'll be voting on it in November of this year. And Florida has a section as well about protecting private communications of any kind. They don't limit it to electronic communications. And then third, for an explicit right to privacy. So this would read, it would add another section to Article 1, and it would read that all natural persons have an inherent right to privacy that is free from intrusion, including privacy of a natural person's personal life, personal communications, private affairs, and personal thoughts or inner life. We already have a right to privacy, but most Mainers would be surprised to learn that privacy isn't explicitly protected in the US Constitution or in our own state constitution. In school, we learn that privacy protections are piecemeal, that there are different elements of privacy akin to slices of a pie that are protected. For example, the searches and seizures portion, the more kind of liberty kinds of things that are protected, intellectual privacy it's essential for free expression under the First Amendment. So, how you want to raise your kids, like there are all kinds of elements of privacy. This complex piecemeal approach could be strengthened and clarified with an explicit right to privacy at the state level. And something that I arranged for today was to have an expert who can explain why this is especially important in the face of emerging technology, because the privacy risks that we face today are more complex, systemic, and impactful than ever before. That's because, a big part of our national and global economy depends on collecting, using, and sharing our personal information. And the imperative of that business model is to collect more data, make better predictions, and deliver better targeted ads that make more money. So there's a lot of our info online that can be misused by both private and government actors. And we're always going to be playing catch up to protect Mainers against privacy threats. So really, this is important as a backstop, because these threats have arisen unpredictably, from anything from wiretapping to cell phone location data to apps on your phone. And now we're looking at Facebook rebranding as Meta and virtual reality and a whole nother level of data that's out there. So the goal here is really to create a backstop that can protect us in ways that statute fails to do while we play catch up. And again, just to close out, states that have some form of a right to privacy are New Hampshire, who in 2018, 81% of voters approved a right to privacy. Alaska has one. Arizona has something about no disturbing private affairs. We mentioned California's. Florida has a right to privacy. Hawaii, Illinois has like a Fourth Amendment. Louisiana, a Fourth Amendment kind of privacy included in Fourth Amendment. And as mentioned, Montana, South Carolina, Washington. So I think I'm all set with sharing screen, but what I want to tee up is one of the experts here today has an engagement that she needs to get to. So I wanted to make sure that I could have her come up maybe first and then take questions after, just to get her in and out if it pleases the committee. That first expert, her name is Shoshana Zuboff. She's a Harvard prof and a Mainer who has helped frame modern privacy issues. And I'm hoping that she can be a great resource to explain how privacy intrusions have arisen from rapidly changing technology and just to understand what we're playing catch up with and what the impacts are. And then the second expert that's here today for the committee is John Davison from the Electronic Information Privacy Center. He's a lawyer and he's on the cutting edge of protecting these against these privacy intrusions that threaten us as individuals, but also our society. And he can explain the current legal framework and, ask questions like that about why the amendment would be important as a backstop and how it would work in practice. Yeah, so that's it. Thank you.
Thank you. So I wanted to ask, we have 2 committee members with hands up, and I wanted to ask if the committee members would be willing to wait until after. Well, what is, should you tell us what Professor Zuboff's time frame is, Representative O'Neill? Like when does she have to be done?
I'm not sure exactly. Yeah.
Okay. Let's, Representative Reckitt and Representative Libby, are you okay with hearing from Professor Zuboff first? Representative Libby is not? Okay. Then Representative Reckitt.
I simply have a procedural question for you, Madam Chair.
Okay, well, let's take the questions in order then. Representative Reckitt, go ahead.
Well, my questions are mostly of substance, and I don't know whether it would be helpful to hear the questions before the presentations in case the presenters have some answer to the 4 or 5 questions that I have about this piece. But so I guess it doesn't matter to me as long as we're going to have a thorough discussion of it, I guess. So
Okay.
She can go ahead, I guess.
Okay, thank you. That's really considerate. Appreciate that a lot, Representative Reckitt. Representative Libby, go ahead.
Thank you, Madam Chair. My question is simply procedural. As we did have a public hearing last session, it seems like we're kind of verging on that public hearing if we're going to hear from 2 experts. I'm just wondering if we should guide that more to questions that we have of the experts to address anything that wasn't addressed in the public hearing, or if it's open for all who would want to speak about this bill to do so. Also, if there is a time limit on the experts. And this is no disrespect to Representative O'Neill. I appreciate her bringing this before us, but given the workload that we have this session, do want to remain on task.
Thank you. I appreciate your concern about our workload. And in speaking with Representative O'Neill about today's work session and also the complexity of this bill, she did very much want to give us 2 experts who could set the context for us. I think what I'd like to do is to limit those expert presentations to 5 minutes each, and then allow enough time for committee members to ask any questions. And I will be mindful of the time, and I do appreciate that you are also concerned about that, Representative Libby. And so with that, we're going to hear from Professor Zuboff.
Hello.
Hello, and welcome to the Joint Standing Committee on the Judiciary. I think you probably heard our earlier discussion. We would appreciate it if you could give us 5 minutes worth of remarks and then be available for some questions from the committee.
All right. Well, thanks very much for the opportunity to meet with you today. And it's a pleasure and honor to speak with all of the members, and I'm very grateful for that. I'm going to have to talk very, very quickly, however, because I didn't realize that we were only going to have 5 minutes. But my ambition was to give you a whirlwind tour of the last 5 decades. So let's see how compactly and quickly I can do that. I want to start in 1967. Justice Douglas, Supreme Court, and in an opinion that he wrote about that had to do with his views of the Bill of Rights and what the Bill of Rights implied about privacy, he said, quote, that according to the Bill of Rights, the individual should have the freedom to select for himself the time and circumstances when he will share his secrets with others and decide the extent of that sharing. The freedom to select. Everybody make a note about that phrase in your mind. Now it's 1970. New York Times Magazine, opening up on a Sunday. The famous economist Milton Friedman was there, and he wrote in those pages what was called the Friedman Doctrine. And he told everybody who was in business or an executive, a manager, he said, the only social responsibility of anybody in business is profit maximization. Okay, you with me? Freedom to select, profit maximization. Okay, and it should be noted that in the year 1970, 0% of the world's information was stored digitally. Okay, fun fact. Now it's 1997. We're in Washington, D.C., the Clinton White House. Clinton and Gore sign a white paper on the Global Electronic Commerce Framework. And in this white paper, having grown up, and they're in Washington, and they've grown up under the Friedman dictum, which you remember, Justice Douglas is in a white paper, and the very first principle of the white paper regarding the internet and this new field of electronic commerce is that, quote, the private sector should lead. In this white paper, all issues having to do with privacy, having to do with liability, and having to do with intellectual property rights, all those issues were given to the private sector for them to have private forums, private associations, and so forth that would generate the rules for these new marketplaces. That's 1997. In 1997, just a little bit more than 10% of the world's information was stored digitally. So we're still in very much a pre-digital age. Now it's the year 2000. And in the year 2000, the Federal Trade Commission has come to the conclusion that giving the private sector complete control over what happens on the internet and commerce on the internet isn't working, because there are violations of privacy all over the place that rob citizens of Douglas's freedom to choose what is shared and what remains private. So this freedom to choose is being violated. How? Things that now seem like really naive and benign, but in 1997 and 2000, they were a big deal. Things called web bugs, things called cookies, these things that tracked you across the web and then compiled these big databases of personal information, and companies are selling these huge databases of personal information about us. The Federal Trade Commission concluded that the companies were not able to self-regulate themselves into good privacy behavior. They proposed federal privacy legislation, basic protections at the federal level. What Representative O'Neill was remarking upon the fact that we do not have to this day, which kind of jumps the conflict here to tell you what happened to the FTC's recommendations. If you were in Congress on September 10th, in the year 2001, you would have found that most people were talking about, should we have privacy legislation and how tough should it be? On September 11th, 2001, that conversation completely changed. Privacy, that conversation stopped. The new conversation was total information awareness. Instead of protecting privacy, the emphasis was now sharing information. That same year was the year that the young men at Google invented what I call surveillance capitalism. What does that mean? Very, very quick.
Professor?
I know I'm running out of time.
You have run out of time. Why don't you
Okay.
wrap up in a sentence or two, and then we'll give the committee a chance
All
to
right.
ask questions.
Surveillance capitalism was the way through the financial emergency of the dot-com bust to save Google. And what it said was the way we're going to get a fast track to monetization so that our investors don't abandon us is that we are going to secretly collect all the personal information of all the users, which means everybody. And that personal information we are going to compute, we're going to translate it into predictions, and we're going to revolutionize the advertising market with something called the click-through rate. That's what people today call surveillance advertising. Just this past week, Representative Anna Eshoo, Representative
Actually, I
Jankowski.
think we're going to have to
Okay.
turn to committee questions. Thank you very much. Committee members, are there any questions? Representative Babbage, go ahead.
Yes, I am fascinated by this, as you might understand. Is there a chance that Professor Zuboff might be able to give us a written testimony as well?
Yes, that would definitely be a possibility if she is able to provide that.
Senator Carney, yesterday I submitted a comment to the Federal Trade Commission, which is entertaining a petition for rulemaking that would ban surveillance advertising, what I was just referring to. I would be happy to share that comment with the committee if that would be of value.
Yeah, it would be really helpful. Thank you. And I know that we have a very specific piece of legislation in front of us, and we've had a work session, a public hearing, and one other work session on it, I believe. And so this time and format is for the committee to discuss and debate the bill. And we do want to hear the context and have the bill sponsor have the opportunity to refresh our recollection and help us understand the context. But we just from a process perspective, we're in the work session forum right now.
Understood. So yeah. I'll say good. Were there any more questions?
Yeah, there are going to be other questions, I think, and this is a great way for committee members to hone in on the things that they're particularly concerned about, and which will help them move on to a vote on the bill. Thank you. Representative Moriarty, go ahead.
Thank you, Madam Chair. Professor, I'm not sure if you're prepared to deal with this sort of question, which is very specific to the draft bill before us. But in reference to Section 5, the unreasonable searches and seizures provision, I have some concerns with the use of the term electronic communications. And I don't know that you can add any insight to that, because I don't know if you played a role in the drafting of this language or not. But as an illustration, if someone uses the most visible and frequently used social media platform, it seems to me there's no expectation of privacy in whatever you post. And I'm wondering if a posting of that type falls within the definition of electronic communications, because it really isn't private at all.
Well, whether or not a Facebook post is private, there are a lot of contingencies around that issue, because people can stipulate who gets to see certain kinds of posts. And then we have a lot of understanding over the years that even with those stipulations, Facebook will, without transparency, violate those stipulations that users believe they have in place, protecting their privacy, even on Facebook. So this is a very fraught arena. And because it's so fraught, and because so much of the company's behavior, so much of the corporate behavior is not disclosed. That's why it's called surveillance capitalism, because the only way they can get access to all of this personal information, which drives their targeted advertising markets, is to do so secretly with systems that are essentially engineered to evade our ability to be aware of them, let alone to resist them or withdraw from them. So in point of fact, the bottom line of my whole multi-decade whirlwind tour is that the only way now in the year 2022, when 100% of the world's information is stored digitally, that's how far we've come. The only way we're learning now to protect privacy is to begin by having it codified in rights. Statutes come and go. Statutes, as Representative O'Neill indicated, can be outrun. They can be outrun by tech company lobbyists, and they can be outrun by technology itself. Codification in rights is what the world is waking up to, is the only way that we can fulfill Justice Douglas's stipulation that we should have the freedom to decide what about our lives is shared and what is private.
May I follow up, Madam Chair?
Actually, I'm going to ask committee members if we could take a brief recess. And it is 3:53. Let's resume at 4 o'clock, everyone. Thank you very much. Hi, committee members. If you are at your desks, could you please activate your camera so that we can resume our work session? I'm going to just check and see. We have a few committee members who need to rejoin us. And would the bill sponsor please come back onto the panel as well? All right, thank you, everyone. I appreciate you giving us, giving me a little time for a brief recess. As the work session was proceeding, I was concerned that I had intended the experts to give the committee some time to ask some technical questions about how the proposed legislation would be implemented and the implications it would have. And I feel that we have really veered in a different direction, more of an advocacy direction that would be suitable for a public hearing on legislation rather than the work session process that we're in right now. And so I think what we are going to do at this point is I'm going to thank our guest and thank her for her information and return her to the attendee part of the meeting. And then we are going to, as a committee, talk about the additional information that we all feel that we need to move forward to a decision on this bill. And then we'll come up with a process to get the information that the committee as a whole needs. And I feel like that will be much more consistent with the approach of a work session than where we were headed. And I do want to thank the bill sponsor for her efforts to bring additional people forward. But we really, at this point, we're in the work session stage, and we need to be fair and balanced in how we run our work sessions. And so Representative O'Neill, I would really appreciate if you could stay on the panel with us as we go over these questions, because I think you can be helpful perhaps in this process of identifying the information that we need. And so I see lots of hands up. And so I'm just going to start calling on committee members and asking you if you could please articulate what information you think would be really important to moving forward to a decision. And of course, we'll have to reschedule the work session so that we can have that information available to committee members. But if you could think of the information you need, I'll take notes, and then we will reschedule the work session. And Representative Sheehan, you're in the upper left-hand box, so go ahead.
Thanks, and I hope that my questions can sort of direct you toward like a meaningful source of information, because they are kind of broad. I had a big picture question, and then later in Professor Zuboff's presentation, another more specific question arose. So I'm going to start with the most specific one. She talked about surveillance advertising and surveillance capitalism. And I'd like to understand what the proposed constitutional amendment could mean for Mainers' access to the information provided by services like Google, whose entire business model is based on collecting this sort of information. Like, would this constitutional amendment effectively ban those services from our state? So that's a really specific one. And the other one is more about the big picture question, because I'm not a lawyer and definitely not a constitutional scholar, but I wonder about the relationship to amendments and the establishment of this sort of right, and statute that, the one that came to mind was last week's bill that we heard about electronic location information. We passed a very similar bill, perhaps not as, it doesn't go as far as the one we heard last week, but we passed a bill that would allow providers to disclose the location of electronic devices if people's lives were like very clearly at risk. And I guess I'm just wondering what would happen to statute like that if a constitutional amendment like this were to pass. I hope that makes sense. I know it wasn't super concise.
Thank you, Representative Sheehan. So, I guess in response to your specific question about the bill you just passed. Oh, sorry.
Yeah, I was envisioning that we were going to take a list of questions from committee members and gather the information at a later point in time.
I could answer, but that's okay. Okay, so you
I'm just trying to give me one moment to think here. Thank you very much. Okay, well, yes, Representative O'Neill, if you can go ahead and try to provide the answers to those questions, and then we'll see if we need to follow up at another work session. Thank you.
Absolutely. Yeah. So I do first want to apologize. I think for the specific question about the specific bill you passed last week, I'd have to take a look at it. I do know that Maine years ago had passed. We have a law and statute. I have it mapped out on a document on my computer, so I could put that side by side with how this changes it. What you have done. I didn't know about the bill, but exigency was already an exception in there to notifying people about getting a location warrant. So I can pull that up and go over what that change was. And then for your broader questions about access to Google and things like that, the first what I want to open by saying is that I was hoping to provide through Professor Zuboff an eye into exactly how much information is stored online that's personal data that used to be in your desk drawer. So right now things are in the cloud that used to be in your desk drawer and protected by the traditional words of the Fourth Amendment that say houses, papers, and effects. And that's why it's so important to say that you also want to protect your electronic data and communications. And in all of my conversations with state police and with MACDOL, ACLU, and others, I came to the conclusion that in the big web of law and then private policies, a lot of this ends up being done in practice, and it hinges on private company policies. And I just wanted to make sure, knowing that we have an economy that's based on gathering more data, and that's what surveillance capitalism is. There's this imperative to collect more, conquer new territory, and that's rapidly evolving. So just understanding that more data, more territory is being collected. In that context, we understand why we need to have this backstop, because statute, as Professor Zuboff was saying, is always playing catch up. Because when technology changes, there's new technology, a legislature has to say, oh, how do we respond to this? How do we want to protect people? How do we, want to regulate it if we do? And as we're playing that catch up, people's rights aren't protected unless we have some kind of backstop, like a constitutional amendment that makes it clear that your data and your electronic communications are protected. So that's why this backstop is so important. And then as it applies to not having Google be in our state or something like that, I don't think we have to be concerned about that, because really it just makes a clear it makes the policy clear, and it's something that the company already has clear as a policy, and we're just saying this is in our constitution now. So it's the company's private policy. It's in our constitution now.
Thank you. Representative Reckitt, why don't you go ahead with your questions? And we're not able to hear you. Thanks.
First of all, I'm curious as to what the impact of this amendment would have on our right to know statutes, on the things we just talked about with FOA, and how things are, the big projects they sometimes have going through all manner of emails and so forth, which I see under this would not necessarily be protected. So much as I'd love to lighten their workload, I'm a little concerned that might be impacted. I'm concerned about possible impact on investigations by law enforcement and Justice Department people about potential terrorist activities. I'm concerned about that. I frankly would love it if it eliminated cookies, but I'm not sure. Well, not chocolate chip, but the other kind. And I'm also wondering whether or not this language or parts of it are already in statute in Maine, or could be in statute in Maine, and may or may not be effective. I understand you're saying we need a backstop so that we could be sure they were effective, but I'm not convinced that we have to start with a constitutional amendment, but I don't know whether that's the case. The other piece is I've been debating in my head, because it seems to me, and I could be wrong about this because I too never went to law school, but it seems to me that when the infamous decision Roe v. Wade was made, that it was made although it was decided on the basis of a right to privacy that was not explicitly stated in the Constitution, but was in fact decided on that basis. So I guess I'm questioning where the rights to privacy are implicitly or explicitly in our current state statutes or in the federal Constitution. So I just think there's a gazillion questions, and I'm not positive whether I should have known all these answers because I should have paid closer attention to the last time we apparently looked at this amendment, which I don't remember at all, which doesn't mean I wasn't like crazed at that point in my life trying to get through the time period we were in. But to me, it seems, particularly with the professor that just spoke to us and the other one that's on standby here, whether or not, and I know there's an urgency in your mind, Representative O'Neill, and in mine to some extent. I'm not sure we don't need to start over again here and do a public hearing on this now that we think that we know the magnitude of the concerns. I'm not even sure that made sense, but I just have a whole panoply of concerns about this.
So, all right. So what I have for questions are kind of what's the basis of a right to privacy if it's not explicit, impact on right to know, and I think what I want to start by saying is that the second expert that is here today is someone that is a lawyer that specializes in privacy law, and I don't know what format works for you. I think but a lot of these questions, I think he would be well equipped to discuss and answer, but I'm going to take a shot at them. You can see what you think and see if you would be interested in bringing him up to talk about what the framework of privacy law is in the US now, what's in the Constitution, what's in statute, how that interacts with, for example, right to know, where it's come from if it's not explicit. But I'm going to go through it a little bit just because this is stuff that I touched on in my testimony and then again touched on in the work session, but you have the busiest committee ever. So I can't blame you for not having it on hand, so I'll go through it. So privacy isn't explicitly protected in the US or Maine Constitution. We still have a right to privacy. But as a result of it not being explicitly protected, courts have developed constitutional privacy jurisprudence in a piecemeal manner, kind of like the way my professor taught it was like slices of a pie. And there are different elements of that. There's the Fourth Amendment that protects your house from unreasonable searches and seizures. Soldiers can't quarter in your home. You can't, like, there's an element of intellectual privacy with the First Amendment. And until legislation was passed in California that's comprehensive, statutory privacy law in the US has been sectoral. It's been about things like your health and insurance data. And it's created protections that are tailored and specific, but piecemeal. So we have this kind of spotty system where certain things are protected and certain things aren't. And constitutional amendments deal with typically with government intrusions. So when we are looking at our system of law and case law in Maine, for example, warrants around searching a cell phone. The way I read it right now, your cell phone, you need a warrant for cell phone location data, but it's not clear for stuff related to apps on your smartphone. That's a gap that's been created by technology evolving. And then companies like Facebook, like the apps that I'm referencing, are now switching over more to a virtual reality kind of thing where new data is going to be collected, like how your pupil dilates in response to stimuli, or that's just an example. And as things evolve, there's different kinds of data to protect. So the legislature is going to try to figure out how we want to protect specific kinds of data, specific kinds of situations. But what this constitutional amendment does is it makes a backstop, knowing that we're gonna say that there's a warrant needs to be obtained by the government for electronic data and communications, and that backstop operates knowing that statute takes time to catch up, if it does at all. And then for right to know, I think that would be a good question for John, who's here. If so, maybe we could make a list of things that would be good, and he can explain a little bit more about privacy jurisprudence at the federal level, like at the Supreme Court. Give a little background, because that's what he's here for. I think he could stick to background info as an expert. So.
Thank you. And I am taking notes of the questions. I'm not sure that we're going to hear from anybody else right now, because this is really about identifying the information that we need to move forward with a good decision on this legislation. So let's keep going with questions, and then we're really appreciating your answers, Representative O'Neill. And I think it's important for us to get out onto the table everything that we still feel like we need to know. And so Representative Moriarty, why don't you go ahead with yours?
Thank you, Madam Chair. I want to pick up on a point raised by Representative Reckitt, but I'll begin by saying that in the work session context, I feel a little bit off my game in that the public hearing was held back in May, and we really haven't done anything with this issue since that time. It would appear to me, if this can be done, that we ought to go back to square one with a new public hearing, particularly if we're taking extensive testimony from academic witnesses. The questions that I have are small in number at this point. The first I mentioned earlier, what does electronic communications mean in section 5? I also wonder if there is some redundancy between section 1 and section 25. And then finally, whether it would be sufficient simply in section 1, the natural rights provision of the Constitution, to include the term privacy and leave it at that. My guess is that if we were to fully hear Professor Zukov and her analysis of the historical development, it would take a good deal of time. One more question or request would be that I'd like to see what the 13 other states have done, how they've written their right into their constitution, and how broadly it's phrased, and whether that would dovetail with our own.
Representative, did you want to respond, Representative O'Neill, or are you okay with us taking the just taking? Actually, I think you should. A lot of these are pretty quick questions. Why don't you go ahead and respond?
For sure. So first question about redundancy, how it's written. I'd be happy to discuss that with you further, and I can also connect you with the my privacy law professor. Different people that I've been really thinking this out with as I've been drafting it. My response off the cuff is that I do think it's important to state that there is a right to privacy somewhere in the Constitution, whether it's up top in the natural rights section or your new section. That's something I'd be willing to consider and talk through the merits of that for sure. And all right, so your other question was about the other states. I included in my original testimony, so I'll be able to send it again, a chart, and it has the text of every single state and what they have in their constitution when it's privacy related, mentions privacy. So you'll be able to see that all charted out there. And you were talking about did you say anything else about the language of electronic communications? Or
yes, I wondered really what is the scope and breadth of that term.
Sure.
And my illustration earlier was if you knowingly, deliberately post something on the most visible and highly used platform, is that an electronic communication within the scope of the Constitution?
This is a great question, and it's one that I talked about in detail in my conversations with both Brian Scott and Chris Parr. And they were not concerned after we talked it through and could see the amendments to traditional Fourth Amendment, so Fourth Amendment law, which was so your police officer is standing on a public street looking at private property, looking at a house, and they see something on the outside. That's all right. A police officer is looking at a public Facebook profile and seeing some things posted. That's all right. And people start to talk about they're concerned about when government transitions from this manual looking at one profile at a time to a more automated system where it's being processed at a big rate and it becomes more advanced surveillance. Folks have concerns about that. But I think that something in statute could look at protecting that kind of technique if that's of interest to the legislature. But really, I think what traditional Fourth Amendment law would be, and it would be up to the court, but it seems pretty clear to me that something that's a public Facebook post is something that can be viewed to the public. Professor Zuoff did mention that there have been some issues with Facebook being clear about what it is that your settings do and convey to the public, and that's a nuanced issue. But I don't think anyone would argue that if I go on my Facebook wall and post something that's not, public facing, the way that we were talking about being on a public road and viewing something. So.
All set?
I am. Thank you.
Okay, great. Thank you. Representative Harnett?
Thank you, Madam Chair. Nice to see you, Representative O'Neill. I must admit, I am suffering a bit too, trying to remember May of last year in all detail. And I'm looking at the original bill and this new language, and I clearly get Section 1 and Section 5. And Section 5 is really, tell me if I'm wrong, is addressing the state securing this information it's addressing only state actors, correct? Like, protection against unreasonable search and seizure. Section 25 goes beyond that. Am I right? And it is controlling private actors and what they do with information, or what they collect in the form of information, or.
So if you look at the amendment that I sent out, I'll read it to you.
Yeah. Okay. Thanks.
The word private does not appear there.
In Section 25?
Correct. Yeah, it says all natural persons have an inherent right to privacy. Oh, thank you so much. That is free from intrusion, including privacy of a natural person's personal life, personal communications, private affairs, and personal thoughts or inner life.
And the word intrusion, is that limited to state intrusion, or is it broader than state intrusion?
I think the traditional interpretation of a constitutional amendment is that it's against a state actor.
Right, and that's my understanding. I just want to make sure I wasn't missing something. Thank you.
Thank you, Representative Harnett. And Representative Babbage, go ahead.
Thank you. I'm almost disappointed with that last answer, Representative O'Neill, because the question that I had for you, really one of them was that we have intrusions by the state, certainly, which we are concerned about, and we have intrusions by private interests, which I'm also concerned about. And one of my questions that I'd like to have somebody address is that corporate citizens, and we've talked about some of the big ones already, but is the government's ability, the state's ability to regulate wrongdoing by corporate citizens impacted by this privacy protection? That would just be one question that I would have. The other part, it seems to me, by elevating this to a constitutional right that has already been declared by the courts, but expressing it simply means, and I just would like somebody to inform me if I'm wrong, simply means, like all other constitutional rights, there are exceptions, but only with a compelling state interest. That would be. And then my final one would have to be with your testimony, which I appreciate very much, and you did designate other states' actions with regard to expressed privacy. And a few of them were only addressing electronic communication, and then maybe as much as a half a dozen others merely talk about expressed privacy. And my question there would be, what's the report card on those states having implemented those rights, and are there precautions that we should be aware of or perhaps take. So thank you for allowing me to express those three concerns.
Thanks. So the first question, as I heard it, was what's the impact for private actors? I think that one reason it might be important to include the to keep in the natural rights section part is that there's no federal analog for that. And I did flip through the case law in Maine, and I didn't do a deep dive in it, but I was able to see that people did sometimes bring up that natural right to underscore certain claims that they were making. So while I don't think it would give you a way to sue a company like Facebook or Google, it would underscore protections that we make in statute. And something that I want to say is that that's something I'm also working on, and I do have a bill, one bill coming to your committee about that kind of stuff, and definitely excited to talk about those issues too, because we need to approach this problem from a lot of angles. I have a note about making it explicit. You asked about how a court would apply the right to privacy, and could we look at what the impacts have been in other states? I think I'm not sure if John's able to answer that question today, or if that's something I could get you a bit more on, because I did do some kind of cursory looking up of that. But when I met with folks in Michigan, I asked them that same question: what have you seen? And they said it's just been pretty straightforward, just as I've explained it to you. But I could, I'll work with you on whether it would help to hear from somebody from another state, or what would be helpful. Because obviously I can't research every constitutional, how it's been applied in every single state, but I can try to get you some information. But I think something I do want to communicate is that this language is quite tempered and not really rocking the boat. It's just kind of making it clear that you get a warrant in these situations, that police are already getting a warrant because Facebook has a policy, for example. So I think we can know what to expect, and just know that in the future, the same things would be true if a new app didn't require a warrant. So it would give us some certainty as technology changes and novel situations arise.
Thank you.
Thank you. Representative Reckitt, go ahead with do you have a follow-up or another question?
Yeah, just briefly. I just want to remind people that I think it was last session, God knows it could have been 2 ago, that I sort of won this judiciary prize of actually being the only one who ever read in great detail the the things that we sign, yes, I will, every time we decide to join Google or we decide to join Facebook. There are fine print pages. I mean, they were 10 or 12 pages of disclosures and exemptions and all manner of stuff. And I was cross-eyed by the end, and I have no idea what they said, even because now, Lord, it's a year later, or 2 years later. But even so, I know that they have a particularly obtuse way to phrase what it is they're going to be able to do to you. And if you want to be on that platform, you got to say yes. And so it's like, it was very frustrating to read. So I'm concerned that that this whole area of law is going to have to evolve a bit. And I'm not sure you evolve law by starting with a constitutional amendment. That's my overall concern. And but anyway, I'm sort of with Representative Hartnett. I think we need to go back to public hearing. I mean, I don't think there's any way to flesh all this out in a work session. It doesn't seem fair to either Representative O'Neill or to people who might have questions, either one. So I'll be quiet now. And if I disappear at 5 o'clock, it's because I have to disappear at 5 o'clock to another commitment. So I will disappear at 5 o'clock. So, but
Thank you very much, Representative Rackett. Representative Newell, go ahead.
Thank you, Madam Chair. I just wanted to bring it to the committee's attention, and I'm sure that they are aware. I know that this was heard in public hearing on May 7th. So I just want to mention that the Judiciary YouTube channel does have a copy available for potential review by committee members. And the approximate time of the public hearing is about 3 hours and 23 minutes into that day's public hearing. If it's appropriate, I can copy and paste that into the chat. But I would defer to you, Madam Chair, if that's an appropriate thing for me to do.
So thank you for that offer, Representative Newell. I would ask you not to put it in the chat because it's not a substantive part of the hearing. But if you could email it, please, to the committee and also to Representative O'Neill, I think that would serve the same function. And I also, for members of the public and others who are listening, the committee's YouTube channel and all of our past hearings and work sessions, the link to that is provided on the Judiciary Committee landing page on the legislative website. And so if you click on the YouTube and you go to May 7th, and then Representative Newell, thank you for helping us locate it at 3 hours in. That's extraordinarily helpful. And I just want people to know that it is possible to, and easy actually, to go back and watch listen to and watch the public hearing on this bill. Representative Newell, were there any other pieces of information that you had wanted to request?
Not at this time. I just kind of wanted to make reference to that because I've been hearing some conversation in regards to having to bring this back to an original public hearing. So I just wanted to note that the original public hearing is available for review.
Yeah, thank you.
Thank you.
Yeah, and I know that Representative O'Neill referred to her chart of the language in the 13 states that have adopted a similar provision. And her original testimony is also available online. If you put the bill number, which is 1529, into the search bill, you'll find the bill. And then if you just go to committee, you'll see a link for testimony, and all of the testimony will be there. And so you can look at that chart. And again, I think she also promised to send it to us as well, which we appreciate, Representative. At this point, I feel like we have a great list of information that committee members feel they need. I do not have the sense that the committee is ready for a vote yet, but if are committee members in agreement that they are not ready to vote on this?
Yes.
Okay. And so at this point, I would entertain a motion to table the bill. Motion
moved,
by
Madam Chair.
Representative Poirier, seconded by Representative Moriarty. And so Representative O'Neill, thank you very much for all of your hard work on this legislation, and especially for all the information you provided to us today in response to our questions. Representative Newell.
Your time.
Yeah, you're welcome. Hang on a second, because other committee members may want to thank you as well. Representative Newell.
Thank you, Madam Chair. I just wanted to get some clarification as this has been tabled and we'll go into another work session. But just to ask this question for Representative O'Neill as well, as far as any further questions that come from the committee, she had two supporting witnesses here today that were not called upon to answer any questions from the committee where, so for me, I'm just wondering, in the next work session, will it be possible for Representative O'Neill to bring in people to answer questions from the committee?
Yeah, and I'm glad you asked that question, Representative Newell, because it takes us to like what's next for this legislation. And I need to look at our committee rules and other legislative rules and determine whether it's appropriate to schedule a new public hearing, because what the information that we're asking for and that that would have been presented today was more suitable to a public hearing than to a work session. And I just simply don't have those answers yet. And if committee members have opinions, please share them with me as you're able to. But I don't, at this point, I don't know whether legislatively the right process is to try to schedule another public hearing or to continue with a work session. I just need to think about that a little bit.
Might I ask a follow-up question?
Yes.
Madam Chair, would that not be a question or a point of discussion with the sponsoring bill sponsor, which would in this case be Representative O'Neill, whether or not a public hearing to go back to another public hearing would be appropriate, or a review of the original public hearing and a work session that might allow individuals to be brought in and be asked questions and allow for responses?
Yeah, and see, that's what I don't know, because I've never had this situation before as a committee chair. And so I need to look at the rules and the legislative guidelines as to whether it's possible to have a second public hearing and exactly where we're headed. So I need to do some research before I can answer those questions. But I'll be sure to obviously consult with the bill sponsor who's worked so hard on this legislation, and with co-chair Harnett and with our nonpartisan OPLA staff, because it's an important proposal, and the process questions are also important to the fairness of the legislative process. We have to make sure that we're fair to proponents and opponents alike in the public hearings and work sessions.
Thank you, Madam Chair.
You're welcome. Thanks for the questions. I don't know whose hand was up next. Representative Babbage, go ahead.
Yes, thank you, Madam Chair. I'm fine with the chair's flexibility and wanting some time to deliberate the question that Representative Newell just brought forward. I will say, in my experience, if requested by any member of the committee, a person would be invited to attend the work session, and then only with the recognition of the chair and at the request of a member of the committee would that person be brought forward to answer any questions by the people. I think the propriety comes with not allowing free testimony, but bringing them forward to answer a specific question.
Thank you for your thoughts, Representative Babbage. Appreciate that. Representative Harnett?
Thank you very much, Madam Chair. And I may be simply repeating or restating what Representative Babbage said. My concern, we always have the right to ask questions. And I did take a quick look at the committee rules and the joint rules. The concern was the provision of extensive testimony as opposed to experts being brought in to answer specific questions from committee members. I think there's a difference between those two types of interactions. And as your co-chair, I'd like, for us to think that through and talk about that. But I certainly support your immediate decision today.
Thank you. And so we had a motion to table by Representative Poirier, I believe, and a second by Representative Moriarty, but we haven't voted on that. And so I just want to give anyone a chance to thank Representative O'Neill. And again, I'll express thanks to you as well. And
thank you to the committee. Really appreciate your questions.
thanks. And now we'll move on to a vote on the motion to table.
Ready?
Yes, thank you
I
very
see
much,
two
Ms.
hands
Burnett.
up, but they may be residual.
Representatives Babbage and Harnett, residual.
Mine's
Thank
down.
you.
Representative Galgay Reckett.
Yes.
Representative Galgay Reckett votes yes. Representative Newell.
Yes.
Representative Newell votes yes. Representative Evangelos. Representative Poirier.
Yes.
Representative Poirier votes yes. Senator Keim. Senator Sanborn. Senator Carney.
Yes.
Senator Carney votes yes. Representative Harnett.
Yes.
Representative Harnett votes yes. Representative Babbage.
Yes.
Representative Babbage votes yes. Representative Thorne. Representative Sheehan.
Yes.
Representative Sheehan votes yes. Representative Moriarty.
Yes.
Representative Moriarty votes yes. Representative Hagan. Representative Libby. I'll recall the absentees. Representative Evangelos. Representative Evangelos is absent. Senator Keim. Senator Keim is absent. Senator Sanborn. Senator Sanborn is absent. Representative Thorne. Representative Thorne is absent. Representative Hagan. Representative Hagan is absent. Representative Libby. Representative Libby is absent. Madam Chair, I have 8 members voting in the affirmative, 0 in the negative, and 6 members are absent. That is the vote of the committee.
Thank you. And so the motion to table carries 8-0 with 6 absences. And committee members, we just have a few announcements before we adjourn for the day. Peggy, did you have any announcements for us? No? Soupy, did you have any announcements?
Just look for my emails. They're coming tonight.
All right, thank you. And committee members, thank you for all your hard work today. We will see you on Tuesday morning.
Yes.
Thank you, everyone. Good night.
Okay. Good night, all.
Night.
Stay
Thank you all.
warm.
Good night. Keep that kitty warm.
Trying to end my video. Yeah, I know.
I'll end
right?
it for you.